or the defendant and another person by words or acts agree together to commit, and in this case, the charge is first-degree murder. The court finds that there's substantial evidence before the jury, with all inferences and viewed in the light most favorable to the state, that they conspired to and agreed to commit the offense of first-degree murder. Two, the other person, count number three, the second element is actually an exclusion. The other person was not a state or federal agent acting in the agent's official capacity at the time. That is not relevant to this case. There's never been testimony or any argument that either Ms. McCulley or Mr. Apodaca were state or federal agents. The second element would be the conspiracy alleged in this count must be separate, distinct, and not constitute a part of count number one. The court finds that it is, that there is substantial evidence before the jury upon which they could reasonably conclude that there was the communications and the intent that occurred prior to Ms. Jennings being present on the 28th and the 29th, and then the conversation as testified to, and the search made by Mr. Apodaca about possible disposal of the body or how to dispose of the body. And then the third element, that the defendant and the other person intended to commit the offense of first-degree murder. The court finds that there is, again, substantial evidence before the jury based upon the evidence, the text messages, the statements by Mr. Apodaca during his interview with law enforcement, and the other circumstantial evidence and expert testimony testified to that both the defendant and Ms. McCulley intended to commit the offense of first-degree murder. And then the final count, the final element of count number two is that this happened in the state of New Mexico on or about the 28th and 29th day of October 2022. And the court finds that there is substantial evidence before the jury upon which they could reach that conclusion. The motions for directed verdict are denied, and the case will go forward with both count number one and count number two. Is there a need for clarification of the court's findings, conclusions, or ruling? Mr. Long?
No, Your Honor. Thank you.
Counsel?
Not for defense, Your Honor.
Okay. We've got about 15 minutes, so we're not going to get a lot done. I have a pack, unless they've been changed in between the computer problems today. My administrative assistant did print out the instructions, so I took a cursory review when I walked back at them, but I haven't read them or spell checked them or anything like that. Let's do this. Counsel, I saw Mr. Long hand you a copy. Would ask that the parties meet and confer and go through and see if there are instructions that there need to be technical corrections made to. Would also expect, and I didn't see, okay. Would need an instruction available, and again, you don't have to make the decision until tomorrow. It looks like it is there, instruction number 12, 5031, but you don't have to make a decision until tomorrow when we call the jury back in as to whether or not Mr. Apodaca is going to testify. But we need an instruction in the event that he exercises his right to remain silent and rely on his presumption of innocence. I was also told that the defense might be offering other lesser included offenses as to count number one. Is that correct?
Yeah, Judge, we're considering a voluntary manslaughter instruction.
Okay, so I'll need a clean and dirty version of that instruction. Any other anticipated instructions that you wish to offer?
No, Your Honor.
Okay. Again, you have the evening to think it over, and if there's any changes, just make sure you communicate that before we start tomorrow with the state and send forms of those orders, of those instructions to the state before we start discussing them here in the courtroom. I think we'll stop for the day. We'll be here. I'll be here at 8 o'clock tomorrow morning. I'll hear arguments on the alternative forms of instruction. Before we call the jury in, I'll have you rest in front of the jury. Probably take a short recess after that, and then we'll go into instructions and closings whenever I'll inquire. Well, I don't know at this moment. If there is testimony put on by the defense, then I'll ask if there's any rebuttal testimony from the state. And then once we finish with the proofs in total, then we'll take a recess before we finalize anything else we need to do on instructions, and then we call them back in to instruct and close. The other thing to think about and work on is if you intend to use any of the equipment as part of your closing, if you're going to use a PowerPoint or just use exhibits that have been introduced, you need to make sure you bring your laptop, whatever you're going to use, and have it here and ready to go. And actually, I'll give you a few minutes to play with the system to make sure that everything interfaces and we don't have any problems. We've had less problems over time, but when we first started, there was interface problems between certain devices and the court system. So I want to make sure you do that before we get started. Are there any other issues for the evening from the state?
No, Your Honor, we discussed, this isn't an issue, I'll just say that we'll work on it though. We discussed maybe creating some sort of evidence or exhibit log. I'll ask, Brian reads minds and already seems to have one done, so I'll work with defense on making sure that that's something that, you know.
And again, it's not necessary, it's more of an aid to the jury, it's not a piece of evidence, but the objections I've gotten in the past, if there's a description that you think somehow colors what the evidence is, other than just simply stating, you know, photographs from the garage or something simply, you know, that doesn't say anything. And if there's an objection to providing to this jury, I'll hear that tomorrow morning as well after you have a chance to look at it and look through the detail.
Sure, we'll work on this, Judge, thank you.
Any other issues for the state?
No, Your Honor, thank you.
For the defense, do you need time with your client this afternoon before we recess?
I'll have another meeting with him, Judge, and I usually just show a few jury instructions on the Alamo.
Okay.
My closing, so I don't plan on using PowerPoint.
There's a number of photographs that are still on discs. So if you're going to reference those and you're going to do it off of your hard drive, they need to match.
Yeah.
Okay. And so you'll need to make sure if you have that loaded into your hard drive, if you're going to use any of those photos or whatever they are, that they match whatever's actually in the exhibits that have been admitted.
Or what I can do is just sort through the exhibits before my closing, and I'll just have it ready to put on the Alamo.
Sure. And if you need help, Angel will be here to help you with the system.
Okay. Thank you very much, Judge.
Okay. We'll be in recess and off the record. Please be here at 8 o'clock tomorrow morning. The jury's not going to be here until 9, so we'll get started and go through jury instructions, at least our first take, and then after the proofs are done, we'll go back to them real quickly to see if there's any changes or modifications we need to make. We're off the record. Thank you all. Have a good evening.
Thank you, Judge.
Thanks, Judge.
this is what's proffered to the court prior to trial. If this is what comes in at trial, this is the court's preliminary ruling, unless something changes. What we're asking for is a violence, any reputation evidence, any battered spouse syndrome, unless and until there is testimony that is self-defense that's recognized under the state of Florida's laws. So what we are asking for is a ruling that if, and this is a motion in limine, and a motion in limine is, hey, this is what's proffered to the court prior to trial. If this is what comes in at trial, this is the court's preliminary ruling, unless something changes. What we are asking for is a preliminary ruling that if that is what her testimony is, then we should not be allowing introduction of past instances of violence, reputation for violence.
Go ahead, sir.
For battered spouse syndrome evidence. And furthermore, what the case law supports is our request that clearly this evidence can only come from her. There was nobody else in the apartment or townhouse that night. So she should have to testify before any of those things come in, and her testimony should meet the requirements of an overt act before any of this testimony comes in. It should not be allowed to come in prior to her testimony. And under the case law that the state cited, it's not unfair. It's not forcing her to testify. She chose to raise battered spouse syndrome. The state completely understands we have the burden of disproving self-defense beyond a reasonable doubt. But what the case law says is we shouldn't have to combat this. We can't put the toothpaste back in the tube until she actually puts forth the self-defense that justifies all this. So that is our request. We're not making any requests about voir dire because we understand she can come in and testify differently yet again at trial. And that's a discussion we'll have to have as well about how that will occur. The state's position is that if she changes her testimony yet again, she should have to give a narrative testimony. No attorney should be allowed to participate in putting forth new testimony about the events of February 23rd. Thank you.
All right, thank you very much. Response.
Good morning, Judge.
Morning, sir.
I'm a little confused, but I want to make sure, so probably can save some time here. My understanding is what the state's saying at this time, that there's no objection to raising this in voir dire to see how the jury would react or their feelings about it. So that's not it. So what that leaves me is, I guess the state's trying to say there should be no mention of battered spouse or anything like that in opening statement.
That wasn't my takeaway either. My takeaway from the motion and the state's argument today is from a evidence perspective, concepts or testimony or even opinion evidence about battered spouse syndrome cannot be raised, including any of the reputation or specific instances of conduct that are contemplated by self-defense until there's a factual basis for it. My understanding of the defense's Dr. Harper's deposition is that the basis of her opinion, and please correct me if I am wrong, but my understanding is that the basis of Dr. Harper's deposition is based on her 4 or 5 interviews or sessions with Ms. Boone as to what transpired on the day and night in question. Is that accurate?
I need to confer.
Sure.
Judge, if I could have you repeat that question.
Sure. So my understanding, well, let me ask, I'll ask a more of an open-ended question. What is the basis, factually, of Dr. Harper's opinion. So if we were at trial right now, for the purposes of this exercise, and you were going to call Dr. Harper to testify, what is the factual basis component under 90.702 in order to get her to testify? We're not dealing with her CV, her credentials. I'm not sure the state's going to have any position with regard to those, but let's just assume the state has no objection with regard to her credentials and that she is in fact an expert based on her knowledge, training, and experience in her field. What is step one under 90.702 to allow her to testify? What is the sufficient factual basis of her opinion?
Judge, I think her opinion would be based on several different things. Mainly, one of the things that her opinion would be based on is her interaction over the course of time with our client, Ms. Boone. That's one. But Dr. Harper has also reviewed other evidence in this case that helps her form the basis of her opinion, and also her knowledge of battered spouse syndrome. That has to be taken into account because, quite frankly, Judge, people who suffer from certain things, they don't know. That's why you have to, like if you have to get an expert opinion as to someone's mental health situation. I mean, a person doesn't really know that they're suffering from a mental health problem. They have no idea in a lot of circumstances. What they do is they get evaluated by a doctor. The doctor has experience of what signs to look for in these things, and getting those signs with what they told in outside sources too. They are able to make a determination based on their training and experience. So,
but based on the Akendo case, which is cited by the state as to what what battered spouse is it's an ambit of self-defense. So under the statute, are you traveling under 776.012 as your basis for self-defense?
yes, but this is the problem that I'm having here. Self-defense is a defense, it's an affirmative defense that's available to anybody. It's based on the evidence at trial.
But what's the overt act? Because in reviewing Dr. Harper's deposition, there were specific questions by the state inquired of her about the language, specifically in those statutes, about the imminence of fear. And she was unable to answer those questions. So my question really is, what's the overt act by the victim which would have given rise to self-defense? Because the case law, taking aside the state's case law under the stand your ground concepts, which I find distinguishable, because under 776.032, there's a specific statutory scheme for pretrial stand your ground motions. So I find those cases distinguishable for that very reason. But there's specific case law, bless you, there's specific case law that talks about in the self-defense realm that the state has cited to in their motion that an overt act is needed. What is the overt act?
Judge, the overt act has to come from testimony, and I agree in this case, but that has to be the testimony of Sarah Boone for that overt act. And that testimony can only take place at trial. In making a determination of whether to give the self-defense instruction, it has to be based on the evidence presented at trial.
I agree with you on that. I completely agree with you on that. And the case law is clear that if even there's a scintilla of evidence, I have to give that instruction. But we're not dealing with the jury instruction right now. What I'm dealing with right now is pretrial. The state saying you cannot proceed on battered spouse. There's two avenues in this motion. Avenue one is you cannot proceed with battered spouse because of the factual reasons based on Dr. Harper's deposition as to what she's going to be the basis of her opinion. Battered spouse cannot be entered. Alternatively, you cannot talk about it until there's foundation. That's my takeaway from the state's argument, that before battered spouse is argued or provided or opinion, there has to be that foundation to it. And the linchpin for me is the overt act issue. that how can we have anybody testify to opinions or any of the reputation or specific instances of conduct that we permitted until that overt act is established? What's your response to that?
My response to that, if I'm understanding you correctly.
If you need to reframe the question, please.
Because it's procedurally. There's no way that we could come in here and put Dr. Harper on the stand before Sarah Boone. It just doesn't work. Because to even establish the relevancy of Dr. Harper's testimony, Sarah Boone, who's the only witness there at the time, I agree with that with the state, has to present evidence of self-defense, has to present the evidence of the court talking about that overt act. It's not based on what the doctor perceives or what the doctor was told by Ms. Boone or what questions were asked at that deposition. I don't know. Mr. Owens took the deposition. The questions, though, at the depositions are limited and the doctor answers. But that's not what this has to be based on. What it has to be based on is what does Ms. Boone, in this case, testifies to on the stand. And if any of that, excuse me, if any of that presents a scintilla of evidence to award the self-defense instruction, then the self-defense instruction should be given. That's the first step. Everything follows after that, Judge, because this isn't a situation where I think it's appropriate to make a pretrial ruling, because the ruling has to be based on the evidence that comes from that witness stand. Now, any of the evidence is subject to cross-examination, impeachment, anything like that. But that's a wait for the jury to determine. But as to the admissibility of the evidence, it has to start with Sarah Boone. A judgment can't be made or a decision cannot be made until the testimony of Sarah Boone takes place at trial. This is just procedurally incorrect.
Any other arguments, sir?
No other argument.
Thank you. Rebuttal?
This is procedurally correct. Parties are allowed to get motions in limine based on the proffers of evidence that have been made prior to trial. Apparently, opposing counsel has not read the depositions, or he clearly didn't attend them because he was not there. But the court has before it the statements that Sarah Boone made when directly asked, what happened that day? What happened next? And there was no overt act taken by the decedent on that particular day. What they want to do, and what is not permissible under the case law that I've cited, in particular the one that says you get a threatening text and then 2 days later you can't go slit somebody's throat because of the threatening text 2 days earlier. Not to dehumanize Mr. Torres at all, but to give you this analogy. If somebody owns a bad dog, and that bad dog bites, and that bad dog is bitten in the past, but on this particular day, the dog is just doing arts and crafts and puzzles and hanging out, drinking some Woodbridge Chardonnay, and you put the dog in the suitcase, and then the dog barks because it's in the suitcase and doesn't want to be in the suitcase when it's zipped up. That triggers you to, I remember when the dog bit me in the past. You can't, that's not how this works. That's not how self-defense works with or without battered spouse syndrome. There has to be an overt act. You can't bootstrap and make up a fictitious act of violence on that day based on the past violence. That's not what the case law allows. And the state is asking, unless they are saying that the testimony will be different at trial, we are asking for the court to prevent them from saying anything about this during opening statements, because they will know, based on the court's ruling, what your client has already said to Drs. Werner and Harper does not admit self-defense evidence into this case. So that's what we're looking for, is that ruling. If this is what the testimony is at trial, then self-defense is not going to apply, and all the ancillary prejudicial things that come with it, reputation evidence, past instances of violence, battered spouse evidence, is not coming in either. Now, if they make some statements and promises that they cannot fulfill in opening statements, then that'll be on them. King versus State will allow us to point those things out to the jury, and it will not be burden shifting. But that's what we're asking is, this is a proffer, just like any other proffer testimony, like a sex crimes case, where we file a deposition of a Williams Rule victim and ask the court to rule prior to trial, hey, if this is how the Williams Rule victim testifies, and it's clear and convincing and it meets all the standards under 404 and 403, can this prior act of sexual violence come in during the trial? This is what parties do all the time, is get pretrial rulings on crucial matters like this. This is a crucial matter because the tip of the iceberg is the second-degree murder. The rest of the iceberg, the 99% of what has been going on for the last month and a half, is the self-defense that just isn't there. It wasn't there under her former statements to the police, and it's not there under her current statements. So we're asking for a ruling, a motion in limine, which is subject to change based on the evidence at trial. But if this is what the evidence is at trial, the court should not allow any of the battered spouse, any of the prior violence, any reputation evidence in. That's all we're asking for.
Okay.
Thank you.
All right. Thank you.
Judge, could I respond?
Briefly.
Judge, it is not the responsibility of the defense to present their case at a pretrial hearing. However,
But the problem is, in the state's argument, in the case law, which the case law has been presented by the defense in your filings, are not germane to the issue. We're not addressing jury selection and the standard of proof and the burden with regard to self-defense, you establishing a prima facie case, and then the higher standard that the state has to overcome it. There's no dispute as to that. The issue is the necessary predicate to establish battered spouse. And the state's argument is that due to the lack of an overt act, based on what Dr. Harper has relied upon, to wit, the multiple interviews or sessions with Ms. Boone, that element seemingly is lacking. We all know what elements are, right? If it's a negligence case, it's duty breach causation. In this case, it's the elements based on the jury instructions are George Torres is dead, she caused the death, and it was done so in a depraved heart manner. I may have butchered that last element, but those are the elements that need to be established based on the jury instructions. Similarly with self-defense, the case law talks about the overt act.
yes, sir.
And then the flashpoint of the defense's argument is that the facts which were provided to the expert, who in turn will testify to battered spouse, that flashpoint, that overt act is lacking.
It's not, Judge, but I find myself in the position now to disclose what our view of the overt act is.
Okay.
That's what this is what this motion has put us into. So it's an exercise of the state to learn our theory or our view of the evidence, because the overt act is in the physical evidence. And the overt act is mentioned to Dr. Harper in the deposition as to the reaction of Ms. Boone by the overt act. And the overt act, I have to tell you, his hand is coming out of the suitcase. That means he's about to get out of the suitcase. Now, based on history and everything else, she doesn't have to wait to see what's going to happen when he gets out of the suitcase. It's clear what's going to happen when he gets out of the suitcase. It's followed up by physical evidence, because there's a picture provided of Mr. Torres' hand that shows a mark on that hand that it matches up with the bat. That's the overt act. It's like a gun, okay? You don't have to wait for them to pull the trigger. You don't. And it's based on all the evidence in the case, just not testimony, but also physical evidence that might support the testimony.
Thank you, sir. All right, the court has had the opportunity to review the motions, review all the case law. The state's motion is going to be granted in part and denied in part. With regard to the state's request to exclude battered spouse syndrome evidence outright, the motion is denied. As to specifically Wagner, for the reasons identified in the court's prior rulings as to the concept of argument, again, there's no outright evidence of accident, not argument, excuse me. As to the state's reliance on Lantz, L-A-N-T-Z v. State, 263 Southern 3rd, 279, no argument of self-defense was ever offered in that case. I find the cases of Reed v. State, 213 Southern 3rd, 1110, Rudin, R-U-D-I-N v. State, 182 Southern 3rd, 724, State v. Woodson, 349 Southern 3rd, 510, and Morris, 325 Southern 3rd, 1009, distinguishable as all of those cases were traveling under 776.032 for stand your ground hearings. It's undisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court, 916 Southern 2nd, 750. I find the departure from the essential requirements of law argument by the state factually and legally distinguishable, as there was a specific statute for the state obtaining medical records as relied upon in Roberts v. State by the 6th ECA in May of 2023 WL 3262633 at pinpoint site 2. So for those reasons, the state outright motion to preclude or exclude battered spouse syndrome evidence in toto is denied. With regard to the second portion, that excluding mention of battered spouse syndrome evidence until there's a basis for it, the court's going to rely on Ladd and Medina, specifically that there needs to be testimony provided for the expert to testify to the battered spouse syndrome, and there needs to be sufficient predicate established for that self-defense. So I'm going to preclude any mention or testimony in the form of expert testimony as to battered spouse until that necessary predicate as identified in Ladd 564 Southern 2nd 587 has been established. Any questions with regard to the state's ruling? I'm sorry, the court's ruling, forgive me. Defense.
Meaning?
You want to mention an opening? You can mention an opening. Certainly I'm going to allow you, and the state at this point has no problem with the concept of battered spouse being addressed in voir dire, and even if the state objected to it, I most likely would overrule it based on the litany of case law that you cited, that you're allowed to dive into those things during jury selection. As to should the defense put on a case, the predicate under Ladd needs to be established before any expert opines to battered spouse.
My concern is open. Can it be mentioned in the...
Yes, that's your decision. That is your decision if you want to mention an opening. There's no preclusion from you doing that. Okay. Any other questions with regard to the court's order on that matter? State.
No, Your Honor.
Defense.
No, Your Honor.
Okay, thank you. Moving now to the defendant's motion in limine filed October 6 and the state's response to same. It looks like we've reached some level of common ground with regard to that motion. The court is going to grant the motion with regard to the statements on page 69 through 71 of the transcript of the February 25, 2020 interview between Detectives Lowen and Kopsel and Miss Boone from page 69, line 6 through page 71. That will be granted to the state not objecting to same. That leaves us to the statements on page 53, line 11, 53, line 13, line 14, page 55, line 24, page 56, line 1, and page 92, line 15. With that, defense, you may proceed with any argument. Similar to the last motions, I have reviewed all of y'all's case law.
I believe there's some state witnesses here. We would like to invoke the rule.
Okay.
The rule of sequestration applies to testimony of other witnesses, not to anything else.
Response?
Is there going to be testimony?
Not from the state.
You've got state witnesses here, do you know?
She's allowed to be here.
here to watch. I understand, but I want to know whether she's going to testify.
I said there's no state witnesses.
So that's a no. May proceed with any argument, Mr. Owens. Yes, sir. I have reviewed the 2.8 instruction prior to today. Thank you, Counselor.
Judge, the problem is the state attorney, when they filed the response, they didn't include the highlighted portion that's italicized at the beginning. Police opinions and statements regarding guilt are generally inadmissible and must be redacted from recordings introduced into evidence unless redaction would render the defendant's relevant admissions incomprehensible. If a recorded interview cannot be appropriately redacted, the trial judge must, upon request, give the following limiting instruction immediately before the recorded interview is played for the jury. That section, which is comments directed to the court, was not placed, to my understanding, in their response.
Okay. Any other argument?
Judge, this was a 2-hour interrogation that occurred the day or two after the event. And the day prior to this time, or that morning, the detectives uncovered the 2 videotapes, the 2-minute video that Sarah Boone had recorded, and then followed up 11 minutes later with a 22-second video that she had recorded and they found on her phone, which I believe from the interrogation discloses that Sarah did not remember making those recordings. But the purpose of law enforcement's position about having her come in was to interrogate her in an attempt to get a confession from her to the murder. They spent 2 hours trying to do that, any which way they possibly could. And the law says that they're allowed to use, and I cited several cases, I cited the Smith v. State case, the Odeh, O-D-E-H v. State case, and the Eugene v. State. And in those cases,
I didn't see a citation to Eugene. I mean, Eugene's included in Odeh, but I don't.
Eugene is found. Do you need the cite?
I have it. It's included in Odeh, but you did not cite it in your motion.
Okay. Eugene is 53 Southern 3rd, 1104. But law enforcement are entitled to use a variety of interrogation techniques to try to elicit a confession to the crime. But as in that case, in spite of the detective's efforts, Sarah Boone refused to admit that she was guilty of the murder. But as a last resort, Judge, and it was a 2-hour interrogation, it was the last portion, at least the last quarter, it may have been less than that, is when the detectives made some statements that are highly prejudicial to the defendant and tend to be opinion and tend to invade the province of the jury. And that's why this special jury instruction 2.8, recorded interview, effective law enforcement statements on the defendant, has that italicized portion in there. And the statements we're referring to under my motion, the second section of evidence to be excluded, page 53, line 11, well, he's dead as a result of your actions. And then paragraph 9, line 13, he's dead as a result of your actions. She responded, line 14, I understand that. And then paragraph 11, page 55, line 24, I have one last question. I mean, you realize you're the person that killed him, right? Sarah Boone responds on page 56, I thought about that. And then lastly on page 92, well, intention or not, here's the detective distinguishing how he interprets the law and her culpability. Well, intention or not, George is dead, and you act like when you say unintentionally, that absolves you from everything. That is exactly the kind of opinion testimony from law enforcement that the courts are worried about. The probative value of that type of opinion testimony about her guilt is outweighed by the prejudicial effect. Thank you.
Response.
The state stands by the case law that we cited and that the jury instruction that would be read. I didn't feel it necessary to include italicized portions of comments to the court because this is what would get read to the jury. Those statements are designed to get responses from her. They did get responses from her.
Let me ask this question first, Mr. Jay. Do you disagree with counsel's representation of what is reflected in the Q&A at that point in time?
To the extent that he is making the argument that they're expressing an opinion about the
No, the words, not his opinion, not his thoughts or what it means, but the black and white verbiage is reflected in the motion. Is that what's reflected in the recording?
I'm accepting that he would not misrepresent that to the court.
Okay, thank you. You may continue.
And as far as the last line on page 92, line 15, if something's designed to get a response that a normal person would respond to and there's no response, that still makes it a relevant statement. He's not giving an opinion on the law. He's giving an opinion about her reactions to this interview and trying to get a reaction from her when he says, well, intention or not, Jorge is dead. You act like when you say unintentionally, that absolves you from everything. He's not stating that that is a legal defense. He's just commenting on what has transpired in the 92 pages of the interview. So we defer to whatever the court's ruling is.
Okay, thank you. Any rebuttal?
Just for the state attorney not to put that in there, the italicized portion, where the Supreme Court is giving instructions to the court with those comments, for them not to put that in there, I disagree with it.
Okay, well, the Jackson case speaks for itself, and the court has reviewed it.
Thank you.
All right, thank you both for your motion, your motions, your responses, and the case law. The court is going to grant the defense's motion. I disagree with the defense, or with the state rather, as identified in their response, that the only issue is battered spouse. The issue is one of the elements is cause, and those three statements go specifically, I believe, to opinions as to the cause of Mr. Torres's death. So the court is going to grant the state's motion, as under the Bush case cited by the state, law enforcement's opinions are inadmissible due to the prejudicial effect that they may have. And I do find that this is the expression of law enforcement's opinions as to the guilt of the accused. As such, the motion is granted, and those will need to be redacted from. I apologize. Thank you. The defense's motion is granted for those reasons. Any questions or clarifications with regard to the court's ruling? State. Questions or clarifications with regards to the court's ruling? Questions or clarifications with regard to the state's ruling? Or the court's ruling, excuse me. All right, that takes us now to the state's objection and motion in limine to exclude decedent's medical records. I've reviewed that as well. State, you may proceed.
Just the other night, I received 550 pages of medical records regarding the treatment of Mr. Torres from two incidents, one in 2017 and one in 2018. A third email that I received from Mr. Owens purported he believed that they had attachments. They did not. I replied to him as such, and I have not gotten any additional emails with attachments regarding the medical records. So for the purposes of this hearing, all I'm arguing about is the 550 pages that I have been provided. One of those instances involved a narrative being given by the patient, Mr. Torres, that he had put his hand through a plate glass window.
This is the 2018 incident, correct?
Yes.
Yes.
And his wife, the following day, made him go in and get treatment. There was a 4.5 centimeter laceration that required 2 sutures. There is no history in the narrative about any violence that the decedent had committed. So I anticipate that Ms. Boone, when she testifies, will give us an explanation about how this was an instance of past violence that she was aware of by the decedent. So making that assumption, then what the state is asking for is the 57 pages seems excessive. This jury is going to have a lot of information to weigh and consider. Not every page of these 57 pages is relevant. What is relevant is, yes, he came in for treatment, that narrative, and the history that he gave of putting his hand through a plate glass window and that he got sutures, that corroborates her testimony. I understand why she will need corroboration for her testimony to bolster her credibility. So if she testifies that way, we get it, but it's just excessive and it's going to be confusing. They don't need to read 57 pages of all of his treatment. The second batch was 487 pages regarding an incident on Christmas of 2017 when what the decedent reports in the narrative to the hospital is that some unknown men jumped him and beat him up. Being a victim of violence is not relevant in this case. I expect there will be a story based upon the testimony that we've taken from the experts that this all happened at a family gathering and one of the decedent's brothers learned from Sarah Boone that Sarah Boone said that the decedent, had committed violence against her and then beat him up. That's not the same ilk as corroborating violence with breaking windows or whatever it is that caused his laceration, whatever she ends up testifying to about the 2018 incident. But this incident, it's irrelevant that he got beat up by his brother. It's irrelevant that he suffered the amount and severity of injuries that he did. That is not required to corroborate her testimony that, I don't even know if it comes in, that she makes an out-of-court statement to the decedent's brother that something is true that happened in the past. That seems like classic hearsay. I'm not sure how she would get that in. I don't know that the 487 pages is needed to corroborate that. And if the court, like I stated in my response, if the court believes that it is necessary to corroborate her story that he did get beat up by his brother, then again, there are narrative parts of these medical records. Generally, I would say in this particular instance, it was a handful of pages that give the narrative as to what happened. And I don't know that it's relevant what the treatment was that he received, but there's narratives of that as well. They don't need to be bogged down with 487 pages of toxicology reports, nursing rounds, just all the things that I'm sure the court is familiar with from your past experience that are in these medical records. It's unnecessary and it's prejudicial. Its probative value is substantially outweighed by its prejudice, confusing, repetitiveness, as I outlined in my response. So that's our position.
Thank you, sir. Response.
Judge, as you know, we got on this case about 45 days ago, and I can't tell you how many pages of discovery there is that we've had to go through. And 2 or 3 weeks ago, the state attorney provided us over 500 pages from either telephone calls that my client was involved in from the jail or tablet communications, which are kind of like emails or text messages. And that hasn't been narrowed down, but that was given to us. So that's something else we had to stop and go through over 500 pages. And they haven't narrowed that down to which ones they believe are incriminating to her.
Understood. But respectfully, that's not the issue before the court right now.
That. But yes, the medical records are going to be narrowed down. And yes, we would have to make some tie to Sarah Boone's testimony to whether or not their medical records of the decedent, George Torres, are admissible to corroborate her stories about the incidences of violence and whether they match up. But yes, I agree there's going to be a narrowing down, but it's kind of premature about that. They've got several volumes. I assume before they introduce something, they're going to have to narrow it down. did y'all not have George Torres's medical records prior to me sending them to you? All right, well, we took the deposition of Dr. Harper, and as you know, Judge, these forensic psychologists, when they're trying to make an opinion as to battered spouse or whatever the case may be, they rely on their assessment involving the personal contact and interviews they have with the client, but a lot of it is any other collateral evidence that tends to support it. That involves arrest reports, that involves court records, that involves psychological notes, that involves medical records. And at that time, when the state took Dr. Harper, our witness's deposition, she said, yes, I did rely on George Torres's medical records. So they were well aware.
That doesn't mean they come into evidence.
I know that. I didn't say that. But they were well aware that that's one thing that she relied upon. A lot of that collateral evidence doesn't come into, and it's going to be...
I need to jump into the breach here. I understand all of that. I understand that there's been volumes of documents that have been provided between both parties. And I understand, based on my review of the highlighted portions that the state pointed out in their motion, as to what Dr. Harper relied upon. None of that is germane to the state's argument. And you've admitted that there needs to be a narrowing down. So let's just kind of compartmentalize what we've got here.
So it's premature. It's premature. I agree it needs to be narrowed down. And then based on Sarah Boone's testimony...
You are the proponent of the evidence.
Yes.
So you have to establish relevance.
I agree.
And you have to establish that it is not so substantially unfairly prejudicial.
Yes.
That the prejudice does not outweigh its probative value.
All right, the court will call 24 CF 1048, State of Wisconsin versus Taylor Shabusiness. Appearances.
Gordon Leach for the state.
Taylor Shabusiness is personally present. She is in custody with Attorney Curtis Jelka.
All right, this matter is set for a preliminary hearing today. Mr. Jelka, what's the status?
Your Honor, my understanding is we are proceeding.
All right. Mr. Leach?
Your Honor, I'm just checking in on the status of my officer. I expected her to be here, but I'm also having connectivity problems here. I might need to run upstairs and see if she may be upstairs. If I can have her.
Sure.
And Judge, it sounds like just one witness. We're asking for a sequestration, but that may be a moot point.
All right.
It is one witness, Your Honor.
All right. We're off the record.
For the state.
Taylor Shabusiness is personally present. She is in custody with Attorney Curtis Jelka.
All right, this matter is set for a preliminary hearing today. Mr. Jelka, what's the status?
Your Honor, my understanding is we are proceeding.
All right. Mr. Leach?
Your Honor, I'm just checking in on the status of my officer. I expected her to be here, but I'm also having connectivity problems here. I might need to run upstairs and see if she may be upstairs. If I can have anyone.
Sure.
And Judge, it sounds like just one witness. We're asking for a sequestration, but that may be a moot point.
All right.
It is one witness, Your Honor.
All right. We're off the record. This is Taylor Business appearances.
Gordon Leach for the state.
Taylor's business is personally present. She is in custody with attorney Curtis Shelka.
All right, this matter is set for a preliminary hearing today. Mr. Jellicoe, what's the status?
Your Honor, my understanding is we are proceeding.
All right. Mr. Leach.
Your Honor, I'm just checking in on the status of my officer. I expected her to be here, so. But I'm also having connectivity problems here. I might need to run upstairs and see if she may be upstairs. If I can add one.
Sure.
And Judge, it sounds like just one witness. We're asking for sequestration, but that may be a moot point.
All right.
It is one witness, Your Honor.
All right. We're off the record. All right, the court will call 24 CF 1048 State of Wisconsin versus Taylor Business appearances.
Gordon Leach for the state.
Taylor Business is personally present. She is in custody with attorney Curtis Shelka.
All right, this matter is set for a preliminary hearing today. Mr. Jellicoe, what's the status?
Your Honor, my understanding is we are proceeding.
All right. Mr. Leach.
Your Honor, I'm just checking in on the status of my officer. I expected her to be here, so, but I'm also having connectivity problems here. I might need to run upstairs and see if she may be upstairs. If I can have one.
Sure.
Thank you.
And Judge, it sounds like just one witness. We're asking for sequestration, but that may be a moot point.
All right.
It is one witness, Your Honor.
All right. We're off the record. State of Wisconsin versus Taylor Business appearances.
Gordon Leach for the state.
Taylor Business is personally present. She is in custody with attorney Curtis Shelka.
All right, this matter is set for a preliminary hearing today. Mr. Jellicoe, what's the status?
Your Honor, my understanding is we are proceeding.
All right. Mr. Leach.
Your Honor, I'm just checking in on the status of my officer. I expected her to be here, so, but I'm also having connectivity problems here. I might need to run upstairs and see if she may be upstairs. If I can add one.
Sure.
And Judge, it sounds like just one witness. We're asking for sequestration.
is one witness, Your Honor.
We're off the record.
Taylor Shabusiness is personally present. She is in custody with Attorney Curtis Jelka.
All right, this matter is set for a preliminary hearing today. Mr. Jelka, what's the status?
Your Honor, my understanding is we are proceeding.
All right, Mr. Leach?
Your Honor, I'm just checking in on the status of my officer. I expected her to be here, so, but I'm also having connectivity problems here. I might need to run upstairs and see if she may be upstairs, if I can have her.
Sure.
Thank you.
And Judge, it sounds like just one witness. We're asking for a sequestration, but that may be a moot point.
All right.
It is one witness, Your Honor.
All right. We're off the record.
Including but not limited to the other identifications in 90.403.
Yes, sir.
So my question is, sir, with regard to the 2018 incident of the fist through the plate glass window, and I can't recall 40 some odd pages, I think the state identified as that. What of those 47 pages is germane to an incident of violence that may be needed to establish the self-defense concept of those 47 pages?
It will be relevant after she testifies about that incident.
All 47 pages?
Maybe not all 47 pages. I've agreed that some of it needs to be narrowed down.
Okay, well, what of it needs to be narrowed down, since
Well,
we have some level of common ground here?
My case is not going to be presented, I would assume, until next week, so I've got a little bit of time. I'll let the state know.
That's not how this works.
Okay. I can't let you know today, Judge. I'll narrow it down, or we'll talk in the next couple of days.
Well,
by
the state's
Friday.
position is that the narrative should be permitted as to the 2018 incident, the why Mr. Torres was there. But the nursing rounds, the charts, the follow-ups, treatment, anything in the future other than the 4.5 centimeter laceration that required 2 sutures. I understand the narrative as to what transpired. What else is relevant? And I haven't seen these 47 pages, so I'm not sure there. I'm relying on counsel's representation.
I don't know. I'd have to look at them, but in one of the medical records, George Torres was over a .31 BAC. Every time.
2018?
2018.
I'm talking about the 2018 incident with regard to the plate glass
I have to look at
window.
the records, but there is other evidence in those records that's going to be relevant after she testifies. That's when she gets beaten, when he gets really drunk, or that's when he does something violent.
Was that... Hey, hello. It's so nice to see you too. It's nice to be here. Oh, there's little hearts and stuff floating around. That's so cute. Hello, hi. Hi. Hello. 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 Oh, the ring. Can you see it at all in the dark? Ooh. Thank you. Oh, thank you so much. I missed being able to share my mind, you know? Like, I was freaked out. Yes, I didn't have a very good time. I was in a manic state because I suffer also from like bipolar disorder. And I understand about most of it, but oh, hello. I hope you're doing good too. Let me see if I can touch this gently. I don't have these things secure, so forgive me. I'm doing well. I hope everyone is well. Okay, a lot of nice comments. Thank you so much. I'm so happy to see everybody too. I hope everyone is doing well. Everyone be nice to each other because that's how we play. I don't like being mad or mean. Hey, crazy lady. I know. I own it though, right? Come on now. I wish I had different lighting in here too. I don't have anything else. Maybe. Next time I'll get some other stuff before bed and try to light it up a little bit or something. Oh yes, someone did ask me if I was still vegan. Unfortunately, I have not been vegan for a couple of years now. That's why I gained all the weight. And, thank you very much. I'm glad to see everybody, and I hope that everybody is doing well. I don't know if they are well, but, proud of me. Thank you. For what? I mean, I made it through a lot of stuff, and I appreciate all those little hearts. That's so nice to see. I love it. So nice to see everybody. Thank you. Hello. It's been a couple of years since I was on here, being able to talk to people and like I said before in the other video that I shared earlier today, no, they did actually, the jail did have some vegan options, interestingly enough. I had switched all the platters to vegan trays from the very beginning when I was incarcerated, like September, right, of 2022, correct? But then I ended up, and I'm sorry, we're getting ready for bed. I don't know why I'm like whispering a little bit, and I don't need to. My fiance's in there brushing his teeth. But yes, hello everybody. Hello. And my cat's in there playing with a toy, running around after a little pom-pom ball or something like that. Anyway, yeah, we got these neat little like, oh my goodness, she loves them. Excuse. She like this little pom-pom gun. Oh yeah, so dangerous. Pew, 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 pew. Anyway, but this little, it shoots out these little pom-poms. I just stored it in this little neat little bottle. But anyway, yes. Aw, thank you for saying I have beautiful nails, but I broke all of these ones off. Can you see? They broke. I've been breaking lately, and I'll discuss that in another video, but I'm so grateful to see so many. I do not live in Wisconsin. I still live in Arkansas. So, I'm just grateful that everything worked out, that I was caught up in Wisconsin when it happened, and that my family was around. My father and my mother were there to support me and to support me financially through it all and everything too. So I didn't have to buy any attorneys or lawyers. I just used the public defenders, and they were great people, wonderful people. I think it was Nicole and Matt is their first names, but they were wonderful people. I really admire the effort that they placed into getting me out safely and, you know, getting me acquitted of my charges. So the weather is crazy right now. There's sleet and ice everywhere. So I hope everyone else is safe wherever they are located. And I would love it if people would share their actual locations on my comment feeds. Like I saw one from Australia. That's amazing. I think that's wonderful. I can't believe I'm affecting or, you know, interacting with individuals from another country. I feel so privileged just in that, you know. I feel just so blessed for some of the things that I've lived through and encountered and that have toughened me up. I know that there are live feeds of some of the things that I had gone through, like my arrests that are still out there. I tried to delete all of my old videos where I was talking crazy and stuff. But yeah. Oh, Florida, Tennessee, Mississippi. Okay, let's see, Michigan, Ohio, Eastern Washington. So nice to see you. Oh, well, you'll be able to meet my fiance at some point. He's a wonderful man. He's so good, and he's so good to me. I wanted to share some of the roses that he's gotten me. I dry them and I put them in jars. And but he just does the sweetest things for me all the time. And we had been together for a little while, and he proposed just back actually December 26th of this last year, 2024. And we had started dating May 30th of 2024. He messaged me. We met on social media, like a dating app, and he just saw that I was in the area, and I was honest about my situation, like I always am, and said that I was like living with my mom and everything, and he offered to take me out. So he took me out to one of the better restaurants in town. And so he just was he's a great person. I love him so much. I'm so proud to just be with him too. And after a short time of dating, and we refrained from being intimate for 2 months as we dated at first. So that was so good. We took our time in getting to know one another, and I really love him very much. Like, I just can't. I'm just elated constantly because he just makes me so happy. I know earlier I might have been flustered trying to get all the information down, but it's just because of the fact that I'm a little stressed about having to deal with all the social media. I've had a little bit of a headache even dealing with all of the electronics. So, because I try to refrain from all of that too. And so sorry about like the angle of the room. It is what it is. Let's see what some of these comments are, because I'm so sorry. Here's some California, Utah. Hello.
For a preliminary hearing today, Mr. Jellicoe, what's the status?
Your Honor, my understanding is we are proceeding.
All right. Mr. Leach?
Your Honor, I'm just checking in on the status of my officer. I expected her to be here, but I'm also having connectivity problems here. I might need to run upstairs and see if she may be upstairs, if I can have her.
Sure.
And Judge, it sounds like just one witness. We're asking for a sequestration, but that may be a moot point.
All right.
It is one witness, Your Honor.
All right. We're off the record.
In on the status of my officer, I expected her to be here, but I'm also having connectivity problems here. I might need to run upstairs and see if she may be upstairs, if I can have her.
Sure.
And Judge, it sounds like just one witness. We're asking for a sequestration, but that may be a moot point.
All right.
It is one witness, Your Honor.
All right. All right. Mr. Leach?
Your Honor, I'm just checking in on the status of my officer. I expected her to be here, but I'm also having connectivity problems here. I might need to run upstairs and see if she may be upstairs. If I can have her.
Sure.
And Judge, it sounds like just one witness. We're asking for a sequestration, but that may be a moot point.
All right.
It is one witness, Your Honor.
All right.
Yeah. Yeah. Yeah.
Because you're jumping to conclusions because you don't know the full picture because you didn't know me from the get-go.
I've seen a lot of you on videos. I've seen the court records. I've seen the documents that were filed. I've seen them all, Leticia. I know exactly who you are. And when I watched that video of you in his kitchen from 2 days ago, I know exactly who you are. I'm way the hell older than you, girl. Been there, done that. I know who you are. And all I ask of you is to either get help if you think you need it. According to that video, to me, you do. If you don't need help, you need to quit doing social media and walk away. And you start a nice, clean life with my son. If you can't do that, me and you are going to have a problem.
Well, I'm sorry that...
He's the only one I care about right now.
Okay, so I'm sorry that you live in the shadows and you're not even able to tell your own daughter that you smoke medicinal marijuana or anything. I'm sorry, but that's the point here. You're disrespecting me. You called him, you woke him up out of his slumber while he was trying to get sleep for work. You woke him up to tell him to leave me, to tell him to get a prenup for me, and you want him to leave me. So, because of the videos that you've seen, I'm sorry for how you feel and what your perception is, but it isn't accurate. It is completely irrational, inaccurate. If you can't see me for the person that I am in front of you, and you presume that these records are factual.
You're the person that you present to me over here with that big smile from ear to ear, and then you're that person that I saw in that video.
Have I ever disrespected you to your face? Have I ever disrespected you to your face?
Mental record to prove it, so don't go there.
So you're saying because of my record, you cannot let your son be with me?
I can't stop my son from doing whatever he wants to do. He's well over 21.
Well, I'm sorry that you feel that way.
I'll tell you what, you're going to involve yourself in my family. I'm going to keep an eye on you. You bet I will.
You called and you attempted to record the phone call to try to incriminate me in some way. And that's why I film. That is exactly why I film. Because you don't...
My voice, I wanted to hear what I had to say.
So you're saying that I never disrespected you to your face. Yet you're saying that these records are out there, these videos are out there, and you're worried that I might hurt your son or hurt your ex-husband, his dad. And you're saying that because of your perception, you're not around all the time. I am trying to show people what I do every day through the videos. If you haven't watched all of them in their entirety, what am I to tell you?
You're not watching your own videos. You're an idiot, man. I'm telling you, you look stupid in those videos.
I'm sorry that you feel that way, but you have a very closed-minded perception. I thought that you were much more open-minded than that. I didn't realize that you were going to degrade me or misinterpret our friendship. I didn't realize that you were going to treat me like an animal, that you were going to treat me like some criminal, which I am not.
You don't come clean with everything. Yeah.
I don't? What did I not come clean with? I've told you about my prior children. You asked me, and I gave you the answers. And then you turned around.
About all these court cases and these
And I had specifically told you. So now you and your daughter, and now everyone you said knows, what's the problem? What am I doing? What have I done to Robert? Has he come crying to you? Has he told you I've broken his heart?
Well, we don't want you hurt now.
And she's not hurting me. She has not done anything to hurt me.
Why are you posting videos like that? Because she looks stupid in them. It's embarrassing to me.
She is absolutely insane. She really just doesn't hold back, and There's no logic to what she says. I could really see how her being nuts is true.
It's embarrassing to you. As an extension, then I'm sorry, then you're just going to have to detach from my life. I'm not going to leave Robert over your words. If it's Robert's choice to separate from me, then that's his choice. But you don't need to talk down to me, presuming that you are superior to me.
You only get the talk you deserve, hon.
I'm sorry, what? I have never disrespected you. I've always been nothing but kosher. Nothing but kind. Nothing but empathetic to you. This is the first time I've ever spoken up to you in an aggressive tone. Ever. How dare you call and wake him up out of his slumber when he has to work? Because you're selfish and you have your own thoughts and your own perception on our relationship. You don't know everything in its entirety. I don't know what to tell you. And honestly, since you've disrespected me so much, I understand we are no longer friends. We are no longer acquaintances. We are no longer family. You have made that. You have drawn that barrier. So expect to understand that in the future. You have drawn a line.
Oh, have them now. Now you're going to hide so nobody can see who you really are?
No, not at all. I'm filming right now. You wanted to record me, and I'm filming at this very moment. Live.
Oh, I'm so glad.
Well, you wanted to cause this war or battle. Do you?
If you post this on social media, I can sue you.
All right. Please do. Please attempt to. You're the one accosting someone with post-traumatic stress disorder. You're the one assaulting a disabled citizen right now, accosting me, berating me over things that you don't know, and inaccuracies, partial videos that were sent to you by outside sources to see how you would judge me, and you judged me poorly. You don't know me personally. I went to Catholic schools. I've discussed all of my life with Robert. I've told him entirely the entire truth. I have not lied to the man. I've not manipulated him. I've not coerced him. I've not lured him into a state of security to try to why would I need a prenup? If I end up making money over the things that I do, the career I end up getting, then why would
Was stealing other people's dogs and puppy milling them out.
is that what you presume I was doing? If that's the information that you received.
Proof of it on my computer.
Oh, is it proof, is it? Oh, obvious proof. Were you physically there? Did you witness it?
Listen to you.
Listen to you.
Me now?
I will pray for you, woman. I will pray for you. Please get some rest. You need rest. You sound delusional. Have a good night. Good night, woman.
Jesus Christ.
Our Father who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done, on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who've trespassed against us. And lead us not into temptation, but deliver us from evil. For thine kingdom, thine power, and thine glory are yours, now and forever. Amen. And thank you for drawing that out. I needed that to be exposed. Even the people that lied to my face tried to sit there and make it out to be like, oh yeah, we accept you fully. We talk about Jesus. We're Christian. They now judge me based upon the records they found online and the videos. I'm not going to get stressed over it. I'm going to leave this in God's hands. I'm going to leave this in God's hands. If she wants to sue me for this, I literally, finally videoed someone assaulting me. And it had to be my mother-in-law, of all people. I'm, please, I don't need extra stress. I was even up. I've only had 3 hours of sleep since the last night. And then I was up finishing the laundry because I had forgotten to put it in the dryer. And Robert had reminded me, oh, we forgot the laundry. So there I was. He was asleep. For an hour he had been asleep. And then she called for selfish reasons because she presumes that her son is in danger. Don't you think he would have reached out? He is a sensible man. Would you have reached out to your mother if I would have been endangering you, Robert?
Yes.
That's my point exactly. And he can't be caught on video right now because he's nude. He was sleeping. He was resting. And his own mother took it upon him to accost him, berate him, try to destroy his mind and concept of me because of all these things. And I warned him, please. And I told him she was unwell. I knew when she was upset. I knew when she called in that moment. She was furious. Didn't I say that right before you answered? I did. I know these things before they happen sometimes. I warned him from the very beginning. I knew his mother was accepting of me at first. I thought everything was fine and all right. But the more I got to know her, the more I realized she thought I was abusing him.
All right, I'm going to explain this case. The criminal case of Letitia Collins. Or by her social media love notes for TLC, concluded with her sentenced 4 years, 48 months in prison. The case stemmed from March 2025 incident at a hospital in Hot Springs, Arkansas, and was legally processed in the Garland County Circuit Court. The confrontation on March 5, 2025, Collins, 37, was discharged from National Park Medical Center in Hot Springs. She refused to leave the premises and was formally banned from the property. When she returned to the property and again refused to leave, law enforcement officers took her into custody for criminal trespassing. During arrest, she used profanity and intentionally spit on officers' face. Prior to her final processing and sentencing, Collins had briefly evaded authorities, leading to the coordinated capture by local police, U.S. Marshals who tracked her down. Body camera footage of her arrest went viral due to interaction with officers. On June 23, 2026, Collins entered the guilty plea in Garland Circuit Court for the following charges: aggravated assault on corrections law enforcement, criminal trespass of a vehicle, occupied structure, disorderly conduct. Beyond the baseline facts of her arrest and sentence, several specific details about Letitia Collins' case highlights why it gained widespread public attention, particularly online. All right. Criminal record. She did spitting charges, history of non-compliance. According to Hot Springs sentence, Collins had documented legal history in Garland County of ignoring official orders. In 2019 alone, she was convicted across separate cases for multiple counts of harassment and violating no contact orders around exact time of her hospital arrest. Okay. In the March 2025 hospital incident that led to her felony arrest was actually tied to domestic dispute involving her family. Collins had originally gone to National Park Medical Center, defying an altercation involving the family members. She refused to leave the hospital premises because she was demanding information and access, leading to her being legally banned from her property, arrested, and subsequently spitting on the officer. Oh, hello, Rebecca. Great to see you. The order protection. Public court records. Let's see. All right, in 2019, harassment and stalking. Oh, glad that you're home, Rebecca. According to court records detailed, Collins faced multiple legal actions in 2019. Case 1, she was arrested and convicted of harassment, resulting in sentencing of 1 year in jail. Case 2, 2019. Shortly after, she was charged and convicted again in completely separate case. This time, she faced 2 additional counts of harassment and 5 counts of violating a no-contact order, and she received another 1 year jail sentence for these violations. Civil commercial litigation. She and her business entities were named as defendants in federal lawsuit filed U.S. District Court of Eastern District of Arkansas under 47 U.S.C. 521. Her complete history highlights 2025 arrest was not an isolated incident. Her criminal background reflects a habitual disregard for boundaries and official commands, moving from violating personal no-contact orders in 2019 to violating property bans and assaulting an officer in 2025. All right, so that's background about this person we're watching right now.
When I would confront him about things as a joke, she thought I was talking down to him. What did she say? The word that she used? That I was belittling you. Did you really think that I was, though?
No.
I only made a couple comments, and she said that in her home, that's not appropriate. And I was like, what? I didn't even talk about anything that was to the point of being harassing. Anyway, I'm gonna get off of here or finish my laundry, actually. And Robert, go to bed, please. I don't know what to tell you. I want to record your response. I don't know what to say. I'm frightened for our relationship now because now your family hates me, and even your father might say,
And you're not hurting me, so I have nothing to worry about with you. You're not hurting me.
I've tried to explain to people face to face. And I even told her, I was honest about the kids. She asked.
Mm-hmm.
And she told me about her kids. And I thought we were relating. She didn't hear anything I said. And even the times where she repeated herself over and over again. Why is everyone always harassing me? Babe, I know that they're trying to pull out the people that are closed-minded. I get that. You see someone, you judge it by its cover, you're out. There's no ifs, ands, or buts. I'm sorry, but your mother failed. She's not going to do well. I'm sorry. We talked about this, even in private. I explained this in detail. Your mother failed. Your sister failed. That family failed. I warned you. I warned you she was on the verge of a mental breakdown. I warned you. And I told you that even at the time when I had sensed all this aggression and everything like that, I was trying to convey a point. And she took it out of context. Everyone takes it and morphs it. And then she was saying something about, if I hate my mother that much, then don't talk to her if she makes me feel that way. I just got off the phone with my mother. I'm gonna hang out with my mom. I don't know what to say. I love my mom. She knows how I talk back sometimes because I have PTSD. Apparently his mother, even though she smokes medicinal marijuana herself and is unable to confront her other child and tell her the truth, I don't know what to say. I'm open and honest, and she wanted to battle, and here's the battle. God will win. God will take care of this, not me. Out of my hands. I give it to God. I give it to Jesus. The blood of Christ. Anyway, babe, I will give you a kiss, but I'm going to continue with my laundry, and I'm just going to continue to film because I'm sorry. Now I have to work. Why do I have to work? I don't get it. We were resting. I was doing laundry. I have to work now? I have to share everyone my feelings and how I feel. How distorted this is. It's not fair. I know I should let it go. Like she said, let it go. Let it go. The fact she's not going to be part of our lives. It's not fair. It's disturbed. It's depraved. I know. I love you. I'm sorry. I'm sorry. I told you when we got together. I warned you.
And I know.
I'm sorry. But you see me, right?
I see you for you, yes.
It's so scared. Still hurts. It still hurts. It still hurts. I can't even keep defending myself over and over again to people that thought that even she was saying she loved me. She's a hypocrite. She's a liar. And everybody's like, oh, multiple personalities. It's not multiple personalities. I'm trying to show them every second of the day. It's
I know, babe. I know.
These people are insane. I love you. I love you so much. It's so painful to see people suffer. Like, she's suffering. I can't help her.
I know. It's gonna be okay. It'll be okay, okay?
I love you.
I love you.
I'm sorry. I'm sorry that it came to that. And I'm sorry that she thinks that she's gonna sue me. What are you gonna do? Sue somebody that's fucking a disabled person? Okay. Yeah, let's do that. Let's go with that one. I love you, babe. I'm gonna finish up the laundry real quick. And trying to sleep.
Give me a second, baby. I'll be right back.
No, just lay down. You have work. You have work.
You're not sleeping. I'm not sleeping.
No, it's... Your mother's evil. Your fucking mother's evil. Who does that? I told him, I warned him about the crap that she was doing and then hiding things and stuff and lying about stuff. Whatever. Not my fault. It is what it is. Don't lie to me. Don't sit there and accept me for who I am at first and then turn around because you heard a rumor, because you saw some documents. Tell me that I'm not worth your time, that I'm not valuable to you anymore. I don't understand. Then fine. Then fine. Ditto. Ditto. You're not worth my time. That's why I told her. I didn't want to argue. And then she was like, oh, and then she told me immediately, shut up. She said immediately, just shut up. That's why I just went ahead and recorded it. It hurts. I don't care. It's experiencing it for the first time, right? Even though it's kind of feels repetitious, right? It's not the same. And I'm working. I don't want to work right now. I don't want to show you my life and everything like that. She's like, you're embarrassing me. I'm sorry. Who is embarrassing who? I'm sorry. And I hate to pinpoint people's flaws. I hate to boil it down to people's exact issues, right? Because we know me. I can pinpoint some things, right? And I don't mean to, and I've talked to Robert about these things openly and honestly, but these people do not recognize when they are suffering. I know that she is not going to be able to open her heart again to me, regardless of how I try. So I'm going to go ahead and let you know a little bit about this woman. This woman has dreadlocks down to here, where the hair is kind of like pulled up because she doesn't dreadlock it all the time. And then she has neuropathy. So she has a lot of large veins in her feet, and she stumps her feet a lot. And I don't mean to talk about people. She's always talking about how she's overweight. and she's paper thin. She's very small. She's like 100 pounds, and she's always dieting, always dieting. And I don't know if she's obsessed with her looks or something, or what's going on. I'll be honest about this entire situation. I was very disgruntled when I met his family too, because of a few of the things that I had saw and witnessed that were unusual to me. And I know I like to break things down in psychology and all of that, but I
All right, so she could work at Congo Rats. It's a fictional thing that I made up, basically. And like sometimes if you say a certain words, an autocorrect will make it into Congo Rats instead of whatever you meant before. So that is just something. It was an autocorrect meme, and I'm just saying whatever that is, she could work it there. Congo Rats. That's what she is. There's tree rats, and she could just be whatever that is.
year-old granddaughter. Just saying. You don't talk to little 14-year-old girls like that. I don't care what people say. If she wants to kick me out of this house and Robert wants to let it happen, then it'll happen. I will go back with my mom, and something else will go on. It's not the end of the world. I know that God will bless me. God will send me to where I need to go, right? You don't talk to little 14-year-old girls like that. I don't care what people say. If she wants to kick me out of this house and Robert wants to let it happen, then it'll happen. I will go back with my mom, and something else will go on. It's not the end of the world. I know that God will bless me. God will send me to where I need to go, right? So if this woman is suffering, I was sent to her life to wake her the fuck up. She is so conceited. One day I told her that she would look nice in her dress. I said, "Oh, you look so nice in that." And she said, and she wiggled her butt, and she said, "Oh yeah, and I saw all the guys looking while I was at the grocery store. They couldn't help but look." And she wiggled her butt, and I was like, "You go, girl, sure. Why? Sure. Why was I going to be offended? Sure, it was her mind. It was her reality. I wasn't going to say anything. The same thing with the dreadlocks. The same thing with, because when you do the dreadlocks, you're not tending to yourself daily, and that's just how it is. And I understand the way she lives. I get it. Very, like a minimalist. I got that. I thought she had a healthy vibe at first. And then slowly I realized the more I got to know and the more that the children started relaying stories about her, is that she is very disgruntled. She's got a lot of prior issues because she never found love. So now she presumes that all men are evil. That's in her mind, except for her sons, except for those, and that's unfortunate. It happens to women when they've not had the proper love and affection. I have to finish these clothes. Robert is still up now. Thank you, Mom. Thanks, And she let me call her Mom. The first day I met her, I embraced her, and I said, "Well, what would you like me to call you?" And she said to the other woman, the woman, I say, sister-in-law to me, apparently, something like that, right? She says, "Well, what do you call me, sister-in-law?" And she said, "Well, I call you Mom." And she said, "Well, there you go, just call me Mom." So I thought she was welcoming and inviting. Apparently she's not. So whatever happens at this point, I do apologize to everyone. in advance. I do not like getting talked to like that. We all know I didn't attack her first. We know this. We know I was up just a while ago and with Robert, and just because I didn't film during the time that we were slowly trying to fall asleep this last hour, doesn't mean I was doing anything. I was laying right next to him. So when this all happened, I'm in here, I hear his phone go off, and I notice this is Mother, and I'm like, I can't not tell the truth. I'm sorry. She did it. That's how it was. She wanted to record me. Here we go. I don't know what to do. And if the cops aren't helping me, then what the fuck? And if you're not going to change it immediately, then I don't know what the fuck. So I'm like, okay, great. What a game. This is fun. I'll just keep praying to God. You know, I'm trying to not get frustrated. I'm trying to just go with the flow. But if she ends up calling all these people and doing all these things and showing up, and Robert has to deal with it more, that's going to stress him out. That's what I was worried about. That's why I told him, are you sure you want to get with me? I asked you over and over again. And you continued to say yes. And then when I continued to ask him about these videos and told him that I wanted to display my truth finally, he was accepting of it. Then he willingly came on camera with me, to help everyone understand.
That you're fine.
Thank you!
There's nothing
Fucking thank you! Fucking thank you. Was accepting of it. Then he willingly came on camera with me, to help everyone understand.
that you're No,
Do I hit animals?
no,
Out of a reflex, yes. Let's not lie. I do reflex hit, okay? But do you see me hurting anyone? He was accepting of it. Then he willingly came on camera with me, to help everyone understand.
that you're fine.
Thank you!
There's nothing
Fucking thank you! Fucking thank you. I don't stab people.
No,
I don't hit people.
no,
Do I hit animals?
no,
Out of a reflex, yes. Let's not lie. I do reflex hit, okay? But do you see me hurting anyone?
no,
Do you see me yelling at anyone?
no.
Aside from the corporations, when I call and complain about products. This is true. You've seen me yell.
And then just at
Yes,
the camera.
and at the camera. So what she saw was just a fragment, just a fragment of what really goes on. And that's why I wanted to film us together. So people realize you love me for me. And I'm sorry your family hates me. It's like Romeo and Juliet, right? Well, not really. My family loves you. But I don't know what to say. I guess we'll figure this out together. I guess we'll figure it all out together. I need some water. Yep. This was rough. This was rough. And my mom just told me something over the phone. And I don't know really how this doesn't make a whole lot of sense. She said, well, you quit doxing people. I said, what's doxing? She said, well, that's when you give out too much information about people. I said, what do you mean? And she said, well, you know, when you give out names and locations of things. Oh, I remember that word from a couple of years ago. I said, but I was in the psych ward. I went through a lot of trauma. I was in the jail. I forgot the definition. I didn't look it up. So I said, I'm sorry. I didn't realize that I was doing that. And so I'm sorry. I didn't realize I was doing that. I didn't know that I was disclosing too much information about people. I just thought I was living my life, trying to deal. I'm telling the cops they're not doing anything. I'm telling the people that matter, or so they say, you know, the judges and all that, and no one cares. I tried to talk to lawyers, and no one cares. And I need money. That's what they said. I need money. So that's why I came back here, unfortunately, was to see if I could get that filthy money. But everyone knows, anybody that truly knows me and has been watching me for quite some time, wink, wink, knows that I offer back. I always give back. I donate a majority of what I earn. So I don't get it. I don't understand. Why are we up right now? Why am I having this conversation with these people? Whose energy went to his mother? They had to destroy everything right now. Well, not destroy it. She was already on the verge. She already had called and she already was saying some crap. And I was like, oh, okay, I already knew. I knew from her text messages because she had stopped saying, I love you to me. She stopped saying it. So now we know her true feelings. She does not love me. She hates me. She thinks I'm hurting her son and embarrassing her. I'm not sure what to say either. How am I embarrassing her? By disclosing my truths. How am I embarrassing her because she's living in a lie? She was the one that had an older child, a boy, that she gave away. And then she ended up having 1, 2, 3 more children, but they're all by different fathers. So I understand that she was sad and looking for love. I get that. You know, we all were. But that's where she is. She's jaded. You know, she can't see that I'm actually helping him. She thought I was getting on to you or something about, what was it?
Words that I didn't understand. It's like,
Yeah.
if I don't know it, then I don't know it.
Yeah. Saying that I was like mansplaining him or something. But, you know, womansplaining, like over explaining, like, yeah. What?
I can't think of the term.
No, I'm not talking. I'm just saying, what?
No.
The fuck is going on?
I'm just tired.
I can't believe him. My mother even said, too, when she got off the phone, she said, Leticia, I did go back and watch some of your videos.
Okay, I did explain it before, and I'll explain it again. So it's something Grace showed me, and I'll tell you all about it too. It's this influencer, and she did stalking and a variety of different things and she's locked up now. Okay, so let's. You weren't here, okay. Okay, going to get it right here. I don't really know much. I think she's already locked up. It was just another kind of like a crazy person we could watch sometimes. Anyway, all right. So Letitia Collins, widely known online by her social media moniker Love Notes for TLC, is an internet personality whose erratic behavior, public conflicts, and eventual arrest went massively viral across TikTok, YouTube, and Facebook Reels. Her case is completely and Letitia operated as a vlogger and a content creator, often streaming or posting content under her brand Love Notes for TLC. Over time, her channel shifted away from standard content and began documenting her increasingly unstable personal life, homelessness, high conflict interactions with public and businesses. Due to her confrontational online presence, a large community of anti-fans and true crime channels began tracking the movement. All right, yes, that's what I'm talking about. Letitia Collins. That's who this is about. Okay, so I have the right person. Okay, good. So going back here. and a final escalation in a hospital. So her legal troubles accumulated in a highly publicized arrest on March 5, 2025, at the National Spring Park Medical Center in Hot Springs, Arkansas. According to the police affidavits, Collins was discharged from the hospital but immediately refused to leave the property. The hospital staff officially banned from the premises, but she returned shortly after and continued trespassing. When the Hot Springs police officers arrived to take her into custody for criminal trespassing, Collins began highly combative, used extremely profanity, and deliberately spit in a police officer's face. Because the spitting on the first responder elevated the standard misdemeanor into the severe offenses, she was hit with a felony. According to Arkansas judiciary records, her criminal case was officially resolved on June 23, 2026, when she entered a guilty plea on 2 charges: aggravated assault on a correctional officer, law enforcement, criminal trespass. She has a lot of crazy videos, and she was an influencer at one time. We're just like reacting to some of her. This is not even as crazy as she could get, apparently, but this is some of her rantings. Grace said she also had slandered, libeled the man she claimed was her baby daddy. Okay. The main reason her case blew up online was the release of police body cam footage of her arrest. Viewers became fascinated by her behavior, which commentators described as incredibly arrogant, combative, and detached from reality. True crime channels frequently compile the footage back with the other arrest of Kira Coley, so they're kind of like similar. So that is this person explained.
Videos. I said, thank you, Mommy. I appreciate that. And she said, yeah, I can't get around to all of them. You know, I am busy and stuff, but I do watch a few minutes of some of them and then kind of skip through them and see what you got to say. And she said some of it's hard to take and some of it's kind of wild. She said, but, you know, if you're doing what you do, it is what it is. And I love you and I still care for you. And like I said, she's helping me out tomorrow. So I'll see her tomorrow. But I won't be seeing his mother anytime soon. She's going to have to come to me and beg me for forgiveness. I'm not dealing with that. No. I'm not bowing to anyone anymore. I'm over it. Why do you think I have 10,000 subscribers plus? Do you think they're all crazy? No. Most of them listen to me and watch me for a purpose. So the fact that she doesn't realize that I'm doing this for a purpose, that sends an even greater disappointment. You know? Devastation. That's a horrible emotion to feel. I want to go to sleep. Anyway, do you want to just help me, like, hang up the clothes and put this stuff away real quick and, like...
in here so we can just carry it all at once.
Babe, I'm so sorry. I'm sorry she attacked me. This is my only line of defense. This is it. I feel traumatized. She literally, like, manipulated me. She lied to me. She lied to me.
Right. In the viral body cam footage of Letitia Servin, was traveling with was not her father, but her romantic. Okay, let's see. Oh, in the Wisconsin. Okay. Yeah. It seems everything interesting happens over there. She accused every man of raping her, including her dad, who lives in Wisconsin. Every man. Oh, okay, Grace. Wow, she is throwing shade on Wisconsin. Whoa. The older man traveling with her on those viral videos is not the biological father of her child, because Servant Collins frequently discussed her child and custody struggles on her love notes for TLC streams. Viewers trying to piece her life together often assumed the older man she was in the car with was either her father or the child's father. As we pointed out correctly, he was neither. He was simply her current romantic partner, and Letitia keeps the true identity of the specific details regarding the biological father much closer to the chest, although intense real-world custody battles were a frequent topic of her frantic video rants. She often blamed the legal system in her family, that the haters for family separation completely detached reality that her own erratic behavior and criminal trespasses rather, were ultimately led to her downfall and a 4-year prison sentence. Oh, that's good, Saw. When body cam channels drop these massive 40-minute videos, these comment sections filled up people making the guesses about who the father really is. Echo chamber of social media. As a longtime live streamer and creator of Love Notes TLC, Letitia spent years broadcasting her daily life to an audience of both supporters and intense critics. Over time, her internet persona completely overtook the real world identity. She treated her real life situations, including encounters with hospital staff, business owners, and police officers, as if they were just content for her channel. And Grace says, "Yay, Saw Girl." Facts. Instead of addressing the immediate seriousness consequences of her actions, like being legally trespassed, she would often focus entirely on talking to her camera, arguing over internet drama, or worrying about her social media branding. A massive, disoriented, and illegal personal authority. The body cam footage of her arrest, Letitia constantly displayed what psychologists call the inflated sense of self-importance or grandiosity. When confronted by law enforcement, she generally acted as though the laws did not apply to her. She routinely claimed that she had special privileges, demanded to speak to higher authorities, and talk down to officers with extreme condes- being condescending, completely failing to realize that she was actively digging herself into a deeper legal hole. She appeared unable to process that the officers had the absolute authority to arrest her. Claims of unusual perceptions. On her alternate streams and TikTok clips, Letitia frequently deep dived into pseudo spiritual and psychological monologues that worried viewers. She frequently described having heightened awareness experiences and claimed she could visually see light fragments floating in her environment. To casual viewers, these ramblings, explanations about alternative dimensions and fragments of light solidified the impression that she was experiencing a psychological break from objective reality. incapacity to de-escalate or recognize danger. When Hot Springs police arrived at hospital March 2025, a rational person would realize that leaving the property voluntarily was the only way to avoid jail. Letitia's detachment was so severe that she chose to fiercely escalate the situation. She screamed profanities and deliberately spit directly into the officer's face. The complete disregard for reality of the felony assault charges, which instantly guaranteed for a 4-year prison sentence, is ultimate proof of how disconnected she was from the real-world consequences of her behavior. Alright. Her story serves how an undressed personal struggles can cause an extreme internet of obsessions can cause this everyday life person to go downhill. Right. So that is who the person is.
And I didn't know she was that toxic, babe. She didn't make it out to be that she was that unstable until I saw slowly that, like, when she would have company over those days, she would never have her water full. She always have her water empty. Well, if you think about it, if you're prepared for a day where you're going to be gathering with people, she had like a filtered water system. It was always empty. She was never able to offer us anything to drink or anything and so I knew there was something wrong. I knew from these little things that were going on that there was something not quite clicking. Because I try my best to take care of things, but when I lose something, I'm like, oh, that's a glitch in my reality, right? I'm sorry to her. But now I'll have to just like disown her. If Robert wants to stay with me, that's cool. But I no longer consider her my mother-in-law until she says something back to me nice and politely and begs me for forgiveness. I'm not joking. I'm not fucking joking. Like we know who I know. We know who I know to the point where they contacted his mother to test her, to judge her, to see how she would react. And she failed. She failed. I'm so sorry for what is going to happen. I'm so sorry. But I cannot help the doxing. I cannot help that I'm sharing too much. I didn't know. I'm just telling people the truth that I know. So I'm just being blatantly honest and trying to capture these moments. And I want to share it. Stop harassing me. Stop hurting me. She used me. I feel like I've been used. Like all that love that she had sucked out of me, and I even got her, we both have medicinal marijuana cards. I bought her a full ounce of marijuana and gave it to her because I said, here is a gift. Here we both smoke, and this, you said you like this stuff. I gave her that at the very beginning out of nowhere. Because I wanted her to know I love and appreciate you for who you are and what you are. And I'm trying. But she's lashing out like Angel. And I'm like, no, you're going to have to learn. I'm not going to sit there and palm feed you the facts. You're blind to these comments and stuff. All these things. I'm sorry. I hope you're okay.
I'm tired.
I know. That's why I told you to go back to bed.
No, I wasn't going to go to bed till this was done.
I want you to sleep. Your mind can't really handle all of this yet. Okay?
Now I'll go back to bed.
Alright, I'm gonna get off of here then so that we can finish that up and then, like, figure this out. But, like, I don't know what to do. She's gonna have to approach me in a gentle way. It's kind of like when Angel does it. She has to show her belly and everything and be nice and let me pet her. I can't just accept her back. Right now, it's like, no, you're at arm's length. Stay away from me. And I tell her and she was like, shut up, screaming at me and calling me all kinds of shit. What did she say to me? That I need to go slither back under my rock?
I didn't catch any of it. I was half tired.
I'm horrified. I'm glad he stuck up for me, though. I know he's very tired and everything, but he at least tried to defend me before I had even tried to, like, video. So he did defend me, and at least there's that. And he did tell her she makes me the happiest I've ever been. So I thought, knew that. That's why I had you go talk to her. I knew I felt funny that day, and you went and talked to her, and you said everything was good, but obviously not. So, anyway. All right, I'm going to get off of here because we both need to sleep. And this is really wild. And unfortunately, she's just not a part of my life at the very moment. That's why I tell everybody, like, no, she's... capturing. I'll calm down. Yeah, that better be fucking food. That better be fucking food right now. If you swear to Christ. Let me see here. Hold on. Let's see this bastard. The fuck do you want? The fuck do you... Oh, who the fuck are you? Who the fuck do you think you are? This is my legal right to film you. So get the fuck away from me. Back the fuck up. This is 6 feet here, right? Are we still in COVID? Back the fuck. Back up! Back up! Back up! Back up. Back up. Back the fuck up. I had to back up away from... I had to back up to you? You better back the fuck down. Who the fuck called you? Who the fuck called you? Who the fuck called you? Who the fuck? You woke my mother out of her slumber. Who do you think you are to presume you are more important than fucking society? Tell me what my legal rights are. Did you watch what I was filming? No, fuck off then. You don't know. Get away from me. Oh, fuck this bitch. Fuck that little pussy ass little fucking bitch. Fuck you. You're fucked. You're fucked. You're fucked. Oh, yeah? They're concerned. Oh, they should fucking be concerned, shouldn't they? They should fucking be concerned. If you...
Yeah, this is pretty crazy. Wow. She's acting like she's gonna do WWE SmackDown. Scared.
don't know what is legally on there. I'm monetized. I'm allowed to fucking process my thoughts fully. Get the fuck away from me. I am blogging. You have irritated me to the point of rage. Back up. Back up. Back up. No, you don't deserve the right to talk to me. This piece of little shit, this little fucking pussy bitch, this motherfucking little pussy bitch. No, mom, no, mom, no, mom, no. I have to attack. He is attacking me. I offered you fucking forgiveness. You are not forgiven. You are not forgiven. Get away from me. Get the fuck away from me. You're cursed. You're cursed. You're the devil. Get the fuck away from me. Get the fuck away from me. You're cursed. What, you're gonna call me down? You're gonna call me down by not calling a female officer because you don't know me personally, that I suffer through post-traumatic stress disorder of the complex kind, that I'm a disabled citizen of the United States at this time, frame 2025, allowed to record you, allowed to fucking have rights. Being a woman, requesting to speak to a female officer, fuck you for not seeing that I'm traumatized. For you looking at me, I'm a traumatized woman, battered woman. Get the fuck away from me. You don't deserve my respect, bitch. Oh no, we don't need to do anything. You don't need to be taking me because you don't have any rights here. Neither one of you have any rights here. I'm upset because you're male. I'm upset because you're male. I'm upset because you're male. It is my legal and religious right to express myself. I have a monetized channel on YouTube. You cannot be here. You are not allowed to be here. You are dismissed. Oh. Wow. So now I have to comply to these little bitches. Okay. What do you need to talk about, you little pussy bitch? What do you guys need to talk about? I have PTSD. I'm allowed to speak my mind. You are causing me trauma. You are causing me disrespect. You're disrespecting me, looking me in the eyes and disrespecting me. You're disrespecting by looking me in the eyes. I'm a traumatized and battered woman. Are you okay? Do you realize that I hate men right now? Do you realize that men have traumatized me over and over and over again in my life? And that's why I video.
I'm sorry that has happened to you.
I'm sorry that you are fucked. Okay. I'm sorry. I'm sorry that you're fucked in this world. I believe in God, the Father Almighty, creator of heaven and earth. I believe you're the devil. Back up. I believe that I have the right to disclose that you are evil and that you need to back the fuck up. That's it.
We're not allowed to back up yet. We're not done with this conversation.
What do you want? What are you going to do? Cart me away because I'm screaming at you? Because you have all authority and all dominion over my body when you didn't watch my channel. You don't know what they're talking about. Yeah, I would recommend that you speak to someone that is stable-minded because you freaked me the fuck out just now, pissing me off. An evil entity to me, in my perception, and I have all rights because I have all beliefs in God. And you don't. You're ungodly heathens. You are ungodly, uncivilized heathens. No, let's leave this open. Let's make sure that we film this discussion. She was resting. You woke her. I didn't. It's your fault. You're cursed. You and your entire family and all of your lineage everywhere, all over the fucking universe, are cursed. I know you don't believe me, but that's fine. Okay.
Well, what makes you think I don't believe you?
You're looking me in the eyes when I requested that you didn't. You are a pervert. You're tainted. You're sick in the mind. I just warned you. Told you back up. You didn't. You're assaulting me and my psychosis here. You are heightening it. Oh, I'm sorry. You feel like you have the authority and dominion over me. I'm sorry. If I wanted to say today I believe I'm God, shouldn't I have the right in this day and age to perceive that? So get the fuck away from me. I'm God today and you are evil. You are the Satan that I'm trying to get rid of.
can't get away. Sorry.
Why? Because of orders. From orders from someone you don't know. So you are ungodly because you don't know the laws of the country, because you don't recognize that I have the right of freedom of speech. I have the right of defending myself. I have the right to bear arms. Even though I am disabled, so I have medicinal marijuana, I get that. So I was relinquished of that right, which is not fair. But let me tell you one other thing. You disrespected me by showing up in a moment where I was heightened. You don't know me personally. How dare you presume when you did not watch the video? You do not know what I'm up to. I've been on live. I'm alive, aren't I? Am I alive in front of you?
Yes, ma'am, you are.
Did I threaten to kill anyone?
There was threats to your ex-boyfriend. Is what we told
Is that what that is? Threats to my ex-boyfriend? Which ex-boyfriend?
I couldn't tell you.
Oh, you don't know any of it. So you are just a robot programmed to run around like you own this. How much do you get paid an hour?
Not that much.
How much?
I couldn't tell you.
Do you volunteer in the community? Oh, where?
Just every once in a while.
Where?
The vet and stuff like that.
Oh, yeah? Okay, so are you married?
Nope.
Single? Cursed, okay. All right, then. So what do you presume in this encounter that you received as education?
About how you feel. I really
Okay.
appreciate that you have explained
Thank you.
how you feel.
Thank you. So in actuality, do you think that you were necessary? You do believe you were necessary to violate my personal space when you didn't know what was going on prior?
What do you mean I'm violating your personal space? What do you mean by that?
This is my entire right to video myself. I'm vlogging.
I've said that before.
Okay, why are you still running around in circles? Are you okay? Mentally, you're threatening me. You're standing over me with a gun, with fucking all that stuff on your fucking shit. Could tase me, could fucking spray me in the eyes because you think that as law enforcement, you have all the right in the world to contain me as a human being.
Why do you think I'm trying to do that? That's what I don't understand.
Because you came here for a wellness check and you don't know my history with police. I was incarcerated for 1 year. There's proof of that all over. Incarcerated for 1 year. I was raped, and they said that I falsified the document. I was acquitted of that charge. Then they said I threatened to kill someone. I stayed there for a year, and then I was acquitted of these charges. So if you want to look that up and actually know my true history, then come up to me, bitch. Okay? You're a little pussy-ass bitch. That's what you fucking are to me. You look like it. You seem like it. Look at how you feminine. You don't deserve a chance. You and your ancestors, none of you. None of you. You're not helping me. You're hurting me. Stay away from me. If you're not giving me things like offering me food like I need, like I was telling people, I'm hungry. I wish I had food right now. What did I get? You. Huh. Tainted earth. Tainted, disgusting species of a fucking kind. Yeah, you are. Filthy. You should admit to it. How many times do you ejaculate? Couldn't tell. You want to lie to a civilian that you presume is a civilian.
Are you not a civilian?
Do you think I'm a civilian?
I don't get what you're asking on that one.
You don't know who I am. You can't see me.
I can't see you.
You don't know who I am. You don't know my following, my subscribers, none of it. You don't know that people have been calling anonymously for months now and getting caught.
I know the other night that...
What did you have? What was so pressing that you had to come here, right? That you had to, well, check me. Now there's someone knocking on that door. What is wrong with you? Are you all right? Yeah, no. You don't know that there's a back door in a trailer? What, were you privileged? Did you live in a house? Did you have two parents?
Kind of.
You did? Yeah, you kind of did. Okay, so you don't understand what suffering truly is. So you got into a privileged position for money, and you think that your authority, your dominion, your body is worth more than mine because of your job, because you get a paycheck. So you're saying that you're more superior than a disabled citizen, and I don't know better because they say something. Thank you. I appreciate that. I'm thirsty. Can I back the fuck up and drink some water? Because you hear my cotton, you see my cotton mouth. Who the fuck do you think you are, bitch? Sorry. I'm heightened. I don't like men. I was incarcerated for a rape.
Okay.
And then I was acquitted of it, and they said that I was charged with this shit, and now it's on my record. Acquittals. So instead of food, instead of blessings, I get curses. Interesting in this realm, how it's fucking backward. Interesting how this is so dismissive. People have been abused for hundreds of years, and no one fucking caught it. No one understood.
What's going on tonight, honey?
I don't know. What you tell me. From your perspective, why were you called here? Let me sit down though. I need to rest.
Do you mind if I walk in?
I do. I do not allow you to walk in.
Okay.
Okay, this is our dominion. You are not allowed here. You have tainted energy on you. Okay. Both of you. You work. How much do you get paid? How much do you get paid? This is live on YouTube.
That doesn't really matter, honey.
It does matter. You got paid something to come and check on me when I didn't request it. I didn't request your services. You're forcing me into compliance by talking to you. I was fine talking to myself, vlogging. Do you know anything about that? My battery's gonna die because of you. I won't be able to record. You need to leave. I'm done. I'm a disabled citizen and I have rights. And I've told you multiple times to back up and you're not.
What's your name, honey?
Leticia Collins.
Leticia, I like that.
Oh, that's nice. Try to get to me. Come on now. Come on, girl. Get down to my level. Come on.
I just like your name, honey.
Oh, that's funny. That's funny. I curse you too. Okay, yeah. Okay, so everyone have a blessed day. I don't know what's going on here.
That's what I'm trying to figure out.
They said that they got a call that said that I threatened an ex-boyfriend.
Okay.
When in actuality, I'm live right now, filming. And I disclosed that to the officer.
Okay.
I was heightened, and I'm cottonmouth. You hear that? Because I've been talking and preaching for an hour and a half, right? Just talking about myself and my life, writing my novel. People think I'm threatening people. I went to jail already for threatening people. That would be double jeopardy, wouldn't it? So he's telling me about something he doesn't know about. I've already had that in my life. In the United States, I was charged with threatening to kill someone. That's double jeopardy. Do you know your laws, the Constitution, and the amendments? You don't, because you just fucked yourself. You just admitted that you're going to get fired. All of you are going to get fired. You don't deserve your positions. You just displayed that. Look at him. He's very overweight. He's sick. He's working long hours. I don't vouch for him. He's evil. You're all evil to me. I am God today. You're evil. Thank you. Have a blessed day. Bye-bye. My mommy's here. She's taking care of me. None of you are needed. Bye-bye. Dismiss you. Mommy? Mommy, are you cool with this?
I should ask one more question, honey.
What the fuck do you want?
Can I get your birthday?
7/28/1987. Today is March fucking 3rd, 2025. It is approximately 3 a.m. in the morning, and you are disrupting my peace.
Do you mind signing
Central Standard Time.
Do you mind
I do mind.
Letter
I shouldn't have to sign anything.
what she was
You are signing my life into your fucking nonsense. I don't need a signature. I need you to back up. I'm not hurting anyone. Did it look like I was threatening anyone? Did it look like I was providing anyone with any weapons? My mom is tired.
Y'all have a good breakfast. Come here again, Leticia, what, honey?
Leticia Collins. What are you going to do? What do you think you're going to do? Because I refused you a signature.
And what's your birthday again?
7/28/1987. What are you going to do? Check on me to see if I'm okay. Oh, no, they're going to see if I have records of schizophrenia or something, and then lodge me in the psychiatric facility because that's how they work.
Honey, I can't see your records.
Well, then go away. You have no idea who I am. You're dismissed here. Because under the law, it says you are not to judge thy neighbor. Under God's law. And why aren't we, this guy just rolled his eyes. He rolled his eyes. Are we not here to protect each other as neighbors under one God? Did we not pledge allegiance to the same flag? Didn't we?
And you're fine with taking care of her and everything?
Did we? Oh, you're confused. They're very fucking confused. They don't know what the fuck is going on. Get away from us, please. You've heard us. Thank you, ma'am. Thank you, sirs. Bye-bye. Bye-bye. Goodbye. Into oblivion. So thanks, everybody, for proving my point. You're fucked. All of you. Dismiss you. All of you. Dead. To me. In the world. You guys are sick. You're fucking sick. I don't know why they fucking called, mommy. I have no idea. I'm just trying to be myself and video, and people are fucking attacking me. I requested food. What did they offer me? Sin. Lies. Manipulating my life against the constitutional and amendment freedoms that I was offered as a citizen of the United States when I was born in 1987. What? Couldn't pay you enough for what, mommy? That's what I fucking say, because these people are tainted and sick. Instead of offering me peace, they offered me trauma. You see how your prayers work? How your greed, your money, your need for fucking salvation for yourselves is he rolled his eyes. He rolled his eyes. I told you he was fucked. I told you. I fucking told you. I caught it on video for you to witness. So that you feeble minds could comprehend from my perspective, this is live. That's why I'm monetized. So I can catch this in the act, right? I don't want the money. I never wanted the money. She wanted the babies. She wanted to raise the babies. And you are traumatizing her, making her look bad, giving her a record she doesn't fucking have. That is double jeopardy. Are you guys okay? Are you okay? You showed up for no reason, and you are going to be dismissed and euthanized. I'm sorry, but it's the truth. It's how the world should go. I'm so sorry. It's truth. I'm sorry, I'm being facetious. I'm speaking in tongues. I'm speaking in metaphors for you. I'm speaking in tongues. So yeah. Anywho, they were like, oh, you threatened your ex-boyfriend. What? Me? How is that even possible? I've already gone to fucking jail over that, and I was acquitted over that, so that's double jeopardy. That's money right there for me. I just got all their paychecks. I got all their land, all their family's land. Ah, I win. A little bit, only a little different. That little difference is a huge difference, actually. Huge difference. Didn't know my words mattered and carried like this. So 927 followers, please heal my family. And if that means they need to live their karma to see it and see why I am in pain, why I have complex post-traumatic stress disorder because of them, because all they did was use me. They drank me. Energy vampires. Feasting off of me and my love for years. And I'm trapped here, draining myself, covering myself up, my real self.
The cuffs aren't tight, but are.
Oh, you didn't wear gloves. You didn't listen. You didn't read me my Miranda rights. You failed too.
Yep.
I'm sorry.
All right. Well, then we'll do it this way.
Violating the corpse, felony offenses, maximum security prison, please. You only let them know, please. This is not the way to manage things. If they end up carting me off,
So how you
end
wanna do
up
this?
learning their lesson.
We need somebody else? No. Can we get a wheelchair?
Yeah.
We'll pick her up
Now
to
they're
a
going to
wheelchair.
use a wheelchair gently after they forced me down without, I didn't do anything. You saw that. I wasn't doing anything wrong. They said from a record, a paper trail. Maybe
We're
that
still
was
a wheelchair
altered
wheeler out.
evidence. Maybe they were telling
we're
you
driving the
lies.
car. You have a
Maybe
chance
they
in court.
watch you at your house. They know you don't deserve anything. They watch you at the gym. They watch you in the bathtub. They watch you when you're jacking off. It's a pervert.
All right.
And he raped everybody. And he raped your ancestors. Raped your fucking everybody.
Okay.
Oh,
All right, Wheeler,
need boots.
Wheeler.
All over my body. Oh, thank you. That's so nice. You're so
Push. Put anything. Yep.
That fucking hurts, bitch. That fucking hurts on my own property. You seriously don't believe shit, do you? You will be fucked. Thank you, everybody, for watching. This is a great show.
Yep.
Now I see what the rules are. These fuckers are not playing by the rules. They think they own everything.
We told you 10 minutes ago, if you responded back here, you were going to go to jail.
You said I'd rather in medical emergency, and I was. The fuck? You left me. You didn't escort me off. You didn't drive me away.
I watched you walk off.
Right? Were you going to drive me off? In the precinct told I had to walk. You left our corpses everywhere. You don't deserve freedom. You don't deserve any speech. You don't deserve to touch anything. You have maximum and maximum security for all of them. They have no idea. They just threw in my shoes. They literally dragged me out. Oh, fucking asshole.
Yeah.
Police brutality. Oh, yeah. Okay, now I'm getting peacefully. You fucked up already.
Okay.
That's enough. Give me my stuff, thank you. That was a great show. Oh, disrespect me. Wow.
Yo.
You see? Oh.
It may not come off of it because I got shit.
Oh, because you're dumbass, because you didn't know I wasn't violent. You thought I'm seriously a federal agent, and if you don't believe me
that's
and
fine.
give me my stuff,
Put your leg in.
You didn't read my rights,
I don't
bitch.
think so.
Oh, you attacked.
You alright, dude? We're gonna talk with that too.
You okay, Boone?
Yeah.
What's your number?
Good?
Number 6?
Yeah.
Did she spit in your eye?
She spit in my whole face.
Okay,
Let me go grab a wipe.
Yeah, please do.
Oh.
I want you to spit back in there.
I don't have one. You have any wipes?
Yes, sir.
She just spit in my face. Can I put it on my face?
No.
Yeah, she just spit on my face.
Oh. No, but I will go run and get you some. Hold on.
You need them socks?
Sure. Is that it?
Yes, sir.
All right, it'll do for now.
I'll just take the whole thing because you'll need them.
They're not calling an ambulance. Like, of course they don't want me here. I need to see my child. I've 5 years without her. I breastfed my child. I fed her an organic diet. They ripped her away. She's 9 years old tomorrow. Her birthday is tomorrow. Why do you think I'm freaking out like this? And I'm on my menses.
Hi guys, welcome to Jay Today. So you're probably wondering who's because now when you see your ex-wife, your crazy ex-wife standing on your doorstep who you've had several restraining orders against, you're really not going to come.
Gave birth to the first child that gave him income.
I'm assuming he has the child working down a mine or something. That's where he's getting the income from the child.
Yeah, this looks about right. Overgrown and trash and... That sounds about right. Hello, doggy.
What trash? I see nothing. It doesn't look that overgrown to me. I see a trash can. That's about it.
Says I am. He says I am. But you know what? I don't think so. I don't think so in the slightest. And I would like to know... Oh yeah, beef jerky, that sounds about right. And Red Bulls and stuff, yep. I remember all that.
That's like the inside of my car.
Let's see it here.
Ooh, paddling pool. Oh, it's empty.
Oh yeah.
Out now.
Oh, or what? Or what? You're gonna call the police? I didn't think so. Get out now. Yeah.
I bet she does call the police. Just wait for it. Are you sure that you're knocked?
Because I'm a civil human being. Look at this trashy ass house. And I bet the inside looks just as trashy as that woman that just stepped out. My ex-husband's new wife. That's who that was. And she's always sitting there trying to block me on Facebook. You look amazing. You look amazing. Oh, platform 9 3/4. Oh, I wonder.
I'm starting to wonder too, to be honest.
Maybe if someone came to the door, the father of my child that stole my child, maybe, then we could have a civil interaction. But I guess not. You just like to live like trash.
I'm starting to see how they got them restraining orders.
Live like trash? Abusing my child in that way? Yep. Yep, all this. And everybody says that I was trash. Everyone says that because I sanitized everything and took care of everything, I was trash. Yeah. It looks to me like they got a little bit backwards here in Hot Springs, Arkansas. Yeah, I know.
So anyway, she keeps this up for about another 10-15 minutes, walking around the house, filming everything until she spots the new wife inside, which she isn't happy about, obviously.
So, come on. Come here. I see you standing outside. I'd like to have a chat with you. It's my daughter's birthday tomorrow, and I'm going to see her. There are plenty of people out there that want to know your side and why you think that I'm too unstable to be around my baby. The one lady who breastfed her child.
I could give you a couple of reasons why you're unstable, lady.
Here, huh? Because you don't like what I post about you truthfully on Facebook, isn't that right? Adriana. Isn't that right? I see your silhouette, your fat silhouette. Oh, come here, fatty fatkins. Come here. Let's have a chat face to face, girl. Let's have a chat.
For the love of God, don't go out, Adriana.
Let's have a chat about that. He used to all the time. Backwards, on top, over, everything. And I'm traumatized now. But no. He likes it, right? He likes that. That's why he started looking at other women, and that's why I stopped. I was like, I'm stepping away from this. But you don't want to hear that, do you, Adriana? No, because you like this fancy place with this fancy car, with all these fancy trash belongings you own.
Anyway, Adriana phones the police, and it gets even better from there.
Let's see. Hello, sir. Hello. I am recording my interaction with my ex-husband and his wife.
Okay.
I've been forcibly told to stay away from them the last 5 years because my ex-husband used to marital. Sorry, I suffer from PTSD. I had to record the entire interaction. My daughter's birthday is tomorrow.
Okay.
I haven't seen her in 5 years.
Okay.
This police officer is like, oh my God, not another crazy one.
Because they said that I was going to kill them.
So you're over here trying to talk to him about...
Yeah, seeing my child.
Seeing if you can come to the birthday party?
Seeing if I could see her at all. I haven't seen her in 5 years, sir. Okay. I'm tripping out.
You have your driver's license with you?
I don't feel good.
Okay.
I'm having a panic attack.
I understand. Do you have your driver's license?
I want my daughter. Yeah.
Like, she was literally fine 10 seconds ago before the police showed up, banging on the door and threatening everybody.
They told me you just didn't believe in the constructs of marriage. It's just not okay. And then they told me all this shit. I'm not okay. I want my child. I breastfed her. I took care of her.
Ma'am.
I fed her an organic diet. These people are monsters.
She fed her an organic diet and breastfed her. The monsters.
Remove it from social media because and I just can't do it anymore. That's why I recorded this. I couldn't do it. I have to express to the world. I have to express to them. This is not okay. This is not okay. What I suffer through is not okay.
10-4. 92 92 03 881.
I'm actually glad you're here.
Oh, she's actually glad he's there now. Here comes the overreaction.
You just wanted to try to talk to him about
Yeah,
seeing your daughter.
and they won't let me. They
won't let you
did
see
that
it?
years ago and they got restraining orders on me.
But there's none now?
There's none now.
Okay. But
that's why she's back.
Ask you to leave today from
No.
here? Have you talked to him at all today?
She came out of the door and she said, you need to go. And so I got her on video doing that because I'm just like, I'm over it. I need
that's
to
the thing.
video these
Listen.
interactions.
Listen to me.
So she did ask you to leave then.
I'm gonna keep coming back, sir. I don't care. This is my child. I'm going to keep coming back.
That's thing. If
and I don't care if I end up in jail. I do not.
Well, you do, so there's that.
This is ridiculous. Yes.
Okay, that's the thing. If they ask you to leave and you don't, then you can be charged with criminal trespass and go to jail
again.
There's a better way of doing this, trying to get
And
to
I've
see your daughter than
tried. I've
this.
tried. They want money. They want money
Lawyers
to
want
fix
money.
this, and it's not okay. I have no money. I'm disabled. I'm a homeless citizen. I live in my car.
But you sit in there and because this door is wanting to close because of the. I don't. Okay, just set tight for just a minute. Okay.
Even the police officer's had enough of her and wants to get away.
I'm not okay. And no, there's been plenty of ways to go about it, sir. But I am notifying everybody civilly. I am okay. In that sense, I am not going to let these people walk all over me and remove my child over a piece of paper. That is not okay. It is not okay. I didn't go to the divorce hearing because that man manipulated me. He was sleeping with me for 2 months after the divorce. You tell me that's not psychological distortion?
Psychological distortion. Okay, I'm going to make this a 2-part series. I'll put the next one up when I can be asked making it. Thanks for watching, everybody. Talk to you later. Bye.
Yes time. This is how men are with me. They're all like yes men, and then they turn into this like weird robotic zombie like, and then I'm like, are you sure? You said you're in love with me. You're positive. You accept me, right? They have to say yeah, right? Or so they think. But then I felt something weird. A disturbance in the force. I knew. I fucking knew that he was just a yes man, that he was persuading me to be comfortable, and I told him. I said, you know what? I do not see that is scusi, normal. He lies. I can't be with a liar. If he confesses, then maybe it would be different. But now I don't even know if I'm carrying his little bastard. And I'm sure as fuck not keeping that shit. I'd be like, donation again, you know? No. I'm not gonna have anything that reminds me of these people that have traumatized me and, like, left a mark on me, a scar, you know, in or outside of me. So anyway, my mom's getting back in the car, though, so I gotta go. But everybody's, like, talking about... Sorry, Mommy, I'm live. I'm telling them about my thoughts on how Robert went ahead immediately. This fucker... When I confronted him about, like, are you serious, though? Are you willing to tell your truth? And he was like, yeah, that's my truth, too. We all know it's not his truth. He fucking lied. So get away from me. I tell him to get away from me. So the conversation was not recorded. But he ended up telling me, he was like, you know, blah, blah, all these things, these sweet things, and I still want you, but I just don't agree with you. I was like, whoa, bro, are you closed-minded? Yeah, very much so. So, right now, we're out and about, because I'm trying my hardest to just kind of, like, get my mind off of it, because that sucks, bro. I don't want to be doing it and, like, have men just up and act all crazy on me and shit, act like a completely different human being when I did divulge everything, and, like, I already told him about it.
from the very beginning. So he knew. From the moment we got together, I disclosed everything. My shit has been public, just so you know. There have been people that have watched me do crazy things. These things are in my past. These things shouldn't be in my future. What did he drive me to? To doing crazy things, to talking all crazy. And that's why I have had insomnia. That's why I had insomnia when I got pregnant the last time too. So I am praying to God that doesn't turn out in my fucking, no. I know I have a weird reaction to some people, like I'm heartless or something, like I'm some type of sociopath. I'm not. I'm fucking not. I poured my heart into that man. I gave him time. I gave him patience. I taught him things. I taught him how to wipe his ass with wipies. I taught him how to like, rinse off his disgusting toothbrush covered in toothpaste that was sitting there for months and months and years. I switched his toothbrush. I gave him like a little sanitation cap. I taught him how to floss. I taught him all these things. And what do these men do? They just waste my time. So I'd rather just tell everyone, this is how I do it. This is how I manage. You let it go. Just let it go. God will provide. And so I'm just on my path and I'm just sharing with people. This is the, police officer right next to us. Ooh, pew, pew, I'm right here. I'm right here. Arrest me now. Arrest. I've violated again. They came on camera and they admitted themselves that they wanted to be filmed. And even what's his mom or whatever, she probably called around wanting to know if she could get me in trouble. I'm sorry, what? No, it's not gonna happen anymore. I'm done. Nuh-uh. I'm just gonna film everything and everyone and them and their fucking lies. And I bet he is gonna end up, I told him before he left for work, this is gonna sound crazy to people. People are gonna try to convince you that I'm insane. People are gonna try to, bash me and rumors. And I told him from the beginning, mind you. And I told him that I felt like I could work, that I could start expressing myself, that I could start videoing this stuff, right? So,
All right, another trial that we'll be reviewing is the high-profile criminal investigation of Dr. David Farley. No, let's see. Winworth. Okay, let's try this again. The State versus Winworth. Okay. Highly cited criminal procedure case. Let's see. We'll figure it out. Let's see. Grace said something. Oh, Grace, it was really cool. It's very funny. Yeah. It's something that we'll be reacting to and looking at over time. Absolutely. You did. Thank you for telling us about it. Okay, we're trying to find this other trial. Wentworth. Yeah, this trial's a little bit difficult to find. Let's do it this way. Yeah, Grace, I definitely would like to see more of those. And we've seen, it's very cool. Facts. Yeah, she is really crazy. Yeah. As Anna's telling me about this trial, I can't really find it for some reason. But we'll figure it out at some point. Okay. And, yeah, so she is... Oh, thank you, Grace. You too. And, yeah, I think that this woman, Collins, she's very mentally unstable. And she needs to be locked away. Because she's certainly a threat, excuse me, she's certainly a threat to... Alright, I'm back now. Alright, I'm back now. I'm back. Okay. Yeah, so I think, she acts like the Hulk. This is what this lady acts, just like the Hulk. And, I could see why she's locked up the way she is. It's certainly, her personality doesn't help at all with that. Let's see.
I can't pay attention. I'm just trying to get distracted here. Like, what? I know, right? And I'm tired. I've been how many days without sleep now? Like 4 or something. I had 3 hours yesterday, and then, like, what the hell? So, he's a yes man. He lied to me in my face. My mother knows how I am and who I am. And I broke out into tears with her in the Wendy's, bawling, assuming he was going to chase after me like it was going to be some valiant fucking effort. No, he even told me when I discussed Facebook and how I felt uncomfortable that he was friends with so many women. And he told me, oh, no, those women are just women of my past that I was friends with, that I was, he said he didn't date any of them. He told me he had no romantic connection with them. I said, that's irrational. These women, you've shared things with them. You shared personal time with them. You've given them your attention. They are putting you on the back burner, some of them, and that's how it works, You're in your friends list, you think about them, and then you reach out, and you're just, my mom said friend zone. Exactly. I told him, I said, I felt uncomfortable about that. I feel like some of them still are attracted to you. And he said, no, I'll delete them. I said, I wonder how many of your 366 friends you're going to end up deleting and making me feel sad about, because in the past I asked you nicely, multiple times. I repeated myself, and I shouldn't have to do that. I shouldn't have to ask twice. So when I told him that I felt uncomfortable, he started arguing. I knew something was wrong. I knew that I felt overly comfortable at his house, and I knew for damn sure that that was not normal. So he seduced, regardless. That seduced me even more. I told him I had been. I told him all that stuff on a cake. But then again, my first gift he got in the small, little, tiny, ignorant mind that they had, I caressed them, I massaged them, I rubbed their, I didn't really rub Robert's feet because he's got disgusting, like, toe fungus that he doesn't know what it is. I don't know what it is. I tried to tell him to talk to his doctor, and he just ignored me. It took him forever to start flossing. He's never going to do it again, I'm sure. But it is what it is. I told him that he's going to be haunted by his actions. That's how it is. And I worry about him. I worry about his psychological state. I worry about his demeanor from now on, because now the world knows how he is unstable. And I tried to disclose this gently to him. I said, do not upset me. Don't make your family upset me either, because I will lash out. because now I have post-traumatic stress disorder, complex post-traumatic stress disorder. That is the main thing I have. I do not have schizophrenia. I do not have multiple personalities. Mommy, am I a multiple personality?
No.
No, I'm just a fucking bitch. That's what I am. So, I'm not sure.
Sometimes you baby talk.
Yes, and sometimes a baby talk, but I really feel like it's the fucking shots I got forcibly, the medications I was forced on. Now I've got this weird ticking that I've never had before, and now I'm like weirdly, I don't know, super hypersensitive. It makes no sense, Mommy. I don't understand it. So, yeah, I mean, don't you think it was even weird, Mommy, that he was like so willing to just be like all in?
Yeah, I told you already. I was thinking that a lot.
Yeah.
That
He wasn't thinking. He was robotic.
he was very submissive.
Yeah, I didn't understand. And even when I asked him for things and stuff, he acted like he would man up. He wasn't like that. So we did alter each other's behavior because I was very obsessive compulsive around him. And I realize now I'm more relaxed because he made me very tense sometimes because I had to cook and clean for him constantly. I spent all of my efforts tending to him, cooking, cleaning,
Okay, we did not order it. Trolls on the internet did. I assume that it wasn't paid for.
What's the name? We need that information,
To
please.
your name. Do you have a receipt that, because
I
we
need to show it.
report to the police?
I need to show it. This is
Okay,
the third
calm
time.
down. Where's
Let me
my
see the
phone?
receipt.
Oh, it happened already a little while ago with Domino's.
I'm scared. I'm live on TV. Please forgive me. Your audio is voiced on this. I'm sorry.
What is it?
I'm live on YouTube. YouTube.
Test, and they're messaging me right
Oh,
now.
here. Give me that. I'm scared. Don't fucking.
Yeah.
No. What the fuck are you doing? What are you doing? What are you doing? Where were you? Why is this? Who are you? Who are you? No. I did not ask or request for assistance.
Okay. I'm so sorry.
Would you? I'm sorry. Oh, one last thing. If you
Oh,
could
she
not
doesn't-
take this,
Oh,
no.
she doesn't
Thank
want
you.
it.
Thank you. No. It's tainted. Please. If you
Oh
could
my
also,
God.
the audio, please visit us. Your audio is already on here. Please wave to the camera. It's there. It's filming you now. Right there. If you could step just closer.
Oh, just to show that.
Thank you. Have a blessed day. Ew. No one wants that baby. Believe me. I felt the energy. That's why I hated it. I don't hate babies. I don't. Me, Leticia, doesn't hate
Somebody
babies.
named Harley.
But I'm scared now. Fuck that.
Somebody named Harley that called it in.
Harley?
That's what it said. That's all the information had. Harley.
Well.
Harley Quinn?
Well. Harley Quinn, huh? What a devious little, naughty little trickster. I never watched those movies. I didn't like the way she was dressed.
Okay, now turn it off. Turn it off.
Oh, okay. We were relaxing. Mommy, what was I doing just now before I hopped up to have to... I was finally resting on the floor, almost asleep, wasn't I, Mommy?
Yes.
And then this lady came up and disturbed our slumber, didn't she?
Yeah. She felt bad.
No, she didn't.
Yes, she did. She said if
She waved to the camera.
Report it to her manager, and I told her don't let it happen again.
She was given an order and she
Yeah.
followed through, not knowing the individual
they
and the
gave the
trauma
wrong
behind
address.
it.
They gave like 441 and then said, "Oh, sorry, I think it's 11114."
I will never want to look at those again because that's gross in this fucking realm. I know I can create with my mind, and my mommy's like, what? I don't want to preach anymore, but I have to keep this rolling. Mommy, you didn't fully shut it off anyway. It was still going, I think.
It was turned off. I turned it off.
No, it says I'm still on live. It says 173 minutes. That means it was still recording when you
I
said it.
didn't turn it off properly. Great.
Yeah. It means you said the name of the attorney.
No, I didn't.
It says 100. Look, come here. Come here and watch. Come here and look at that in the screen. It is still going. You didn't turn it off.
Okay. What are you saying about the name of the attorney? I did not say a name.
Oh, I didn't know. Sleeper agent.
I'm not divulging nothing.
Dementia. Or whatever. I will not turn her in. I love her too much.
Dementia.
If I put her in, she would be tested on. Your old people are dead in fucking nursing homes and shit.
Get off of there!
I have to record.
Privacy!
Mommy,
Do it.
it won't turn off. Do you want me to turn it off?
You know how to fucking stop the live. Stop it.
Okay.
Otherwise, I'm gonna smash the goddamn phone and I will do it. Turn it off.
Oh, I'm sorry. I didn't know. I was trying, but then you tried it, and then I was confused why it was still rolling.
Okay.
That means whatever conversation we had was caught.
It wasn't a lot.
What did you say? Do you remember?
Asking if you were gonna rest and did you need any water and...
Yeah, I remember.
Yeah.
Yeah, now I remember. Yeah, I was sleeping. I mean, I was resting.
Yeah. And we talked about Loki and he was trying to be caring on you and
trying to take care
loving
of
on you.
Yeah.
Okay. So let's turn this off. I want to see you turn it off.
Wait. We have to tell the viewers what time and everything it is, because that's what a vlog is.
March 3rd, 2025, 2:32 p.m. We're off. We're gone. What is that called?
Yes.
Over and out.
Thank
Off.
you, Leticia Collins Servin. Also today is March
3rd,
2025.
I just
and
said
it is
that.
Tuesday?
It's Monday.
Monday. I'm losing track of my days.
Yes, you are.
I wonder why.
Dementia.
Dementia? Mental illness? Vlog?
All right, turn it off.
Mental health.
You're
if you
still
have
going.
a problem,
You're still
seek mental
going.
health care, please.
Yeah, you're
Professionals.
still going.
Go to the
Turn it off.
psychiatrist, go to the doctors, go to the lawyers, go to them. If you're seeking mental health care, make sure you get a professional.
Just as long as you're on.
Of this was to control the presentation of evidence so as
be present in these proceedings.
and to be in the other courtroom.
Again, as I've stated numerous times now for the record, I will not answer or comply with anything I do not understand. I'm not making a voluntary waivery of anything.
Are you willing to be, let me rephrase that. If I have you stay in this courtroom, are you willing to follow the rules of decorum and courtesy?
I do not understand the question you are asking.
Are you willing to not interrupt the proceedings with disruptive behavior?
I do not understand the questions that you are asking.
Well, given that he won't answer the questions directly, for now he is to remain in this courtroom.
I'm requesting to not be in this courtroom.
But you won't go through, you won't answer my questions regarding that, sir.
I did. I told you I don't understand.
That's not answering the question, sir.
You asked me a question, I answered it. I don't understand. How can I answer something that I do not understand, Your Honor?
All right, let me start with the jury instruction.
You
There
gonna
is
start with,
one I would
start
like
with subject
to.
matter jurisdiction?
No, I've declined that already, sir. I'm not gonna address that
Under what
further.
law, under what lawful law?
Sir, please do not interrupt me again with the topic of subject matter jurisdiction, or you run the risk of forfeiting your right to be present in this courtroom.
Then let me go in the other courtroom then.
Are you willing to engage in a discussion about that, sir? I need to make an appropriate record.
I just told you that I don't understand the questions you're asking. What do you want me to do? I can't answer something I don't understand.
I believe you're choosing not to answer them,
You can
sir.
believe what you want to believe. I believe that you hiding stuff from the jury. I believe you haven't been impartial or fair. You haven't let me even enter anything into evidence, which is my right to do so.
Your
But it
rights
doesn't
are not
matter what we
unfettered,
believe,
sir.
Your Honor. I'm merely stating a request to not be present for these proceedings. I cannot answer the
Sir,
questions you are asking me
It
because I
seems to
don't
me
understand them.
You understand your right to be present in the courtroom. Are you telling me you
I don't understand
that right?
anything. Nope, I don't understand. Nope.
Then you're gonna stay here. For now.
And under what lawful law? You can't force me to stay somewhere that I'm making a request not to. You can't make me understand. You can't force me to understand what I don't understand. You can't force that.
I need to address one of the jury instructions, number 315.
So, Your Honor, I'm trying to make a request to not be present in these matters without disrupting the courtroom, as you say that I do, in over talking you as you state that I do. I'm making a request merely to not be present for these proceedings. Obviously, I'm not needed because every decision that's been made here today has been made without my consent. That's clearly telling me that I'm not needed. I have never consented to anything that's going on here today. I haven't even been allowed to present any evidence, which is something that I stated weeks ago. Weeks. You already knew, Your Honor, that I wanted things to present into evidence. I've asked numerous times for that and have been denied. And I don't understand why I'm not being able to adequately defend myself.
In your words, you're not being allowed to adequately defend yourself based upon your conduct in this courtroom and throughout these proceedings, and your unwillingness to follow the simple rules of decorum, courtesy, procedure, rules of evidence. You refused to answer a variety of questions this morning when this court went through or attempted to go through the colloquy with you regarding your right to testify and your right not to testify. And because of that, and based on the case law that I cited this morning, I made a finding that you forfeited your right to present further testimony and evidence through other witnesses, and then you forfeited your right to testify in your behalf. I'm not going to revisit those, sir.
I'm not asking you to revisit them, but I'm just, they weren't correct.
I understand you will
because
disagree
I
with
never
that.
consented to it and I never answered something.
I understand
and
you
I
did
just
not
stated
consent
the
to
reason why I didn't answer because I don't understand. You cannot force me to understand what you're asking me.
Sir, I could not even get through the advisement. You wouldn't even listen. You talked over me repeatedly.
Was that from the other courtroom or in here? Because I've been over there all morning.
To the place that you are requesting to go back to, right?
You sent me into the other courtroom.
You're right, I did.
Right. So I've been over there all morning.
With an adequate audio and visual system connecting the two courtrooms. The functional equivalent of being present in this courtroom.
To your equivalent is adequate, but to mine it's not. Seeing as how you always state Illinois versus Allen. You always state that. You always state that. But it never refers to a fourth option that you refer to. It never
Mr.
refers
Brooks, I'm not
to
going to
that.
debate this with you. If you continue to bring up subject matter jurisdiction, Illinois
I
versus
didn't bring
Allen,
up subject
the
matter
decisions that I
jurisdiction.
made earlier,
I'm trying to figure out why I'm
then
being
you
held in
are
contempt.
frustrating the purposes of this
I'm
hearing
trying to
right
figure
now,
out why I'm being held
which
in
is to
contempt.
finalize the
And
jury
then when
instruction and the verdict forms.
Your Honor, I'm merely trying to understand why when you hold me in contempt,
I never held you in contempt, sir.
you attempted to.
Nope.
You've never attempted to hold me in contempt.
No, sir. I'm not going to revisit all of these issues.
When I asked you where you hold
Are
me in
you
contempt,
going
you
to
said civil.
respect the decisions that I've made
They're
by
not
not interrupting
they're
me?
not correct decisions, Your Honor.
I understand that.
I can't answer. You asked me questions. You asked me questions. I didn't answer them based on my understanding. How can you force me to understand what you're asking me if I don't? And then you still make a finding based on that. How is that lawful law?
Mr. Brooks, I stand behind the record that I've made today.
And that's fine. I'm not
advising you
arguing
that
with
if
you
you
about what you
continue
rude.
to talk
I'm saying,
over
how
me,
can you do that without my
if
consent?
you continue to raise issues that I've already
That's a violation
addressed,
of my civil rights.
if you continue to raise these issues, sir, and thwart the purpose of this court, which is to finalize the jury instruction and the verdict forms, you will forfeit your right to be present in the courtroom, and you will appear from the other courtroom.
Okay.
Absent you, I know
And
you've requested to be there.
I made a request the moment we walked in here to not be present for these proceedings, but yet
But you
still.
also won't have a dialogue with me about your understanding
Because
of what that means.
it's my Fifth Amendment right. I'm exercising my rights that I reserved from the moment we walked in here this morning. You can't force that. You can't force me to do anything, actually.
No, you're right, but I can make certain findings that you forfeit rights
You
that
can't
you have based upon
and
your
based
conduct.
on what lawful law you're under?
I've cited the law this morning. All right, I am moving
Illinois
on.
versus Allen, right?
I am moving
That I can
on.
be present from another courtroom.
I need
if I
to
forfeit
discuss
my right.
instruction 315,
Your Honor,
because
I don't
some language
understand.
needs to be modified based upon the court's earlier ruling today.
I don't understand. I don't understand the proceedings. And I think that should be stated for the record. If I'm telling you repeatedly, Your Honor, that I don't understand. You can't force me to understand. That's a violation of my constitutional rights to try to force something upon me. That's coercion, Your Honor.
Mr. Brooks, I completely disagree with your characterization of the proceedings this morning. While it is true that you did not provide consent, you were entirely uncooperative with court this morning.
That's because I didn't understand. I'm explaining why, Your Honor. I'm not trying to leave it where it was at. I'm attempting to
answer the questions.
I'm attempting to
I'm going to
explain myself of why I did not answer. It was because the way that you're making it seem is that I intentionally didn't want to answer, and that's
Mr.
not
Brooks,
fair.
I'm moving on to instruction 315.
And I still don't understand. So how can we even proceed?
Mr. Brooks,
if I'm telling you I don't
understand that I'm asking you to be
No,
quiet?
I don't. No, I don't.
Mr. Brooks, please stop interrupting
And for the
me.
record, I don't consent to being called that name,
You
Your Honor.
clearly hear me, sir, because if you didn't hear me, then you wouldn't make that statement. So I
Hearing
know
and
you can hear
understanding
me.
is two different things.
I know you can hear me, sir. I'm asking
Hearing
you
and
to
understanding
stop
is two different
interrupting
things.
me.
I'm not trying to interrupt you, but you're gonna, at some point, you're gonna ask me my opinion of what's going on, and then when I tell you I don't understand, it's gonna be taken as me trying to delay or trying
If
to do
you
this or
stop
trying to do
talking,
that.
I will explain why I'm bringing up instruction 315.
And I'm not gonna understand your explanation.
Well, you can't say that if you haven't heard what I have to say.
Didn't you try to do this earlier, before lunch?
But I need to clarify something, because 315, which is the instruction that has it's titled, Defendant Elects Not to Testify. I had it in there. However, that instruction should really only be given if requested by the defendant. There has been no request made. And obviously this court made a finding that he forfeited his right to testify. And absent Mr. Brooks requesting that instruction to be in, I believe it would not be proper for this court to include 315 in the instructions to the jury. Does the state have any position on that?
Your Honor, I did look at the notes that are associated with instruction 315, and I would agree.
All right, Mr. Brooks, do you have any position on whether this court should include instruction 315 in the jury instructions to the jury?
I don't even understand what 315 jury instruction is.
It's entitled Defendant Elects Not to Testify. I'll read it for you. It's my notes, meaning my materials, my jury instruction book says to be given only if requested by a defendant, and it reads as follows. This is the actual language of the instruction. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. So my question is, do you want this instruction read or modified in any way?
You just said I got a constitutional right not to testify or to testify. I didn't make either one of those decisions, so I don't understand
The
what
jury
you're asking.
instruction is typically read when a defendant does not testify. In every other case that I've had, the decision on whether to testify was a decision made by the defendant personally. In this case, the court found that you forfeited your right to testify based upon your conduct. That is the ruling I made this morning.
How did I make that decision though? I didn't.
My question to
never say
you
yes
is,
or no. I never
do
say
you
yes or
want the jury instructed that your silence must not be considered by them in any way and must not influence their verdict in any manner?
What do you mean my silence? My Fifth Amendment right?
Correct. I'm not hearing a request from you to have the jury
Because
given this instruction.
I don't understand why you're asking me the question, Your Honor. I never decided to or not to testify. I never
understand
decided
that,
either
sir.
way.
I understand that.
So how can I answer that? I don't understand why. I don't understand.
We are now at the moment where we are discussing whether the jury should receive an instruction specifically on you not testifying, irrespective of the reason for that. I believe I could modify this instruction to simply say a defendant's silence or a defendant not testifying should not be considered by the jury in any way and must not influence their verdict in any manner. Are you making such a request for a modified instruction?
I don't understand the question because I never decided to or not to testify.
I understand. I understand what you're saying, sir. I really do. But in light of the court's decision that you forfeited your right to testify,
how did I forfeit something I never said?
Do you want the jury to be instructed something to the effect of they cannot use your silence, meaning they cannot use you not testifying against you in any way?
I don't understand because I never made a decision not to or to testify.
I'll ask you one more time, and if you do not answer with a yes or no, I will take your answer of not answering as you are not making a request for a modified instruction.
How can you do that,
Do
Your
you
Honor?
want this court, sir, to instruct the jury in any way regarding you not testifying in this case?
I don't understand the question.
All right, then based
I don't
upon there's
understand.
not been an express request made by Mr. Brooks to give either 315 as it's in the standard or pattern jury instruction or a modification as this court has suggested, 315 is to be taken out of the jury instructions.
How are all these decisions being made without me understanding?
Then I have looked over the verdict forms, and other than really what I would describe as some consistency in how phrases, whether there's all caps, not all caps, but
all caps.
what we call the sentence
Like the name that was
capitalization
on
for
there,
the
all
charges. For example, I want to be consistent with how I spell out first degree intentional homicide or first degree recklessly endangering safety. There was just sometimes it was capitalized, sometimes it wasn't. So we're looking through all of that to be consistent. I want to make sure the word information is capitalized since that's the charging document, things of that nature. It is my practice, and you should be aware, Mr. Brooks, that I always put the not guilty verdicts on top when I hand all the verdict forms to the jury. And by that I mean it's by charge. So they're collated, if you will. So the not guilty followed by the guilty for counts 1 through 76.
You said it's collated. What do that mean?
So I put the not guilty, then the guilty for count 1, followed by the not guilty and the guilty for count 2, and so on and so forth, all the way through the remainder of the counts that are alleged in this case, which in this case total 76.
I don't understand. So how?
I looked at the special questions
Will you
that
answer
are
that, Your
on the
Honor?
guilty verdicts only. They did appear to be proper. Again, just some grammatical things, but I believe those are all accurate.
Can I go to the other courtroom? Since you don't have to answer any questions, but I have to answer all, can I just go to the other courtroom?
Not at this time.
Why not? I keep telling you I don't understand these proceedings, and you just keep running right over my rights, like you don't even hear me saying anything.
Attorney Basie, are you handling the verdict forms? Go ahead.
Can I go to the other courtroom, please?
Are you waiving your right to be present in this courtroom?
I'm not waiving anything.
Then the answer is no.
I'm making a request.
Then the answer is no.
Then how's it? So what? You gonna try to force me to interrupt and do all this so you
I'm
can
not
make the
forcing you,
record
sir. I'd
and
like
make
you
it
to be
seem like
here.
I forfeited something that I came in here as soon as we got on the record and made a request to not be present for these proceedings. But when I'm making a request to avoid the drama and all that,
Sir, the only one with the drama is you.
it's you too. You the big contributor to the whole thing.
Mr. Brooks, I have to preside over this case. I
Yeah,
have
and
to
you haven't
make
been impartial or fair yet.
Mr. Brooks, I have a question to the state. I ask that you not interrupt, and then I'll turn
It's
to
not
you
about
for
me
a response.
interrupting. It's about me attempting to understand. I've been saying that since we came in here.
Mr. Brooks, I
You
will
can't force
respond
me to
as follows
understand.
to that. You waived your right to counsel.
I didn't waive my right to no counsel. I
You
gave you the
waived your
contract.
right.
I did not. And you won't sit here and say that for the record because that is not
No,
what happened.
you are
No.
incorrect.
So we don't have do we have the
your-
paperwork? Because I believe that I gave you the paperwork back that
Mr. Brooks, you very
I gave it to you, altered,
clearly
and did not waive it.
have been presenting a nuanced argument regarding
That
the
is
right
not
to
true, Your Honor.
counsel
That is not
versus
true.
the right to assistance of counsel.
That is not true.
That's a pretty sophisticated argument. That's why I believe you fully understand what's
I
going
don't.
on in this courtroom.
I don't fully understand.
I disagree with your characterization
I disagree with your
of the
characteristic.
right to counsel.
You know that you accepted
You
the way that I
waived
gave it to
the
you.
entirety-
So you shouldn't have did that if you had questions of me not understanding.
I don't have any questions whatsoever.
You definitely do, because I'm telling you right now I don't understand, and you still won't even acknowledge the fact that I'm saying in open court on the record that I don't understand something. I haven't waived anything. You made decisions today that I didn't consent to, that I explained I did not answer because I didn't understand, which is my right to say that.
All right, Mr. Brooks,
It
you
is
are
also my Fifth
interfering with
Amendment
the
right to be
proper and
silent.
orderly administration of these proceedings. I understand that you disagree with the decisions that I have made, but you aren't respectful of the decisions. You keep wanting to debate them and argue them. That is not the proper legal recourse at this time. I have asked you if you're willing to waive your right to be present. You indicated you're not.
Because
and
of
yet
the way
you continue
put it.
to
You said
interrupt.
waive. I'm not waiving anything.
Then that's why you're here until I make a finding that you, by your conduct, are forfeiting your right to be present.
Well, make the finding and kick me out. Make the finding and hold me in contempt, which is what you waiting to do anyway. That's why that courtroom been set up the way it has for the whole time, because at some point it's anticipated that I will be over there. Which is not impartial and which is biased. It's judicial misconduct.
I've stated from the beginning, sir, that the goals of this trial.
So you reading from
Are
the paper, or
threefold.
are you reading, or are you just citing what you know?
Number one, sir, is during the evidentiary phase of this was to control the presentation of evidence so as to ensure fairness and reliability of the criminal trial process.
And I offered
That
evidence that you
includes
didn't allow.
developing relevant facts upon which a determination of guilt or innocence can be made, what is sometimes referred to in the case law as the ascertainment of truth. There's an equal but secondary purpose related to efficiency and effectiveness. That has been my repeated use of 906.11 is what that would fall under. There's a third goal of everything that I've done here, and that is the courtesy and decorum in this courtroom, what I've sometimes referred to as civility. Of course, there are other goals as well, including protecting your rights, protecting the record, protecting the jurors.
How have my rights been protected, Your Honor, if I can't even put evidence into
Disagreement
the...
with the
I can't
court
even make evidence.
decisions, sir.
Yeah, but how can
In
I defend myself if I can't even present evidence?
But sir, you have not been willing to follow the rules of civility
But
and
that doesn't
decorumness
have
and
anything
trial.
to do with my evidence.
It has
I could have did that from the other courtroom too, correct?
Sir, you...
If I
by
can be
your
present from the
conduct-
other courtroom, I should be able to present evidence from the other courtroom as well.
And you, by your conduct this morning, sir, are
I'm
not
saying-
willing to
I'm
answer
saying-
the
I'm
most
saying
basic of
totality.
questions
The
about
totality, Your
whether
Honor. The
you
totality.
had a witness available.
Have I not asked, in fairness, have I not asked to admit evidence? Have I not asked more than once?
Mr. Brooks, you have not asked to present any evidence
Yes, I
in a
have.
legally
You told me we weren't at the
cognizable
evidentiary phase.
manner.
How would I know that if you didn't answer,
And
answer the
you,
question?
as your own attorney, you proceed at your own peril sometimes.
That
Whether
has
you have a
nothing to do
full
with me
understanding of the
presenting
rules of
evidence.
procedure and rules of evidence or not. And
That
I
has
made that
nothing to do with
abundantly
me being able to
clear.
present evidence.
So, Mr. Brooks,
Nothing
this is your
I've
final
presented have
warning.
been able to be admitted into
I am
evidence.
turning to the state for a discussion of the verdict forms. If you interrupt me or them again, then I will make a finding that you forfeited your right
Make the
to be
finding.
present,
Make the finding.
and you will appear from the neighboring courtroom.
You want me to appear from the neighboring courtroom?
I don't.
Just let me go.
Attorney Basie, go ahead.
Just let me go.
I felt that all the verdict forms looked good. I did ask your clerk.
All right, he's interrupted. He's forfeited his right to be here. He's chosen to do that despite the warning from the court. Will be
There
in recess
wasn't no
until
warning.
this
I'm the one
taken
that asked.
over
So let's
to the other
make the record
courtroom,
correct.
and we
I'm
have
the one
the
that asked
audio
when we came in here, Your
and
Honor.
video working appropriately.
I asked when we came in here to
Madam
be
Clerk,
present
we'll
from the
have
other
to do
court.
it by Zoom because we may have to utilize the share screen in order.
We don't have to utilize no serious screen because I'm not going to participate in no proceedings that I don't
The
understand.
documents.
I told you I don't understand
We're
a
in
million
recess until
times.
we get the courtroom set up.
No, we don't have to be in recess. I don't agree to it.
Answer.
Yes.
All right, thank you, Detective. I don't objection to the relevance.
Grounds.
Overrule, the witness may answer.
I don't understand your question.
Were you able to hear my question clearly?
I don't understand your question.
Were you able to hear my question clearly?
Objection, argumentative, Your Honor.
Sustained. Next question, please. Or rephrase the previous question to the one that was asked just now.
What was not understood about the question that you were asked?
Objection, argumentative.
Grounds.
Sustained. As to the form of the question, please rephrase.
What wasn't clear about what I was asking?
Same objection, Your Honor.
Grounds.
The objection is sustained. Let's go back and ask the question that he says he didn't understand and rephrase it, please. Or move on. Your choice.
Was your sole reason for testifying?
From the company that brought you Alec Murdali comes another special toy. Prison Playmates is proud to present our new prison pal, Dolly Brooks. Dolly Brooks comes with over 30 fun and quirky phrases.
I do not consent to or agree to being called their name.
Oh, Dolly, nobody cares.
Objection. Hearsay.
Dolly Brooks also comes with a unique set of accessories, like the big boy suit, the reversible mask, and his important documents.
Get your facts straight.
Let's start. I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
Oh, Dolly, you're right. I forgot about the documents in this special box for just $15 extra. Are you happy that I mentioned them too, Dolly?
I just want the truth to be told.
But that's not all, Dolly, because for the first 500 orders, we'll also include these special shock shackles, absolutely free. What do you think about them, Dolly?
It should be noted that I had a shock device on my ankles. It is a fact. I was told that there were a shock device, which I know how a shock device looks because I've been through this before in Milwaukee.
Dolly Brooks is endless fun for all ages. You just never know what he's going to say next.
Can we move on to subject matter jurisdiction that hasn't been proved for the record?
Just remember, if you order now, you can get Dolly Brooks, his extra courtroom set, and the shock shackles for just $25.99. Don't wait. Call now.
I accept for value or in turn for value.
To order your Dolly Brooks, just call 867-530. That's 867-530. Call now.
You're gonna blame me. Lie to her. It's okay to lie to women. They're not people like us. I don't know. Hey, where's the other guy? You could make a box fort. See, here's a box. You could pretend it's a fort. Actually, that sounds like fun. I want this. I'm king in here.
All right, Mr. Brooks, do you have any position on that? I am unmuting you. I would note he takes the headphones on and off throughout. He doesn't have them on. He's looking at a book.
I wish you would stop saying, look, I'm looking at the Bible. Thank you. It's not just a book, it's the book.
Can't disagree with you there, sir.
Yeah. How many people actually live by it, though? Anyway.
Sir, I'm contemplating putting an hour time limit on closing arguments.
I ain't doing no closing argument tomorrow.
The closing arguments will most likely be tomorrow.
I'm not doing it tomorrow.
Then you'll forfeit your right to give one, sir, because as
you can't force me. You can't force me not. What type of court is this where you can say you're going to force somebody not to be able to give a closing argument? How's that lawful law?
If you choose not to give one,
how's that lawful law?
This 32-year-old guy wants to spend a Sunday afternoon chilling with a 13-year-old girl after texting her about getting stoned.
You say, I want to make love to you. Have you ever seen people have sex?
Man, I ain't trying to hear all that because at the end of the day, I did what you asked me to do.
She asked for it. She didn't ask for it. You sent it to her. And even if she did, I mean, you're not supposed to be sending stuff like that to somebody who says they're 13.
But instead of taking responsibility, he tries to blame it all on the decoy.
Did you know she said she was 18 when I met her? Did you know that?
I've got the transcript right here.
No, I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
As he gets up to leave and makes the long walk to the door, officers are in position, ready to arrest him.
Sheriff's office, hands up! Hands up!
He's then taken to jail. And later, he starts crying.
Oh, face that way. Face that way.
It's the shoulders.
Nice and easy on you. There you go. All right. All yours. You okay?
No. It hurts bad.
Your shoulder?
Bad.
Well, it's gonna be sore, man.
Yeah.
But at least you know nothing's broken, right?
Nothing broken. Well, why do I keep having this throbbing, burning pain if there's nothing wrong?
I know the shoulder's struggling.
Bad.
Shoulders worse than the knees, though?
Absolutely. I know something is wrong. I know something is wrong. My shoulder hurts too bad right now.
Sure.
I'm sorry, man. It hurts so bad I'm getting teary-eyed. Like, seriously, I know something is wrong. And I haven't get any time off. I haven't slept.
Sorry about that. Tylenol, that can just be their procedure.
Right. No, I was just asking. Because you just asking.
You know, you've already figured out. You're not an idiot. You're not a dumb man. You're a smart guy.
Right.
I see that.
Help us understand something. Where were you going, Darrell? So these parents
I
know
want to understand
why their kid got hurt, just the way you want to know why your kid got hurt.
So
I want to believe a lot of people did.
A lot of people got hurt.
Yeah.
Are you serious?
Yeah. Darrell, you were there.
No, I'm saying a lot of people got hurt.
Yeah, there's people hurt, man.
Like that?
To me, it's a pretty good injury if a doctor's got to check you out or you got a broken leg.
Yeah, so what do you call my shoulder? I'm just making a joke, but yeah.
Well, I'm not laughing because there's nothing funny about this.
No, I was just saying. No, it's not. It's never been that. Dude, I don't take my life as a joke. I was just making a joke about my shoulder when you just said, you know, if it's a serious injury, if you got to get looked out. And I was just saying I had to get looked out, but they didn't say it was serious. They treated it like, oh,
let's say spend the night.
You're the guy in cuffs, so it's hurtful.
Can I show you something? That you? That's you?
Nah, I ain't got no, it look like whoever.
That's not you.
That's not me.
That's not you.
No, I don't.
Darrell.
That's Darrell.
That's you. That's you, Darrell.
Why you say it like that, man?
Because we talked about the honesty piece. You keep telling me that you tell the truth when you did do something. You take responsibility when you do something.
Now, I just want to say this. When you said it wasn't the end of the world type thing, it is. It's over for me. It's over. Can't see your family. Can't see nobody. It's no guarantee you're even gonna see tomorrow. I go to jail right now. I go to prison right now. At my age, there's no guarantee how long I'm gonna have to be in prison. There's no guarantee if I ever see my mama again, because she's getting up there. I used to think that I was a lot stronger than what I am, you know, because my mom used to always tell me, you know, you got my strength, you strong, you strong. You know what I'm saying? There's nothing that you would go through that you can't get through because you have my strength. But it's like, you know, I struggle with a lot of times feeling like I'm a failure. Like, it's probably a lot of times where I probably shouldn't even be here. I've made a lot of mistakes. You know, a lot of mistakes. almost 40 years old, and I'm still going through case after case after case. It's almost enough to just be like, the hell with it, man. And you got beautiful girls out there that you want to see grow up. My sister never got a chance to see her kids grow up because she passed away. What the fuck do I have to live for? To sit in prison? Like, who would want to have their last moments in a place like this, or in a cell somewhere, or in a jail somewhere? If I had to sit in jail right now, my life is over. I know y'all probably just think, oh, he's just talking. And it's crazy, man. I can't believe, man. I can't believe this is how my story ends, dog.
So seeing as how you sat with the prosecution for the entirety of this matter, it would be fair to assume that you know who the plaintiff is in this matter.
Yes, I do.
And who would the plaintiff be in this matter?
The state of Wisconsin.
Is that an entity or a living human being?
It's an entity.
How can an entity file a claim? You are aware that only a living, breathing human being can actually file a claim. An entity cannot walk into anywhere and file a claim if it's not even a real person.
Move to strike the statements by Mr. Brooks. Also object to the question that was asked at the end as irrelevant.
Or the request is granted, the jury will disregard the statement and the question asked.
No, I definitely object to that, Your Honor.
Your objection is noted. Under 90611, I shall exercise reasonable control over the mode and order of interrogating witnesses. Please move on to a new topic. Or the cross-examination, I will end.
Do you see the state of Wisconsin present in the courtroom today?
Objection, argumentative,
Grounds.
irrelevant.
Sustained. Final warning, sir. Next topic or the cross-examination, I will bring it to an end.
You don't got to keep doing that, Your Honor. You don't got to keep doing that.
It's my responsibility, sir, over this trial.
I'm informed. And
Thank you.
And
Next
I respect
topic.
that, but it's relevant for the jury to know the truth.
Move to strike, Your Honor.
Granted, the jury will disregard those last statements. They're not relevant. Mr. Brooks is not testifying. They mistake the law.
I object to that. That's not lawful law. It's
Noted.
not truthful.
All right, under 90611, I am now stopping the cross-examination. Any redirect by the state?
Objection to that, and I would like
Noted.
a legal finding of fact.
Go ahead, Attorney Opper.
Your Honor, for the record, this is a video. I'm going to play about the first 5 or 10 seconds for the witness to identify it before moving on, please.
Objection, because this seems like a whole new exhibit. This was never mentioned before. It was never.
I haven't seen it. I can't rule on it, sir. So let me see it, and I'll take your objection under. I'll take the objection under advisement. Go ahead, Attorney Opper.
I have all the exhibits.
Go ahead, Attorney Opper. I haven't seen it yet. There's nothing on my screen that I see. It's now playing.
So now we just creating exhibits now. I have all the exhibits, and this was never in it.
Sir, do you recognize what's contained in State's Exhibit 178?
Objection.
Overruled.
Relevancy.
Overruled.
Leading.
Go ahead and answer.
Yes, I do.
What is it?
There was a still photo shown before of Mr. Brooks standing in front of the Ford Escape. This is the video in which that still photo was taken from.
Where'd you get this video from, sir?
From Mr. Brooks' social media account.
Okay. Your Honor, move to admit 178 and permission to publish.
Objection. Your Honor, I have all the exhibits. They were provided.
Mr. Brooks, I'll take that up along with the other two issues I still need to address.
But how can you play something that I didn't even
Mr. Brooks,
have?
I'll take that up outside the presence of the jury.
This
Your
is
objections are
mind-boggling.
noted.
This is
It's
mind-boggling.
overruled.
Mind-boggling.
Actually, Your Honor, I changed my mind. I would like to play the audio, please.
Sustained.
This is mind-boggling.
So we will play the entire video, Your Honor.
He's just setting the foundation.
It's relevant. You question
I
this
question him
detective
about
about his knowledge.
the steel frame from the video. The video wasn't even in the exhibits that I received. I actually didn't even receive them. They
Mr.
were
Brooks, please
obtained.
stop. The video's playing.
Dimárcate y... I just got a load worth about a half a ticket. 30 in the blicker when I'm out here chasing chicken. Was observant to the game when I used to play the benches. Now I swipe Da Vinci, got them looking at me different. I can't miss him, yeah. AR with a stitching, yeah. Venom when I kiss him, yeah. Kidnap you and misses, yeah. Work all in the kitchen, damn. Money by the ceiling fan. Shorty wanna take a chance, I'ma need a cash advance. Only fuck with real gritters, and I've been around gorillas ever since a little nigga fucking on my babysitter. Put some prices on a nigga, you know they gon' come and get you. You see how them hollows did him, now he look like Tyson hit him. I was in the slums, any weather, I was still trapping, sliding on the pussy early morning. Bitch, you still lacking. Caught him in the mall, had to tuck it in my heel figure. You know I got steel with him, fully not that little pistol. Heard they putting cameras on the lights, bitch, we still dealing. Give a fuck about the past, nigga, I'ma still kill you. No love for the suckers, listen, put them in the field, we bliss them. Shoot out all the ammunition, they move like some caterpillars. Post this on your social feed, addies that extend release. Two cent boy, your talk is cheap, I won't stop till you deceased. Coming out your face, you bleed. Carbons, we gon' sweep the scene. Sensors, we gon' find the heat. Take you out the movie screen. Got another low, how we playing with them digits. Weighing up them bowls, hella coke around the digi. Playing with them bloods, they gon' pop you like a skillet. Nigga, I'm a menace, and that's word to Mr. Wilson.
I hate that song. Why am I singing it? To be blunt, which I've been since the beginning of this trial, obviously, I see the whole strategy here by the prosecution. I see right through it. Don't have any cross-examination, mainly because you've already schooled the people getting on the stand on how to answer certain things.
Well, that is completely speculative on your part without
It's
any
obvious.
basis in law or fact.
It's obvious.
Sir, you said you wanted to raise a legal issue. What's the legal issue?
The legal issue is how is the state allowed to coach the
You're
people getting on the
assuming they
stand?
spoke to them and coached them.
It's obvious. I'm not stupid.
Well, I disagree with that, sir. Again, you could ask
All of a
questions to
sudden,
lay a foundation
all of a sudden the
with
state
these
don't got,
witnesses.
all of a sudden, for the first time in trial, all of a sudden now they don't got no cross. That's clearly a rush to try to get through the case. Hurry up. We just gonna let these people go.
Well, this is
And not-
argument.
Come on, man.
This is argument on your part,
I
sir.
see
It
through
is
it.
pure
I just
commentary
want
at this
that on
point.
the record. I see through it. I find that
All right,
very.
I'm having the jury brought
man.
out. I'm instructing you to
Come on,
avoid
man.
the commentary when the jury comes
Nah,
out, or you will
I didn't
forfeit
say-
your right to be
I didn't say
present.
nothing.
Before we do that, there's an issue that we do need to take up. So as long as the jury's out, we should probably discuss that. I would like to provide the defendant and the court with a copy.
So that had
of
to be
the-
said. So it's the defendant.
That's not how it was said. I
That was how I
completely
said. You want to
disagree.
run the record back?
Mr. Brooks.
So I'm the only one. I got one. I
Mr.
got one
Brooks.
ear that work, and I heard that.
This
Come on,
is
man.
to benefit
Come on, man.
you so
No,
that
it's
you
not.
understand
Ain't none of
your
this to benefit
witness
me, so let's be
has
clear
a
about
prior
that.
record.
Your Honor, when I leave the table, I'm away from the courtroom and I have to elevate my voice.
So can
Your
you
Honor,
tell,
I
can you
believe he
explain-
has 7 prior convictions via OWI second from 2006.
All right, I need to take a break. This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared. And we're taking a break.
The fact of the matter is, just like I did with my opening statements, I don't have a well-prepared or rehearsed speech. I didn't look in the mirror and say certain points to myself over and over again to make sure I have them right or anything like that. I've chosen to speak from the heart. And now I'm going to speak from the heart. What you won't hear me do is argue facts. Trying to argue facts of this, facts of that. I'm not going to waste your time doing that. It's a little emotional. I apologize for the long pause. What you've been hearing from the prosecution, and not to take anything away from them, but let's call it what it is. You've been hearing a lot of rerun. Same things over and over and over. No different than when you turn on the radio and you first hear that song that you don't like when you first hear it.
but they play it so much that eventually you start saying it, the words to yourself before you even realize it. And then you sit and you go, I hate that song. Why am I singing it? That's what's been happening. Rerun over and over and over and over and over and over and over. Attempting to make things stick in your head that simply aren't true. It's a lot of information that you guys should be privy to, I believe. And one thing that I believe that you have not been privy to is the truth of your rights and your duties. The fact that you and you alone have the power, not well-prepared DAs with well-prepared and clearly rehearsed speeches and exhibits and a lot of theatrics. Frankly, not the judge. You and you alone have the power. You and you alone decide what is truth and what isn't truth. You should be informed that you have the power to nullify any law that you don't agree with. Remember the power that you have. Don't for 1 second let it be taken away from you. I can never understand the position of sitting on the jury in something of this magnitude. So I'm sure there's a lot of pressure. I pray that the right decision is made. The right decision. Do what's right. Don't let the smoke and mirrors take away your power. Don't let the theatrics take away your power. Each and every one of you has a decision. Do what's right. Make the right decision. That's the magnitude of the power that you have. Just like this tissue is in my hand, this is everything. You have everything. Be at peace with what you decide. Have no regrets. Don't let this decision weigh on you after it's over. And again, I say the same thing that I said earlier. Same thing I said in opening statements. I'm not reading from any paper, any books. Everything you've heard in opening statements, everything you're hearing now is from right here. Everything. You have the decision. You and you alone. All of you. You have the decision. I know it's probably not proper, but you guys deserve a round of applause if you could get one. Thank you guys sincerely. And I know, and I have faith and I trust that you guys know what's right. Ladies and gentlemen, I don't think it's fair to just say guys, but I believe in your heart you know what's right. Thank you.
Madam Clerk, might I please get verification that the audio and video are working in the neighboring courtroom? All right, thank you. I do have verification. There are headphones on the table in front of Mr. Brooks should he choose to wear them. I see he's reading from a book at the moment. I do need to make a record that this morning, although Mr. Brooks was not raising his voice, there were repeated interruptions. I gave Mr. Brooks multiple opportunities to stop talking. I asked him repeatedly to stop interrupting me. I advised him that if he continued, he would forfeit his right to be present in this courtroom and would be taken to the neighboring courtroom. I believe I gave that warning at least twice. It's my hope that we can continue with Mr. Brooks in this courtroom. At some point today, I'll certainly invite him back over when I get through these advisements. I'm not asking for a response yet, Mr. Brooks. What I'm asking you for is whether you have any requests for jury instructions, or if in your review you think anything needs to be changed, deleted, added, etc. Do you have any requests as it relates to the jury instructions, sir? I would note he put two boxes right in front of where he's seated, so I can't presently see his face. He is unmuted. I've confirmed previously regarding the audio working, and I will just ask him a second time, sir, do you have any requests as it relates to the draft packet of jury instructions, whether that be any additions, corrections, edits, or deletions?
And Your Honor, would it be possible for the bailiffs to just move the boxes off the table so
Yes,
we
I
can
think
see?
that's fair. I'm going to advise the bailiff to remove the box so I can see Mr. Brooks. I don't know what he's doing behind there.
Hey, why do you tell them to move my box?
Because I couldn't see you, sir.
Or what?
I've asked you twice now, and I'll ask you a third time. Do you have any requests as it relates to the jury instructions? Any additions, deletions, edits, or otherwise?
Hey, man, you don't got to talk to me like that.
Do you have any requests
First of all,
related
what?
to the jury instructions, sir?
Yeah, I got requests. It ain't like they gonna be honored though.
As it relates to the jury instructions, sir, what are your...
I heard what the hell you said, man.
Well, Mr. Brooks, that was very disrespectful.
Yeah, and I've been getting disrespected since the beginning of this whole process. So welcome to the club.
Mr. Brooks, do you have any requests as it relates to the jury instructions? Sir, I understand you may be upset, and I really do,
No, you
but
don't
I've made my
understand
determinations.
nothing. You don't understand nothing. You don't understand anything, Your Honor. You don't.
I'm going to mute him again because he's not answering the questions that I'm very clearly asking him, and I've given him 5 opportunities. Mr. Brooks, do you have any requests as it relates to the jury instructions? I'll unmute you for that answer.
I can't hear everything you're saying.
Mr. Brooks, do you have any requests as it relates to the jury instructions?
I can hear what you're saying. I can hear what you're saying.
You just told me you didn't. So which one is
Yeah,
it?
I got the headphones on. You can't see that?
What are your requests as it relates? What are your requests as it relates to the jury instructions, sir?
Man, don't try to come with this whole little sir. Now it's all this sir and all this. Trying to put on this little act like you so worried about what's going on with me. You don't give a damn. Never did.
Mr. Brooks, you're being disrespectful again.
You've been being disrespectful. You've been being disrespectful.
Mr. Brooks, do you have any position on the verbiage of jury instructions 70 on page 65?
Don't ask me no question. Are you my accuser? Are you my accuser, Your Honor?
All right, he's choosing not to answer, so I'll mute him again. It's unfortunate that he's deciding not to participate in this. I agree with the state. I don't need to highlight that second paragraph. I will take that out, but I will include in the paragraph that reads, at times, Mr. Brooks has appeared from another courtroom, period. This must not influence your verdict in any manner. Mr. Brooks, do you have any position on that? Which is, so jury instruction 70 has to do with the defendant proceeding pro se. I need the bailiffs to move the boxes away from his face. I need to be able to see him. He can keep them on the table, but they need to be moved off to the side. And if he does it one more time, then I will instruct the bailiffs to take the boxes away. Those are trial prep materials. If there's something in those materials related to jury instructions, he should take those out now. Mr. Brooks, one final time, do you have any requests as it relates to the jury instructions? Otherwise, I'm going to approve them. I'm going to take a break, and then we'll come back in the afternoon to go over verdict forms.
I didn't answer yes or no, so how do you consent to anything without me answering the question?
Are you going to answer the question, sir?
But you can't force me to do it, though. You can't just say, I'm going to do this. Because
sir, but you also can't stall the proceedings by failing to answer.
I didn't try to stall the proceedings. You the one that held me in contempt.
I never held you in contempt. All right, I'm going to mute him once again because he refuses to answer a very simple question about whether he has any requests as it relates to the jury instructions. I will work on making all the changes with Madam Clerk, finalizing the order. So we'll come back at 1 o'clock to finalize the verdicts. All right, sir, I'm going to let you make an offer of proof as to why you believe the photographs and the questioning about contact after the alleged incident is relevant.
It's relevant because these were sent by the witness.
It assumes a fact, not an evidence, but
You
what
want
is,
the letter
hold on. Tell me the basis you believe there's been communication and why you believe it's relevant to her testimony.
It's relevant because it was testified to by what's the last guy, Guth, that he was told that the witness was supposed to be so deeply afraid of me and all this type of stuff. So if you're so deeply afraid and worried about somebody and this and that, why would you sneak and have
Do you want
contact?
to open up the door to the other act's evidence of
That's
you
not
use-
opening.
No.
That's not
Hear me
opening
out.
the door.
Sometimes in a court of law, when there are pretrial rulings, the testimony of a witness needs to be said in such a way not to run afoul of that. But if you keep questioning her about whether she's afraid or not, or
I
why she
didn't
wouldn't
question
have
her about that.
contact or
I
not,
didn't
you are
question her about
opening
that.
the door to that testimony. All of
How
my
do- how
rulings
does-
have
how
been
does-
made to prevent what
does
could be
pictures
seen
work?
as prejudicial evidence. The standard's not prejudicial. The standard's whether it's unfairly prejudicial.
It's
But you
unfairly
can
prejudicial.
open the door
Your
to
Honor,
that,
It's
sir.
unfairly prejudicial that I have a document stating that November 20th never even happened, but yet and still the witness
Then
can
have
get on
you
the
turned
stand
that
and lie on the
document
stand.
over to the state?
Come on, man. Y'all know that's not right. Y'all know that's not right.
Then you need to immediately turn it over to the state right now. It may become relevant, but no one has seen it. When
So-
did you receive the
so that's- so
document?
what-
So hold on. I'm having you make an offer. When did you receive the
Okay,
document?
but that I just want to state for the record, Your Honor, that's it's not
All right.
fair. It's not fair. Your Honor.
When did you receive this document that you claim was sent by this witness?
It's not claim. It's for a fact.
Sir, it hasn't been established yet. I need to make a record.
So do y'all want
I
the
want
letter?
to see
Y'all want
the letter.
envelope? What?
I want to see the letter.
Okay, so I got.
And I wanna know when you received it.
I gotta bring that in. Come on, man.
Mr. Brooks.
Come on, man. Stop.
When you
Stop
aren't
Stop
even
it.
letting
You're a
me
public
ask the
servant, Your Honor.
questions.
I respect your courtroom. I
You
respect
do.
you. You're a public servant, though. Your job is to be the referee. Is it or is it not? You stated so yourself on record that your job is being the umpire.
So I'm going to make a record about what
This
he's
is
referring
ridiculous,
to in
man.
count 77. Okay. The
And what happened to that paper? Because it was on the table. Then when I
Mr.
come
Brooks,
back in,
I
it's
need to
nowhere
make
be
a
found.
record of a variety of
So who
things.
took my paper?
And you keep interrupting me. You attempt to divert everyone from what is being done this very second.
I didn't attempt to do anything.
Yes, you do it repeatedly, sir.
Whatever.
So you're doing it once again.
Whatever. Just make your record. What does the letter read?
You have the letter. You showed it to me, sir.
I tried. Yeah, and I've been trying to find it ever since I came back in here. And now all of a sudden I can't.
And now
find
you're impugning, though, like somehow you're impugning the integrity of this court,
No,
of
I'm
the
not.
bailiffs of this state. You're accusing, frankly, everyone
Did I
of
point
moving
the
your
finger?
papers.
Did I point the finger at anyone? Did I say anyone did anything?
Not directly, but indirectly you did,
So
sir.
how can you make the assumption
made-
that I'm saying?
Can
that
I
I'm
please
pointing to
make the
someone?
record without
Yes,
you interrupting
yes, you may.
me?
Yes, you may. I apologize.
I appreciate that. Thank you. But you made repeated comments, sir. And if I need to, I'll have a bailiff put on the record that no one touched your table.
Your Honor, did I say anyone touched my table? I didn't. I
You
didn't say you.
implied it, sir.
But did I say that? I can see if I came in and said, "Hey, one of you moved something off my table," then it would be more of a validity to what you're saying.
I need to continue with the record, sir. It's very apparent to me, sir, that every time throughout this trial, and especially the last 2 days, when the court makes a ruling that you disagree with, that you start peppering me with questions. You question me about the law. You ask, is it verified law? It is, from my perspective, a clear attempt to kind of turn us in a direction away from what we're doing.
I'm sorry
That's
you
my
feel that way.
that I'm making a rule. You're doing it again.
I mean, because it has no validity.
So, I am trying to make a record about a line of questioning you want to ask Ms. Patterson. Now we have you claiming that there's some document that was sent by the witness after the charges were filed that apparently contained photographs. that you believe goes to the credibility of this witness. So I need to ask a few questions about that, sir, to determine whether it has relevance to those issues. Number one, when did you receive this letter?
I received this multiple letters, actually, over a period of time. It wasn't, I referred to this one because this one had the pictures.
Does it have a date on it, the letter?
No, I didn't bring the letter, I brought the pictures. The witness knows that they sent me the pictures. They know that.
Well, again, it assumes facts that aren't here. You're assuming this witness sent it. I don't know. But even if she did, what relevance does it have to her credibility before this jury?
It goes to the credibility because she's put on this facade of being so afraid of someone, but yet still, you know that we're not supposed to have contact, but you still sneaking behind and saying, oh, I wonder how you're doing, and oh, this and this and that. Oh,
I don't think she's ever said she was afraid. I think that was the officers who may have stated that. So again, I'm going to ask you, even if this letter's from her, these pictures are from her, how does it relate to her credibility before the jury?
Who else could these pictures be from?
I'm going to ask you point blank. Did you get a letter that's signed from her?
I got. What do you mean signed? No
How do you
signs
know?
letters.
What's your why do you have a belief that they are from her?
I have multiple letters from her.
You're not answering my question. Why do you believe the letters are from Erica Patterson?
Because they were sent from Erica Patterson. Why else would I?
Were they signed by her?
What do you mean signed?
Did she write her name on the letter? Was it the content of the letter? No, I'm not kidding you. I need to make a record, sir. You're making a statement that these letters are from her and that they're relevant to her credibility.
Your Honor, I'm going to go out on a limb here.
And I'm asking you why you hold that opinion.
I'm going to go out on a limb here and assume, which I know is true, you've never been in my position. You've never been in jail. So you've never received a letter from someone writing someone in jail. No one is going to... When you
You're
say
not
to
answering my
me, when
question,
you say to
sir.
me,
What's the basis why you believe they're from Miss Patterson? Is there some information in them that only she would know? Did she sign the letters? Is it penmanship that you recognize? Why do you believe they're from her as opposed to somebody else sending you information? Could be your mom, could be, I'm just saying, could be anybody else. You got to answer my question. It's called an offer of proof.
But you still got to understand why this is mind-boggling to me. Like, how I got a child with this woman. Why would I not know her handwriting?
But you have to lay a foundation for these letters, sir. That might be through your own testimony. So that I'm trying to figure out why you believe they're from her. Not all this other stuff about I'm in jail and I have a child. I'm trying to I need to know. It's called an offer of proof.
Are you serious?
What do you believe? Why do you believe they're from her? I am serious.
Because they're from her.
But you're assuming.
Like, how else am I supposed to answer that?
I've given you a few reasons why it would lend to that opinion.
So it has to be put in a legal term.
The bottom line is I need the letter. So if you're going to question her on that, the state absolutely has a right to see the letter.
So
the state has the ability to question you about that, or question this witness, and to look at the veracity of what your claims are here. So I may take an early lunch. If that's in your cell, then you can go get it and bring it. But without that letter, I'm not allowing this line of questioning. Do you have the letter with you in court?
I just said no. How many times I got to say the same thing on record?
You know, sometimes, sir, I don't hear what you say because you interrupt me so much or you answer quietly. And I'm taking notes and I'm focused on probably a dozen things at the same time.
But if I say something under my breath, everybody seems to hear it. Everybody seems to hear that just fine.
In a quiet courtroom, yes, we can hear it very clearly.
Everybody assumes that it has to be disparaging.
Once again, you're doing this tactic.
Because
it's
not a tactic, it's facts.
What we're talking
it's
about
facts.
To some other reason.
It's facts. Because I find it hard to believe that all of a sudden nobody hears what I say.
I'm going to let the state make a record of why they believe it's objectionable, because I haven't let them do that. I've given you multiple opportunities to tell me why you believe it's...
I didn't get these pictures from nobody else. Why was somebody else...
The record will reflect you have 2 pictures that you believe were from this witness.
That I know is from him.
No, that you believe.
That I know.
All right, I'll ask the state their position on all of this.
My position, Your Honor, is that these pictures, first of all, should not be admissible. One, because of a discovery violation. We've never seen them before. Two, because we have reason to believe that he did not get them from Erica Patterson. He is on a jail phone call talking to his mother, Dawn Woods, about Dawn Woods sending these photographs to him. Now,
That's a lie. I object to
Let
that.
the state make their argument without interruption, sir.
That's a lie, though.
three, I believe that these photographs are designed to make a suggestion to the jury that Erica Patterson is a bad mom. I think that is what the defendant is trying to do. And if we're going to go down that road, then we would be forced to counter that claim. First of all, it doesn't make her an incredible witness, if it's even true. And second of all, if we go down that road, we would be forced to counter that claim by pointing out that not only does the defendant not live with the child in question, he doesn't live with any of the other children that he has. He impregnated Erica Patterson when she was a minor in Nevada, and for doing so, he was convicted of statutory sexual seduction, pled guilty in March of 2007 to that felony offense, and is a sex offender on the registry as a result. So if there's any causation that would lead to Erica Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
And that's
Furthermore,
I object to that.
I'm not
because
done.
that's a lie.
Let
Because
him
at the end
finish.
of the day,
Let
if
him
we
finish,
gonna open the door
Mr.
on that, no,
Brooks.
since he want to make a record and not be accurate, so let's be accurate all on the record. Since you think you know so much,
Once
so
again,
we can
Mr.
open the
Brooks
door
is
on.
being
We can
loud,
open the door on how old she told me she was when we met.
interrupting.
We can ask that question
He is
too. Then
over the
Did you
top,
ask that?
animated
Did you
right
know
now.
that?
Mr. Brooks, I'm ordering you to sit down and to let the state
No,
finish.
no, I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
Right. Under Illinois versus Allen, I've warned him repeatedly. He's being removed from the courtroom. And you know what? Let me dial that back. We're just going to take an early lunch, 1 hour. We'll be back. And unless he brings that letter, and he can show it is inadmissible, she will not be questioned. And under 906.11, I will declare the cross-examination closed. Thank you. We're in recess. 1 hour.
Get your facts straight. So let's open the door on all of it then, so we can get all of it on the record. Since you think you know so much. Did you know she said she was 18 when I met her? Did you know that?
I don't think there's anything else I need to cover at this time, unless there's something from either one of the parties. From the state first.
No, but we would like some further direction from the defendant as to who he wants here tomorrow morning and tomorrow afternoon, if he wants us just to continue that list that he originally provided, or if there's an update. And we can do that off the record, Your Honor. I don't know that we need you involved.
Okay. Thank you. Then hopefully the parties can figure that out without me needing to be involved further. But anything from you, sir?
No, I'm just gonna say with that, I'm not gonna put them in specific order.
Not looking for the order, but we're behind given the timetable and the understanding between, as I understand it, between you and the state. So,
State has the list.
well, based on the groupings that you gave to the state, it sounds like we got through only one from each kind of category. So we'll go back to the first would have been Thursday morning. You need to call the rest of Thursday morning. Was there two left of that?
Yes, correct.
So
let's do Thursday morning and Thursday afternoon. The people you designated, I'm going to direct the state to have here tomorrow morning. That's 4 witnesses, whatever order of those 4. And then how many does that leave? Because
that's what I'm trying to
doing good with math this late in the day. 4, so 4 in the afternoon then. So our hope is to get through all your witnesses.
I can say this
tomorrow
for the record. One witness I intend to call tomorrow is not going to be 35 minutes.
Fair enough. Do you plan to call that person in the morning or the afternoon?
I'm leaning towards the afternoon. If the morning goes pretty.
Can you tell me which list they were on when you gave it to the state? Was it Thursday afternoon, Friday morning, or Friday afternoon?
I didn't put them on days, but I believe they were in maybe the second floor names. If
You just want to tell me who it is so we can prepare, so that person is told to come in the afternoon rather than wait through the morning?
I don't want to say who it is.
Well, I want the person to be here when we're ready to go, but
They were here today, if that helps.
Yeah, I know who it is. It's Erica Patterson, Your Honor. There's no
Maybe.
mystery here.
Maybe
All right,
it is,
that's
maybe
what I
it isn't.
would have. That's kind of who I thought it would be as well.
So,
I'm going to have her come tomorrow afternoon. Then. I'm
okay,
not
we
gonna
will
her
have
come
you
in the
here at
morning.
1 o'clock tomorrow afternoon.
So
Your Honor.
we
Thank
need to be
you.
mindful of people's schedules.
Thank you. We'll have everyone else here at
That's
8:30.
interesting because what if that was not who I was referring to?
Then you need to tell me right now so I can make an alteration to that.
Come on, Judge.
Sir, we're at the end of the 3rd week of trial.
So
I
can we
need
at
to
least
keep
be
this
fair?
moving
Can we
along.
at least be fair and say that's not due to me though?
That would not be fair to say.
How?
It's
how? The state said that they needed 5 to 7 business days to present their case. Did they or did they not say that on the record?
And there's,
So
it
how did
doesn't
I-
matter how we got there at this point. I'm trying
Then they
my
need to chop,
darndest
chop.
to get all the
Should've been
witnesses
chop, chop.
done. So I'm directing the state to have Miss Patterson come tomorrow afternoon.
If that's
And the
what I was
other
referring to,
witnesses?
which I wasn't, but everybody think they know what I'm thinking.
Then you need to tell them if it's someone else, and if you want her here in the morning.
I'll
then
say
that-
this. Everybody that was here today that didn't get called, have them here tomorrow. So that'd be 1, 2, 3, 4, 5 people.
And you need to tell me who you want in the morning, not by the order, and who you want for the afternoon. Otherwise, I'm going to make the order that I just made.
No, how you gonna make the order for me?
Under 906.11, sir.
No, you can't. I can call. I have the right to call them in the order that the state didn't have to have an order. And I'm guessing.
No, but the
correct me
state's
if I'm wrong, but
helping
I'm-
you out in terms of the order,
They were helping me out with serving
and
the
they're helping you.
subpoenas. Not the
So,
order of how I would call the witnesses, but the subpoenas. And I gave the state.
do you want to be responsible for calling each person tonight and telling them what time they need to be here, or should we let the
See,
state
here we
do
go
that?
with this again. There's something that's impossible to do.
That's not true. You have
How's it
access
not
to
true?
a phone.
So somebody's gonna answer a collect call from someone they don't even know. Nobody in this courtroom will answer a collect call and pay for a phone call from
not
somebody
my
that you
understanding
not know.
of how it works at the jail. That you can.
Yes.
There's other means to make phone
there
calls.
there is no other way to utilize the phone.
Well, maybe I'm wrong on that, but be that as it may, the state is helping you out. This is to make tomorrow go as smoothly as possible, to be effective, and to use all of our time wisely.
Your Honor, with all respect, I did what was asked of me to do. I provided them with the list of the witnesses that I would call. And I stated before that I would not put them in order, and the state accepted the list that I gave them. So why, at this point, is
Who are
everything
the witnesses who are here
being
today?
a problem?
Kohler, Douglas Kohler, Detective Guth, Erica Patterson, Christopher Bertram, and Jason Hayes were here today, in addition to Miss Reimer. Miss Reimer's now done. Nicholas Kirby was also here today. He's done. If we are going to continue to assist Mr. Brooks in getting these witnesses here, we need to have a reasonable time schedule. These witnesses don't just show up by the tooth fairy. We have to communicate with them. They have jobs, they have families. I've explained this 3 times to Mr. Brooks. If he wants our assistance,
Objection. She can chill with all
He
that. She can
needs
chill with all that
to-
tone.
hold on, hold on. I know
Get
we-
on that if that's what it is.
Hey, I
We
know
can
it's been a
definitely
long
get on
day.
that.
Let's keep this civil.
That's what I'm trying to do, but
So
she gonna have to tone it down.
I think both of the parties are getting a little
For real.
frustrated. I'm getting frustrated. So, I'm
don't
Kohler,
even know who they be
Guth,
like.
Hayes, Patterson. I missed a 5th.
Bertram.
Guth is a police officer, right?
Yes.
I know who Eric Patterson is. How about Kohler, Hayes, and Bertram? Are those citizens?
They're citizens that relate to the parade, I believe, and post-parade, not the DV.
It seems to me that even with one of the witnesses taking more than 35 minutes, that doesn't fill up the whole day. So we need to have some other people on that list for the afternoon.
So I will just continue to work in the order of the list that was provided, Your Honor. I think that's the only reasonable thing we can do at this point, or we can do it alphabetical, or we can do it by random lot, because I don't know really what else to do.
By the list that was given.
What was the order of the list that you were given?
The first 3 were Kirby, Kohler, and Guth. The next line has 3 names: Patterson, Bertram, Hayes. The third line has 3 names: Reimer, Aldrich, and Lescano. The last list has 2 names and then also reads the state of Wisconsin.
First 3 people on the list you need to advise to be here tomorrow at 8:30.
Okay.
The next 2 people tomorrow at 10:30. The next 2 people after that tomorrow at 1:30. And the next 2 people from there at 3:30. And then do I have anyone left over from there?
No.
If I have to go late tomorrow, then I would say the last person can be at 4:30 if need be.
Yeah, I agree. We would very much like to get through the defense witnesses tomorrow, Your Honor.
I don't know if that's going to happen.
Well, that's the order that I'm making in terms of the times people need to show up. That gives you a range of people to select from.
I'm going to have to see that, what you're referring to then, because...
Oh, I trust you wrote it down because that's what I did.
I
so
didn't.
We are at recess then for the evening. We'll see everyone tomorrow at 8:30 a.m.
So if they don't get called like that, don't try to blame it on me. To be blunt, which I've been since the beginning of this trial, obviously, I see the whole strategy here by the prosecution. I see right through it. Don't have any cross-examination, mainly because you've already schooled the people getting on the stand on how to answer certain things.
Well, that is completely speculative on your part without any basis in law or fact.
It's obvious.
Sir, you said you wanted to raise a legal issue. What's the legal issue?
The legal issue is how is the state allowed to coach the people?
You're assuming they
stand?
spoke to them and coached them.
It's obvious. I'm not stupid.
Well, I disagree with that, sir. Again, you could ask questions to lay a foundation
all of a sudden, the state
with these
don't got,
witnesses.
all of a sudden, for the first time in trial, all of a sudden now they don't got no cross. That's clearly a rush to try to get through the case. Hurry up. We just gonna let these people go.
Well, this is argument.
Come on, man.
This is argument on your part, sir. It is pure commentary
I just want
at this
that on
point.
the record. I see through it. I find that
All right,
very.
I'm having the jury brought out. I'm instructing you to avoid the commentary when the jury comes out, or you will forfeit your right to be present.
Before we do that, there's an issue that we do need to take up. So as long as the jury's out, we should probably discuss that. I would like to provide the defendant and the court with a copy.
So that had to be said. So it's the defendant.
That's not how it was said.
That was how I said. You want to run the record back?
Mr. Brooks.
So I'm the only one. I got one. I got one ear that work, and I heard that.
This is to benefit you, so that you understand your witness has a prior record.
Your Honor, when I leave the table, I'm away from the courtroom, and I have to elevate my voice.
So can
Your
you
Honor, I
can you
believe he
please-
has 7 prior convictions via OWI second from 2006.
All right, I need to take a break. This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared. And we're taking a break.
Mr. Brooks, the live stream is on.
I don't care about no live stream. Just like y'all don't care. All this political. This is a show. Y'all getting told what to do.
Mr.
Y'all
Brooks.
getting paid what to do.
Mr. Brooks, look at me for a minute. Mr. Brooks. Mr. Brooks,
You
look
sit
at
here and act like you know me. People like you don't. Y'all
Mr.
you don't
Brooks.
know nothing about where I come from.
Mr. Brooks.
You push me, dog. Don't push back then.
Mr. Brooks.
Don't push back. Push me again.
Mr. Brooks, we have to continue with this hearing.
I want to talk to the judge or not. I'm not worried about, man. Don't put your hand on me, dude.
Nobody put their hands on you.
Yeah, they better not put their hand on me.
Okay, Mr. Brooks, you need to look at me for a minute, okay?
Why? To listen to all this political stuff y'all got going on?
Mr. Brooks, I'm more concerned about...
Don't touch me, dog. Stay seated.
All right, we're going to take a break and we're going to come back after lunch. I'm not going to do this with him right now. He needs to be here. He's not cooperating. I'm going to give you the warning, Mr. I will give you the warning that if you continue to interrupt when we go back on the record, you will forfeit your right to be in the courtroom today. I can't have these interruptions. I want you here. It's been a long day and a half.
Keep your hands off me.
We'll come back at 12:30.
I just told you to get off me.
$12:30, everyone.
No, it seems like there's something going on that you clearly... Dad, what? Turn it up.
To be blunt, which I've been since the beginning of this trial, obviously.
And that's funny. That is. Yeah.
I see the whole strategy here by the prosecution. I see right through it.
I wish I knew how to quit you.
Don't have any cross-examination, mainly because you've already schooled the people getting on the stand on how to answer certain things.
Well, that is completely speculative on your part without
It's
any
obvious.
basis in law or fact.
It's obvious. I didn't interrupt you. I let you make your incorrect record.
You snotty little bastard.
Sir, you said you wanted to raise a legal issue. What's the legal issue?
The legal issue is how is the state allowed to coach the
You're
people getting on the
assuming they
stand?
spoke to them and coached them.
It's obvious.
Go back to jail.
I'm not stupid.
No, you're actually the dumb.
Well, I disagree with that, sir. Again, you could ask questions to lay a foundation
All of a sudden, the
with
state
these
don't
witnesses.
got. All of a sudden, for the first time in trial, all of a sudden now they don't got no cross. That's clearly a rush to try to get through the case. Hurry up. We just gonna let these people go.
Well, this is argument.
What we've got here is failure to communicate.
When the jury comes out, you will forfeit your right to be present.
Before we do that, there's an issue that we do need to take up. So as long as the jury's out, we should probably discuss that. I would like to provide the defendant and the court with a copy.
So that had to be said. So it's the defendant.
That's not how it was said.
That was how it said. You want to run the record back?
Mr. Brooks.
So I'm the only one. I got one. I got one ear that work, and I heard that.
This is to benefit you so that you understand
Ain't none of
your
this to benefit me,
witness
so let's
has
be
a
clear about
prior
that.
record.
Your Honor, when I leave the table, I'm away from the courtroom, and I have to elevate my voice.
So can
Your
you
Honor,
tell,
I
can
believe
you
he has 7 prior convictions via OWI second from 2006.
All right, I need to take a break. This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared. We're taking a break.
Very disappointing. Just a complete failure.
here today?
Objection, relevance.
Let's let Mr. Brooks get the question out. Go ahead.
Apologize, I thought that was it.
Are you testifying today strictly to prove your case to the jury?
Objection, misstatement of his testimony.
Grounds that that's what he said.
Sustained as to the form of the question, misstates the prior testimony.
That's what he said. So why did you decide to testify here today?
Objection, that's a legally inaccurate question, Your Honor.
Please rephrase the question. I'm sustaining the question asked as to the form of the question.
I don't know how I'm supposed to rephrase that. Without having the same form of the question. That helps.
I'll rule if there's an objection, but ask a question, please.
Did you seek to testify here today in this matter?
No.
So how did you ultimately come to that decision?
Objection, that's a misstatement, Your Honor. It was not his decision.
Sustained as to the form of the question assumes a fact, not an evidence.
Were you subpoenaed?
Yes.
Do you recall by whom you were subpoenaed to testify?
District Attorney Sue Opper from the Washington County District Attorney's Office.
And at that time you were subpoenaed, you decided to testify?
I don't believe it's my decision.
Well, it would be fair to say that you didn't have to show up, right? That'd be fair to say?
No, I had to show up.
But would it be fair to say that you could have chosen not to?
No, it would not be fair to say that.
Exhibit 131 that was shown to you. Have you seen that video footage before today?
Yes, I have.
Do you recall who showed it to you before today?
I don't recall who showed it to me.
Would it be fair to say you've seen it multiple times before today?
Yes, I've seen it a number of times.
And do you recall when you were first shown that video?
Not off the top of my head.
Was it the same day of the incident, the days following, sometime after?
I don't recall when I saw the video the first time.
And what about Exhibit 130? Had you seen that video footage before today?
Objection, Your Honor. 130 is the map.
Or the map? Had you seen the map before today? I don't really think it.
Just for the record, I'll sustain the objection just because it referenced the wrong number, but I believe you rephrased. So go ahead, the witness may answer.
Can I ask the question again, please?
Had you seen the map of Exhibit 130 before today?
Yes, I have.
Multiple times as well?
Yes, numerous times.
Any idea why you viewed it so many times, multiple times?
Unsure.
Were you able to obtain any more information upon seeing the map numerous times that you didn't obtain when first seeing the map?
No.
So it would be fair to say you pretty much knew what the map was detailing each and every time you saw it?
Yes.
And on that map, Exhibit 130, you made reference to at some point the dotted line, and it stops at some point. That'd be fair to say?
Could you be more specific?
The dotted line that was referred to on the map.
Do you want the map brought up? Would that be helpful to you?
Or maybe it might be helpful to him.
He's got the large map, but if you want to...
So, if you can see the dotted line on the map behind you.
Yes.
Is it fair to say that the dotted line stops at some point? Around Central Avenue, maybe?
Yes, there's a couple lines that seem to come to Central Avenue or egress out of Central Avenue that do stop.
And you stated that, well, what was the reason that you stated that that line stops, the dotted line?
I stated that It's because we don't know the exact location where you crossed the street to get over to Elizabeth Street.
And were there no cameras present at that point, or how did you lose the path of travel at that point?
We didn't find any cameras or any eyewitnesses in that area.
So it would be fair to say at that point you weren't sure what happened.
I know that you crossed the street at some point. We just don't know where.
How do you know that?
Because you were arrested on Elizabeth Street.
Did you see any crossing of, I think you said that was West? Would that be West Avenue that you were referring to, that you don't see any crossing of?
What's your question?
Is that West Avenue that you stated that you didn't see any crossing of?
That is Northwest Avenue.
Or Northwest Avenue, I'm sorry, I don't know the streets. Northwest Avenue. And you don't have any visual footage or any eyewitnesses, as you said, to say for sure if Northwest Avenue was crossed?
We didn't obtain any witness statements or any eyewitness or any video of the suspect crossing the street.
And what day were you doing your part of the investigation? Was that the same evening or the next few days after the incident, or?
Can you clarify which investigation you're talking about?
The one that you took part in. Your part of the investigation.
I don't understand what time frame you're asking for.
What day did you start your part of the investigation?
Well, we started the investigation as soon as he ran people over in the parade.
And you were there?
I responded to the parade after he had done that.
Were you at the parade?
No, I was not.
So it'd be fair to say you were on call?
No, I was not.
So it'd be fair to say you don't know when your part of the investigation started then, right?
It would not be fair to say that.
You don't recall what time it was when you started your part of the investigation?
As soon as I responded.
And you don't recall when you were dispatched to respond?
It's in my report. I don't remember the time exactly, but it's in my report.
And at that time, did you know the identity or name of any alleged suspects at that time that you were dispatched?
The time that I was sent to the city of Waukesha, I did not know the identity of the suspect.
You made reference to a report. Do you recall when you wrote that report, or did you write the report yourself?
Yes, I typically type my own reports.
And do you recall when you submitted that report?
I have no idea what day I submitted the report.
So when you were first dispatched, what did you do?
I drove to the city of Waukesha and met with members at the Waukesha Police Command Unit.
And were you dispatched to any location from that point?
I was not dispatched.
Were you sent to any location from that point?
I was assigned with taking a number of investigators with myself and walking the entire parade route, going from establishment to establishment, bar to bar, restaurant to restaurant, and obtaining phone numbers and names of people who were present at the parade and who had witnessed something and would be followed up with later by a member of the Detective Bureau.
So it would be fair to say you did some interviews at that time?
Yes.
Do you recall how many?
No.
And after conducting these interviews, what did you do?
I went home.
So at that time, after conducting your interviews and then going back to your home, did you have the name or ID of any suspects at that time?
Yes.
And whom were you told by?
I don't recall.
Do you recall who you submitted your typed report to?
I don't understand your question.
Do you recall who you submitted your typed police report to?
No.
I'm assuming your law enforcement agency doesn't type up reports and just leave them sitting on the desk. Would that be fair to say?
That'd be correct.
Any reason why you wouldn't recall who you gave your report to?
Well, it's electronically submitted.
And from there, does it have a specific sergeant or lieutenant or captain or someone that it goes to from that point? If you recall, or if you know?
I wouldn't know.
So it'd be fair to say, once you type a report and submit it, you're not sure who sees it?
Correct.
Would you say it's fair that because of you not knowing who your report is submitted to, that your report can be altered in some kind of way? Especially being that you don't know who sees it?
The reports are done via PDF style reporting. It's protected by my username and my password. And when it's submitted, it's usually not altered unless I request it to be altered.
But it is fair to say that there's a possibility that it could be tampered with because you don't know for sure who all sees it.
It's entirely inaccurate.
How so?
My report is accurate. My report is the way that it was written, the way that I wrote it myself.
So you've had a chance to read your submitted report after you submitted it?
Yes.
And to the best of your knowledge, is exactly word for word as you remember typing it?
It is my report. It is what I typed, and it is accurate.
Word for word?
Yes.
Do you recall how many pages long the report was?
Objection, relevance.
Grounds.
Sustained. Not relevant. Please move on.
Do you recall if the report was lengthy?
Objection, relevance.
Grounds.
Sustained. Next question, please.
Grounds for the sustain?
Relevance.
And you stated that you read the report after you submitted it. Do you know how long it was before you were able to see the report that you typed?
Objection, relevance.
Grounds.
Sustained.
Well, he already answered that.
Then I'll object as asked and answered, Your Honor.
Sustained.
That question wasn't answered, but okay. I see. Do you recall when you typed your report?
Objection, relevance.
Grounds.
Sustained. Not relevant.
How's that not relevant if he already answered that he typed a report?
Please continue, sir.
Grounds for the sustain.
Relevant.
He answered that he typed a report. So how's it not relevant if he recalls when he typed it?
Please continue, sir.
Got to be kidding me. Did you file any claim related to this matter?
No.
Do you know if anyone who did?
Did what?
Do you know of anyone who filed a claim in relation to this incident?
No.
Do you know who the plaintiff is in this incident?
Objection,
Grounds.
relevance.
You may answer that question. Go ahead.
Can you ask the question again?
Do you know who the plaintiff is in this incident?
Well, plaintiff would be the state of Wisconsin.
Is the state of Wisconsin a human being or entity?
Objection,
Grounds.
argumentative.
Sustained. On relevance grounds.
Have you ever had any interaction with the plaintiff in this incident?
Objection.
Grounds.
Relevant, legally inaccurate.
Grounds.
Sustained as to the form of the question.
Were you ever contacted by the plaintiff in this incident?
Same objection.
Grounds.
Sustained as to the form of the question.
Would you call the state of Wisconsin a living, breathing human being or
Asked and
entity?
answered.
Grounds, because I didn't ask that question.
It's not relevant. Sustained. Next question.
It's very relevant. Seems like there's no plaintiff.
Jury will disregard statements made by the attorneys and the parties. They are not evidence. Please ask a question.
So to your knowledge, the plaintiff is the state of Wisconsin. Do you see him present in the courtroom today?
Objection, irrelevant.
Sustained.
Can you identify the plaintiff, state of Wisconsin?
Same objection.
Grounds.
Sustained. Sir, please continue and not on this topic. Next question, please.
To the best of your knowledge, you're not even sure if you've ever even had any interaction with the plaintiff, state of Wisconsin, correct?
Objection, argumentative, and compound.
Grounds.
Sustained.
Definitely wasn't compound. Would you consider yourself an injured party in this incident?
Objection.
Grounds.
Argumentative.
The witness may answer.
No.
Have you read or seen the complaint?
No.
No further questions.
All right, thank you, sir. Any redirect?
No, thank you.
All right, thank you, sir. You may step down.
Detective Rowe should be dismissed, please. And yes, could we get the exhibit?
Yeah, why don't you grab that exhibit and take it? That one has the exhibit sticker, correct?
Yes.
All right, we can keep it by the state for now, and then later on it can be brought over to the clerk. All right, the state may call its next witness.
It's going to call Special Ryan Schultz. Other questions, Your Honor?
As to this particular piece of evidence only, Mr. Brooks, you may ask questions of Detective Casey.
Objection, I don't consent to being called that name. And yeah,
Noted. Do you have any questions for the witness?
This, when did this video, when was this made a exhibit? Because I don't have it.
Objection, that's not a question for the witness, Your Honor.
That was a question.
Sustained.
When was this
As to the
video
form
made
of
an
the
exhibit?
question.
When was this video made an exhibit? That is a question.
I object to the question directed at the witness, Your Honor. It's beyond the scope of his knowledge.
Well, he said he saw it.
But that's not the question asked. So you can rephrase your question if you want to.
When did you see this exhibit? When did you see it?
With the understanding that you're asking when did he see the video, I will allow the question to be asked.
When did you see this exhibit?
With that understanding, you may answer, Detective Casey.
Am I answering when I saw the video for the first time?
Yes.
Objection, Your Honor. Why is something always funny at that table? It would be the same thing. I'll take that as disrespect because they were allowed to say something and I said under my breath that was disrespect.
I would direct both parties to avoid commentary.
Okay, well, can you do that, please? And admonish them because I'm always the one getting admonished.
Everyone.
I take that as disrespect too.
Sir, can I do my job? State's directed to avoid laughing, commentary. I didn't see it, so I can't further comment. I was looking at
all these
the
cameras
witness.
in here, don't nobody see
However,
nothing.
I'm advising both parties to show
Come on,
decorum
man, this is not fair.
and restraint, to be respectful of this jury's time and attention, and to let them do their job by focusing on the testimony and exhibits and evidence that's presented. Go ahead, Detective Casey. You can answer the question about when you have seen this video prior to today.
I saw the video within a few days of Mr. Brooks being arrested. I've reviewed it since then a few times. I reviewed it yesterday and again this morning, and now in court again.
You said you reviewed it yesterday and this morning.
If you had seen this video numerous times before yesterday and today, why did you feel the need to view it yesterday and today?
Objection, argumentative.
Grounds.
Sustained as to the form of the question.
Why did you need to review it this morning?
Objection, argumentative.
Overruled, the witness may answer.
Because I wanted to be 100% sure of the content, and if there's any questions that were asked of it, I wanted to make sure that I would be able to answer them appropriately.
And why was this, to your knowledge, why was this video never brought up in your earlier testimony?
Objection, that's a
Grounds.
misstatement, Your Honor.
Sustained as to the form of the question assumes facts not in evidence.
If you had seen it numerous times before today, why did you need to see it again to make sure if any questions were asked, or however you refer to it? What would be the need to view again this morning something that you had viewed numerous times before?
I will see what my
Objection, compound, asked and answered, misstatement of the facts, argumentative.
Sustained.
Did you view the video this morning because you knew that the video would be made an exhibit this morning?
Objection, assumes facts not in evidence.
Sustained as to the form of the question.
This is mind-boggling. This is mind-boggling. Can you clarify again why you viewed the video this morning?
Objection, asked and answered.
Sustained.
So you're gonna sustain everything?
It was already answered, sir. Next question, please.
And I'm asking for clarification.
Next question, please.
I don't got no more questions, man.
All right, thank you.
This is mind-boggling.
Detective, you may step down. I'll excuse the jury.
What you people was trying to do is not fair. Hide things from the jury repeatedly. You don't tell them all the information
Mr.
they
Brooks,
need
I'm
to
going
know.
to take up all of your objections outside the presence of the jury. I'd ask that you honor my decision to do that and you show courtesy and decorum.
Because you asked.
Mr. Brooks, please.
Because you asked. That's the only reason, because you asked. I see what you people are trying to do. It's not right. It's not fair and it's not right.
You can have a seat. Well, once the jury's outside of the courtroom, I'll take up the objections previously in the evidence. All right. First of all, Attorney Hopper, if you can make a record as to this exhibit and whether it's been turned over previously.
It was previously included in the initial discovery that was sent initially to the public defender's office, and now we have a record that those 3 boxes were turned over to Mr. Brooks.
Objection, I don't consent to being called that name, and it was not in the video footage that I have obtained. That video was not part of it. Do you think I would sit here and be this irritated?
Mr. Brooks, I need to make a record, so just please sit down. There's no need for you to stand at the moment.
I feel like standing right now.
Please sit down.
I feel like standing.
All right, based upon the offer of proof provided by the state, and it was provided to prior counsel, that satisfies me as to that issue. I indicated I would.
That's inaccurate, Your Honor. Can we have the prior counsel testify to that then? Because
not at this time, sir.
I have not obtained that. Right now, that was my first time seeing that as an exhibit.
Mr. Brooks, I presume, and you can correct me if I'm wrong, but you're familiar with that video? Yes or no?
What does that have to do with what we're talking
Because
about?
I'm going to make a finding based upon what I viewed in that video, that there is absolutely no surprise to you. It appears to me, even without the video, that that's a music video, that you are in it, that the vehicle that has been the subject of this entire case, that red Ford Escape with the plate that's been testified to, is in that video. That video is relevant for a number of different reasons, the first of which it goes to identification of you, identification of the vehicle. You opened up the door through your cross-exam of Detective Casey about his ability to identify you in that video. And when I say identification of you, specifically as it relates to Detective Casey's opinion that that's you in the video, of course, it's ultimately up to the jury to determine that, and what relevance, if any, evidence have, but you opened up the door for the state to show that video because you directly attacked the credibility of Detective Casey through his knowledge of it and the identification by him of you in it. Because the still image was of your back.
Okay.
So that opened up the door, and it's proper. There's absolutely no surprise to you that that video exists, and that is my finding as it relates to that.
What do you mean by it's no surprise to me that it exists? That was not the issue. The issue was how was it made an exhibit at the last moment? How does it be made an exhibit out of the blue? That was the issue. The issue
State can make an offer of proof on that because obviously they marked it as an exhibit.
But with all respect,
so go
Your
ahead,
Honor, you're
Attorney
mischaracterizing what I said, and the record needs to be clear. The issue that I raised was how does this, at the last minute, out of the blue, become an exhibit? That was the issue.
Go ahead and make your offer of proof on that.
Thank you, Judge. And another thing worth noting is the testimony of Detective Casey that this video was obtained from the defendant's own Facebook account as well. The court is well aware.
He said social media.
Nothing that.
He didn't say what it was.
Sir, stop interrupting. We have to make a record of it. You've interrupted multiple times. I've been abundantly patient with you. Again, another interruption. So you need to be quiet and let the state make a record. Stop gesturing at me. Stop rolling your eyes at me. Stop mumbling.
I'm looking right at you. I'm not rolling my eyes.
No, you have throughout. I've seen it and I've made note of it.
I'm looking at you. Okay, so are you asking me to be quiet or are you telling me to be quiet?
Go ahead, Attorney Opper.
Thank you, Your Honor. And just to indicate, Your Honor, this court has been abundantly patient with Mr. Brooks. He challenges the court's authority repeatedly. This court absolutely has the ability to tell him, sit down and be quiet. And you haven't done that. And I know why you haven't done that, Your Honor, and we appreciate that. He is not in control of this courtroom. You are. And he needs to respect that. This video was relevant based on his questioning of Detective Casey, as you just indicated, challenging his ability to identify the person who had their back turned to the camera in the still shot of State's Exhibit 175. Trials are fluid. When he opened the door to that, we came up with the video which Detective Casey testified repeatedly on direct examination and cross-examination as to how he knew that was Mr. Brooks because he had seen the rest of the video. He would not accept that. He pushed it and pushed it and pushed it until we played the video. The lyrics of that video probably would have been prejudicial. Originally, I wasn't going to ask for volume. Then I did because he pushed it again, and his voice and his mannerism of speech, I thought would have assisted the jury in identifying Mr. Brooks as the person in the video with the red SUV. However, you smartly asked me to play it without the audio, and I did that, and then I never went back to that. This is all to the benefit of this defendant who continues to suggest and impugn the integrity of this court and this prosecution without basis. He doesn't like it because the evidence is stacking up and stacking up, and whenever it does, his response is to accuse you, the court, or the prosecutors of being unethical and hiding things. There is nothing in law that prevents me from pulling something out of my briefcase right now and making it an exhibit if it's relevant. You decide what's relevant, what's admissible, not Mr. Brooks. There is no law, he can cite to no law, no authority whatsoever that says I can't make an exhibit essentially on the fly if it's called for, and that's exactly what just happened here. So I apologize for my tone with the court. I don't mean to direct this at the court. It is very frustrating. The court has demonstrated much more patience than I have with Mr. Brooks, because again, I do not appreciate his impugning the integrity of these proceedings, of Your Honor's efforts to run a fair trial, and of our efforts to run a fair trial. We have ethical obligations as well to be fair in this courtroom. We have respected that entirely. The reason I was laughing 30 seconds ago was because the exhibit was mislabeled. There was an extra Y and it said Exhibit E, EXHIBITY. And I turned around to the paralegal and pointed that out, and we laughed over it, the word exhibity. That was it. There has been no disrespect directed at Mr. Brooks directly in any fashion. So he can object all he wants, and he has made that clear. He will continue to object and obstruct the court and obstruct these proceedings every last chance he gets. But legally, everything has been above board and proper, and this exhibit is no exception. I apologize for my tone, Judge.
Thank you. I appreciate that additional record being made.
I object to that.
My previous ruling doesn't change in any way that the exhibit is relevant. I indicated I would take it up because, and I'm taking what the state's saying as withdrawing the request to play the lyrics.
That is correct.
All right. I have not heard them, but I'll certainly take the state at its word as an officer of the court that it would be prejudicial based upon the lyrics that are in that video, but my decision to admit the video without audio stands. I do want to take up two other issues. There was an objection to questions regarding cross-examination, so the objections were by the state. One had to do with there was questioning about possible testimony with his niece and nephew, and then the jail cell search issues. So Mr. Brooks, you asked the questions. The state had objected. Since you're the proponent of what would presumably come in through the testimony of Detective Casey, what is your offer of proof as to why I should allow Detective Casey to come back on the stand and testify about his interaction, I believe it was with your mom, and possible testimony of your niece and nephew?
It don't matter with Detective Casey. He's off the stand. He's not going back on the stand too.
No, but I told you I would recall him. I wanted to take it up outside the presence of the jury.
How do I supposed to know?
So are you?
Glam, sir, you allow another moment when Miss Love calls me that I did not do something. They have the exact image of what we got from the jail in Fayette County. That is it. And if I get another false allegation and you do nothing, I'm shocked. I'm appalled at you. I sit here day after day with this false allegation just machine. I gave the state everything. There's been no disconstruction. There's been no purposeful, I don't care. I don't care. I give over everything. I've done this for 33 years. Never in my life have I seen a trial. I've done 300 appeals in the state of Georgia alone. I've never read a case like this. Judge, I gave them everything I had. I waited. I was at my office till 8, after 8 last night. I waited for their investigator to come by. I handed him an exact copy of thumb drive. They have everything that we got from the Fayette County Jail. There's been no deconstruction. There's been no purposeful exclusion. This is not the first time. Okay. And I apologize that I'm getting tempered, but I've never been treated like this. You talk about professionalism every week. Professionalism is lacking with one lawyer here. It has never been. I don't even like coming to court. I used to love this. I would die for what we do. I used to say, I'm dying. I would die. I couldn't choose a better profession. If I had litigated with Miss Love, I would. Your Honor, could we strike the hominem attack? No, I'm speaking. Really, could we strike that?
Okay, everybody, calm down. Everybody, both of you, please be seated.
Judge, I'm not
Both of
done.
you, please be seated.
You have to do something. You have threatened me with contempt. You have threatened me with jail. If you go back in time, we can just start in voir dire. Jury after jury, you did individual voir dire painfully. Miss Love would come in and say that juror was crying. It was not true. You would say, that's not my recollection after I said it. You did nothing. We start the
Okay,
case.
but Mr. Steele.
I asked you, please.
Mr. Steele.
Please, Judge.
Mr.
How would you feel if you were being treated
Mr.
like
Steele.
this?
Mr.
Well, I'd
Steele.
like to finish.
Mr. Steele.
I gave them everything on that drive, and it's continual abuse of a prosecutor of another member of the bar. I don't talk with Miss Love. And that's fine. I like that. But Judge, I'm not going to stand here anymore. I don't care. You can take my bar card.
Mr. Steele, listen.
Wrong, though.
But there.
And Mr. Williams, you know, to me, this is an innocent man. You talk about, Miss Love said there's a man in the Fulton County Jail who shouldn't be there, Mr. Copeland. Mr. Williams shouldn't be in custody. But he's been charged, and we come here for a fair trial. It's been everything but that, according to Miss Love has tried to demonize me. At times, Mr. Adams. At times, Mr. Shaw.
I object to the ad hominem attacks, and I ask for
all because she wants to win the case. And now she speaks over people. It's not right. I gave them everything. And by the way, and what I want to tell you, by the way, it's not even the law. If they call that gentleman on direct, I don't have to give them anything before trial. I do it because you asked me to. You said, listen, we got a big case. It's going to take a long time. Give them things. I gave this, by the way, to the state October of 2023. October 2023, that was uploaded, given to the state. I hear about it now, and I wait there, and I give them the exact duplicate of what we have, and now there's a false allegation of misconduct. And what I'm telling the court is what I said again. I do not appreciate it, and you have told it in front of the jury that I'm unprofessional. You were wrong. You based that on Miss Love's false representation.
Your Honor, again, the ad hominem attacks, Your Honor. I object, and he should stop talking when I
Miss Love can
object.
try to silence me. Will not be silenced.
But Mr. Steele, here's the thing. Okay, I think that Mr. Steele, please be quiet at this point in time. You made your point. You made your point at this point in time. Both of you, please be seated. Please be seated, sir. Sir. Please be seated.
Whatever you do is fine, but I care about Jeffrey Williams. It's the best.
Sir, it's obvious. I would expect no less because you're his advocate, you're his champion. But could you all please sit down so I can kind of figure out a solution for this? All right. First, let me just kind of address the obvious. I know that at times tempers have been heated in this particular trial, and they continue to do so. And I know that all of you are being zealous advocates and representing your clients to the best of your ability with zeal and rigor. However, I agree that, you know, there should not be ad hominem attacks on anybody or any counsel, and that you all should think and reflect about what you say about your brothers and sisters of the bar. Because we have a large contingent of folks that watch this trial, and I mean, and so not only for the purposes of this, but it sends not the message I think you want it to send. All right, so I'm going to leave you all to your wise discretion in order to do that, but I'll take up whatever I need to take up as I see fit. But I know that you all. This has been a long trial. It's very demanding, exacting, and grating on, and tiring on all of you. So I ask you to just take a couple deep breaths and step back and see, and kind of look at, and just remember that you do represent of who you represent and what you're here for. In terms of the tape or the phone calls from Fayette County, it's the court's suggestion that, and if you want my assistance, I can always, with a proper subpoena, have the raw, whatever it is that whatever you're seeking to get, I could get that, and you can compare that against what you have. Because maybe that's what, I mean, and Mr. Steele, I don't doubt, and I know that you would never delete or otherwise try and alter evidence, and I assume that that's what you got, and I'm gonna take that at face value. I'm in no way saying that. Ms. Love is in her argument is saying that she is, when it's stripped down, less all the sound and fury, She's saying that that particular type of file has other things with it. I don't think you were given those. And that's what she's trying to get. So I'm in no way blaming anybody in this particular circumstance. But if you want that particular file, and I think you all should have that particular, the raw file, then let me do a notice to produce or a rule nisi, and maybe we can get the entirety of the file. And I think that if you did that, I think that the whole thing would probably be produced to you, because nobody probably wants to come down here and see me. So I will work with you all to get that, and you all we can take that up. And it's a problem I think can be resolved. But I'm in no way. But I would just remind everybody to be careful about what they say to each other. Some things you just can't take back. And remember, y'all are going to see each other over and over and over again. And, you know, it serves you and serves the profession, serves your clients. It's not effective. So just please consider what I've just told you. All right? So, I'm just going to recess and we'll see where Mr. Melnick is at that point in time. And then I can talk about Monday. Okay, Mr. Steele, would you take the podium, please, sir? All right. All right. Mr. Steele, before I recessed, I asked you, how did you get this information? And it is not covered by work product. There's only one way you could have gotten it. So I'm going to ask you again.
And I respect that. And it gives me no joy. But as you know, Georgia Rule of Professional Conduct, please check me. Rule 1.6, comment 5 reads, and this is what I have. 1.6.
I know what the rule says, but here's the thing.
Well, let me just.
You need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt.
I understand. I don't want to be held in contempt.
And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious.
Yeah. And that's why I raised it. It is that serious that we should have been there and it shouldn't have happened.
Sir, that's a whole separate issue. And that's why ex parte conversations are recorded.
Why would it be ex parte? You're acting like it's ex parte under seal.
It's ex parte. It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation.
I've never asked this honorable court or any court to meet with me and a witness.
Sir, you're straying off the issue.
I'm not.
The issue is how did you get this information?
I understand the issue. I promise you I understand it. But what I'm trying to ask you is, if you look at comment 5, this is how I understand the law.
You cannot you can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, but that's why I'm saying, how did you get the information?
But just listen to what I'm trying to tell you. You're threatening me with contempt.
The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
Let me tell you. I'm just reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe, you're asking me, I'm not saying you're ordering me, but to give you information, and you're saying it's not substance, but I'm telling you I can't do that under the bar rule.
All right, well, I'm going to hold you in contempt. And you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it.
You can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea.
I have an idea how you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to listen. I told you the first time. And I'm not going to breach that confidence.
I don't want to hold you in contempt, but this is that serious.
Judge,
you cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
Judge, listen, and listen, I'll do whatever you want to 5 o'clock or thereafter. But what I'm trying to tell you is, Your Honor, this is so serious to me. We need a hearing, and I'm moving for a mistrial. It is my understanding, based upon information belief,
from whom?
Part of it.
From whom?
Well, I'd like to get the substance first, and then we can.
Okay, well, then you'll be in custody until then, because you need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you. So,
but you're assuming something because I told you already.
Well, then, other than if you were sitting, unless you were sitting in there with a recorder, or Miss Love, or Miss Hilton, or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left.
Well, Your Honor.
And if that person gave you that information, or shared that information with you, she probably violated privilege.
Well, let me tell you two things. One, I don't know how that is a privileged communication. It shouldn't have been.
Well, it's because she has a client she's supposed to represent.
Who are you talking about?
But anyways, I'm not going to have a.
When I got this information,
I'm not going to have any further conversation with you about this. I want to know. The question still remains. I want to know who gave you the information.
I'd like to know what information happened outside our presence. That's really it.
He can go into custody at this point in time.
I think that the court needs to again declare a mistrial based upon.
Okay, and I'm going to deny your motion. I'm going to deny your motion.
I understand that you spoke with a witness outside of our presence.
And whenever, yes, I had an ex parte conversation, which is appropriate.
And you influenced the witness based upon information belief, and I'd like to have that all on the record.
All right.
I mean, I don't know why that's so hard to do. If nothing happened bad, that's fine. But you're acting like, tell me who it is and don't talk about the substance. Why can't we have an issue that was outside of presence? It should not have been.
Because you got some information that you shouldn't have gotten.
Why?
Well, that's for another day.
But why?
Okay,
why
that's for another day.
In the first place, I didn't know about this stuff.
That's for another day. So
I raised it as soon as we found out about it.
Well,
I gave you the case I'm relying on. I assume you read it. If you didn't read it, you should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the court has said it's right there in Division 2.
Okay.
That is a material or critical part of the case, and it's an automatic reversal.
Mr. Steele.
But you're acting like it's
Mr. Steele, that is not that is not the case when somebody discloses information in a ex parte conversation that one of the parties lawfully asked me to hold.
You're not supposed to have communication with a witness who's been sworn. You know that I'm not telling you. I'm just saying if you read I'm assuming you read it. That's what it says. And you did it.
Does the state wish to be heard?
You said it supposedly.
Yes, Your Honor.
And what I'm trying to get to is why did that happen outside of presence? And I need to have I'm respectfully requesting the transcript that you mentioned to be given to us so we could really understand it. And then anything that was not on the transcript, if anything, that we understand what happened outside our presence.
Okay.
And now you have put it where somehow I have to reveal, and I told you the first time, I'd be breaching 1.6. And I know you're assuming something.
I don't think you're breaching 1.6. You can't hide behind 1.6.
I'm not hiding behind anything.
You can't hide behind, yeah, but the thing is, I think you got this information. Somebody disclosed it to you, and that's the only way you could have gotten it.
What I got.
Because unless you're sitting there, you're eavesdropping. So you can't use something ordinarily that you had no business getting to begin with and then stand on, well, hey, we didn't give you the information, or that a party didn't give you the information. So,
Your Honor, but that's the issue, isn't it?
well,
Why aren't we
that needs to be told. But
right now, we don't know why we were excluded from that.
Mr. Steele,
and I want that information because Mr. Williams' constitutional right on the Georgia Constitution.
Just stop at this point in time, because
Article 1,
because you've already said that. You've already said
Georgia Constitution, and we have the right to be present.
All right, Mr.
And we're not waiving anything.
Yes, Madam, Ms. Love.
And Your Honor, excuse me. And I know I said this previously.
Yes, sir.
But we are not accepting any proffer from Ms. Love.
Okay, excuse me.
Okay. All right.
To the court. The court has inquired. We have no way of knowing what it is or who it was that disclosed information that was contained within an ex parte conversation. Not only was there an ex parte communication between that we requested as a state to be on record with the court, but there was communication made, I believe, to a person and his lawyer. I don't know that the reason that counsel took the podium was to address that particular issue so much as it was to try and assert an inaccurate what he calls fact and put it out there in the open as if it were true. But we certainly have the right to request ex parte communications. That's why we ask that the court reporter be present. This is a matter that the defendants did not have a right to be a part of, as this was a matter regarding a civil contempt that the court imposed upon a person for not obeying the court's directive. The state read the case that Mr. Steele cited. It does not stand for the proposition. He asserts that it does. And regarding further legal support for our position, we would provide that to the court, but we are more concerned that information that is disclosed in an ex parte setting gets relayed to the parties who are not privy to that. The whole purpose of the ex parte request was so that that did not happen. And we expressed on the record our concerns and our reasons for concern regarding that. We believe that without more information about how that information got relayed to the defendants, we cannot make the kind of assertion I'd be inclined to make. So before making the next set of assertions, I would need to know how that information was made privy to them, to counsels for the defendant. We did not act inappropriately or outside of the rules of professional responsibility. And if need be, we will reach out to the state bar ourselves and ask what the appropriate remedy is for everything that has happened over the last 2 days, well, the last 2 work days, because we are extremely concerned. We have observed a number of actions on the parts of a number of people that I am not comfortable stating publicly at this time, but that would appear to call for being addressed in some other way. So as to Mr. Steele's request
I guess it was for a mistrial. I'm not even certain what all that was. I think it was probably more to make inaccurate assertions on the record public to whomever was within listening shot of his voice. And we would ask that the court strike everything that he said from the time he stood up and started talking after the court asked him where it was that he obtained the information that was made privy in counsel for this court.
All right.
And regarding Rule 1.6, Your Honor, we read 1.6 as standing there. 1.6 in no way shields Mr. Steele's answer that the court requested he give. Rule 1.6 has to do with attorney-client privilege, and that is information that Mr. Steele obtained from his client regarding whatever matters. I don't know if the information was leaked to his client from someone who was in chambers, or if the information was leaked directly to Mr. Steele. In either event, it is concerning and in no way falls under the protections of Rule 1.6. If the court would allow me a moment.
All right.
Regarding further appropriate remedies, Your Honor, we would ask the court for an opportunity to further look into appropriate remedies for circumstances such as this, apart from what the court has already said, because it's grave enough when information is leaked from within the court's chambers regarding a matter that has been requested as ex parte, and we would ask for the opportunity to present to the court additional appropriate remedies that we believe are available.
All right.
Your Honor. Have you heard?
Sure.
And Your Honor, also, unless it's Mr. Adams representing Mr. Steele in the capacity as someone who has been held in contempt, Mr. Steele just argued whatever it is that they are trying to argue based on information we believe illegally obtained from the court's chambers.
I represent Mr. Williams, and my statements are in regards to my representation of Mr. Williams.
All right.
He has two attorneys.
Okay, yeah, he does, but
the court now having found Mr. Steele in contempt, if the court continues in that position, that leaves Mr. Williams represented, at least at this juncture, by myself. That puts me in a position of making sure the court is aware that I'm in receipt of the same information that Mr. Steele received. I'm of the same opinion that the court has engaged in behavior that I believe compromises and corrupts the continuation of this trial. I do believe that we are entitled to and should receive a copy of the transcript so that a full investigation can be made as to what we believe has occurred here. And so I take the same position as Mr. Steele. I am asking for a mistrial, as he did previously, and I'm telling the court that I do not believe that we can proceed at this point based upon the information that we've received.
All right, sir.
And frankly, I don't believe the state has any say in that. My statements are in regards to my representation of Mr. Williams, and if Mr. Steele is going to be held in contempt, I have exactly the same position. I also do not.
Well,
believe
I asked him, so I didn't ask you.
Yeah.
So, but I'll leave it at that. Okay. What is it, Mr. Sharp?
Thank you, Your Honor. As you know, I represent Shannon Stillwell. On behalf of Shannon Stillwell, I am going to be moving for a mistrial, first and foremost. I just want to clear up a few things that have been said. Today, we were instructed to come 8:30 for a 9 o'clock start. I would not be honest with the court if I said I was here at 8:30, but I was probably here at about 8:40. We did not start till approximately, I'm estimating 11 o'clock. Clearly, we figured something was going on. We were given no information about any meeting, who was meeting, what the meeting was about, or whether the meeting was ex parte or not ex parte, who requested the meeting, who was in the meeting. We were completely in the dark. And quite frankly, we kind of remain in the dark. I am not a false accuser, okay? I do not just willy-nilly accuse people of things. So, I'm not going to throw out spurious allegations like the ones that have been thrown at me over the past couple days that are absurd. But I will say, Your Honor, what I do know is just based on what we've heard over the last 20 minutes, it appears there was a meeting that I knew nothing about that involved Your Honor, the district attorneys, and a witness who had been sworn in. My client was not given an opportunity to be present at this critical stage. This was a critical stage in this trial. That error is a foundational structural error in this case, and it is the cause for an immediate mistrial. Additionally, Your Honor, I believe that this meeting, again, I'm going to ask for the transcript and I'm going to ask for the recordings as well, should they exist. But I believe that this meeting with a witness without us present may have made the district attorneys and or Your Honor a witness to this in this case, a material witness in this case. And finally, Your Honor, I'm going to ask for as soon as possible, I'm going to ask that these proceedings be halted until we can obtain an accurate final transcript for what occurred where none of the defendants or defense counsel were present for, and also the recordings of that meeting so we can see where we are. Again, I'm not going to sit up here and make false accusations or spurious allegations, but I do think we need to figure out what happened. We need to be in the know and not in the dark about what happened when a meeting occurs with a witness that has been sworn in and we're not invited to the party. So those are my requests, Your Honor. I think it's necessary at this time to put a halt to these proceedings. I am moving for a mistrial. I have not waived anything. I just found out about this information. It is timely, and that's our stance, Your Honor. Thank you.
I've noted your motion for mistrial. It's denied. Okay, are you same thing? You want the Harvey?
Mr.
Okay, all right. Okay, Mr.
I'm adopting all of the statements.
All right.
Good afternoon, Your Honor. Carrington Matthews here on behalf of Mr. Mark Huey.
Okay.
We are also adopting all the arguments that have been made by
All right, sir.
Steele, by Attorney Keith Adams, by Attorney Max Sharp, by Attorney Douglas Weinstein. We also, Your Honor, we were here at the appropriate time, and when the court did come out, we were not made aware that there had even been an communication that was on the record, just in the point of just letting the parties know that there had been this particular meeting. I had my suspicions that that was likely what was going on, but I could not reduce that to a fact. When the court came out, the court just got started. We believe that based upon, again, ex parte, we don't have to know the substance all the time. Just the fact that there was that meeting, Your Honor, would have at least put us on some notice that there was something that was going on even beforehand. I thought that would have been the appropriate move, but nonetheless, Your Honor, I'm asking the court for a mistrial. I believe that it's appropriate here under these facts and circumstances. Thank you.
All right, motion for mistrial denied. Ms. T. Williams? All right, thank you, madam. Motion's denied. Mr. Garner? Okay, so noted. All right. Okay, Mr. Steele, last time, who told you? All right, Mr. Steele's in custody. Once he clears the area, we'll go ahead and get started.
If by that point means we'll get started, resume the trial, Your Honor.
Yeah, we're going to continue. I'm not calling nothing.
I'm not going to participate in the trial without the Steele and without.
You don't have that luxury at this point in time, sir. You don't. You don't.
Without the court addressing.
You don't have that luxury. You don't have that luxury at this point in time. You don't.
Without the court addressing the issue that we believe is germane.
Sir, you all are really getting yourselves cross purposes at this point in time.
I don't believe so.
Sir, I'm telling you, you are at this point in time. You made some things out of nothing. I think that you're on very precarious ground at this point in time. So I'm telling you at this point in time, he's in custody. We're going to go ahead and start. You can represent Mr. Williams. That's okay. That's fine. I'll take up the other stuff as needed, but I'm not going to take it up right now.
Respectfully, I will not.
Say again?
Respectfully, I will not. I cannot.
Sir, you have to. Well, you're gonna have to do the best you can at this point in time, because you don't get to extort the court. That's what you're attempting to do at this point in time, sir. Yes, you are. What you're trying to do is, I'm not going forward if I don't get this. You know, it doesn't work that way, Mr. Adams. And I'm telling you at this point in time, I would just kind of govern yourself accordingly, sir. I'm telling you, as the court, under these particular circumstances, everything will come out as it should. I don't think, sir, I don't have enough information at this point in time to address it. I don't. But I'm telling you at this point in time, there is nothing that was given, said, whatever, this morning that.
If there is any accuracy to some of the information that we are.
But sir, I don't even know. Your co-counsel won't even tell me who said whatever. Okay. And the challenge I'm having in this particular circumstance is that is such a violation of the sacrosanctness of the court's chambers and an ex parte conversation. You're just glossing over that. You're glossing over that in its entirety. No. It's not, sir. Sir. That's not what happened. That's not what happened. That's not what happened. I'm just telling you, that's not what happened.
Judge, respectfully, we are not obligated to simply accept that there's been no violation. We believe that there has been, and the only. Okay, well then no, we're not doing that at this point in time. So you'll have a choice to make. All right, take Mr. Steele into custody, please.
Your Honor, would the court afford me one moment to confer with counsel regarding the appropriate remedy in this type of situation?
Okay, all right.
May I say one thing, Your Honor?
Yes, sir, you certainly may.
Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I ask for a mistrial. And I assume you deny, but I'd like you to deny our motions for mistrial. You denied the. On the recording that you just heard at the beginning, the first couple of minutes, and I don't have the time in front of me, it was not shown on the screen. Mr. Bean said when he spoke with the detectives or the authorities, whatever his words are, at the hospital. That's what he says.
Okay, but here's her beef. If you'd have said, who'd you talk to? And he said, I talked to the detective. Well, was it Detective Lewis? Was it Detective Quinn? Was it Detective whoever? What I think that the question assumes is that he did in fact talk to Detective Lewis, and he didn't.
I don't know if that's true.
Well,
I'm not conceding that.
Well, I'm going to tell you that I haven't heard anything that would indicate that's truth.
Yeah, well,
That you have a good faith basis to ask that.
You haven't heard anything of who he spoke with. That's my point.
That's the point.
But you all can't. But you two, neither one of you can proffer that.
Judge.
It's not proper, Mr. Steele.
No. Listen.
It's not. It would be a violation before me for you to put that in front of this jury.
You're not letting me finish. In the September 17, 2000.
You were saying to the court that you have a belief that there is another statement out there. There's not.
How could you say that?
Because it hasn't been brought up. If it gets brought up, then we'll correct it at that point in time. But right now, I'm going to direct you not to inquire that line. You don't have a basis to do so.
Not true.
Well, go ahead and make a statement and see what happens.
Your Honor, listen.
Go ahead and make the statement in contravention to what I've just told you, and I'm telling you that you will have some problems in front of me.
I'm trying to articulate to you.
You have told me everything at this point. You have told me that there's got to be a statement. Now, if you find the statement, I will, one, apologize to you. Two, I will take corrective action. That's probably not going to be nice to anybody. But at this point, there's nothing for me to do other than if you don't have a good faith basis to do it, you can't ask the question.
Honor, listen. There is a recording between Detective Quinn and Adrian Bean where Adrian Bean says, I lied to your...
But we don't know what he lied about.
He says he lied about who... He's talking about the car.
But we still don't know whether or not he had a conversation with Detective Lewis.
And I made it clear. It's 10 years ago.
But you said you had, in your conversation with Detective Lewis, that's what you proffer.
I said, or any other detective or law enforcement. Read the transcript. I made it clear. I don't know. He doesn't remember names. He says it was Detective Quinn. Also, on the recording, on Sunday, January 22, 2023, Mr. Bean is the one who said this happened in the hospital. Your Honor, I'm the one complaining about I don't have the statement. I've been asking for it. This is Brady. Clearly there was a statement made.
We don't, but we don't know if there's a statement. You're supposing there's a statement, okay? And there may be. And you know what I said? And you know what I said earlier? I said if there is Brady that's not disclosed, then that particular individual is going to have some problems with me. I told you that already. Or I have a lot of different remedies I can execute at that point in time.
There has to be. That's why I gave you.
But you can't intimate or otherwise cross over the line when you don't have the statement to back it up.
Judge, I've been robbed of the statement.
But we don't know where the statement is. If we find the statement or it comes up or in cross-examination, Quinn brings up and says, hey, happen to have a statement right here in my massive file. And if he does, then of course I will revisit this particular subject again.
I'm saying it's been deleted. It's been destroyed.
We don't know. You don't know. We don't know what happened. We don't know what happened. We had the same issue that happened earlier in this trial about a statement. We don't know whether or not it was the hack or whether or not it's intentional. Now, you can make whatever hay you want out of it. I mean, and the jury can decide for what they want to give it. But you cannot ask the question in its current form. You just can't.
Your Honor, I'm not asking any questions, but you have to understand the following, please. 6 days later, Detective Quinn and Adrian Bean are on recording where Adrian Bean tells Detective Quinn, I lied.
About what?
I lied.
About what?
Who was driving the car. He gets cut off. Detective Quinn says, yeah, tell me about it. Where's that statement? That's what I've been asking for.
But that doesn't still give you the latitude at this point in time to ask that question. Now, I told you, if we find out from Quinn, and I'm telling the state that if I find out that the statement exists, there's going to be a lot of unhappy people.
Well, what if you don't find out it exists? I still am entitled to it. That's my whole point.
Okay, but here's the thing. You've asked me for it. I've asked them. If it comes up later, or I find out it's sitting someplace that was in possession of the state, pursuant to case law and definition, then we'll have some problems.
I understand, but you're asking where you have to find the statement for. I'm telling you the statement was made.
It doesn't work that way, Mr. Steele. I'm sorry.
It does work that way.
No, it does not.
Yes, it does.
No, it doesn't. And you haven't presented any case law to tell me how to do that. And I'm telling you, as the judge presiding over this case, if you do that, it's misconduct.
I'm not doing anything.
I'm telling you right now.
I don't know what you're telling me. I'm not.
I am telling you, you have no good faith basis to this point in time to ask that question right now, or to intimate that.
I didn't ask any question. You are listening to the district attorney above. I'm ready to cross-examine. I'm going to play the recording you just heard. This gentleman tells me on recording that he was at the hospital speaking with law enforcement. I want that. It is backed up because on recording, 6 days after the crash into that side of the building, Your Honor, Detective Quinn and Mr. Bean are talking about the statement that Mr. Bean made prior. I don't have it. And when the court asked me, well, you got to find it, or if I find it, it wasn't given over.
Then we'll have some problems. Then we'll have some issues.
I have some issues now. I've been begging for it. The state's supposed to give this.
Let me ask, hold on, Mr. Okay, stop for a second. Mr. Steele, you've got to stop commentating or offering commentary in front of the jury. I've warned you about 4 times. If you do it one more time, I'm going to hold you in contempt. Contempt is punishable by fine and or jail of up to 20 days. I don't want to have to do that. But please do not comment in front of this jury anymore, okay? That's the only thing I'm going to tell you. Do we understand one another? I need an audible response, sir.
I said, yes, sir.
Okay, all right. Just as long as we do that, okay? Okay, Mr. Shard, have you and the state worked on Mr. White's redaction? Mr. Shard?
Yes, Your Honor. Trying to turn on the microphone.
There you go.
I have spoken to the state about this issue, Your Honor. I identified 2 different, and we're not in agreement. I've identified 2 different portions of the tape. Overall, it's about 1.5 minutes that's in dispute. Probably, I believe that there's a hearsay statement at 6:48 of the phone interview. In the car interview, there's just basically what I feel is an argument of future dangerousness that's completely irrelevant, made by Investigator Dennis. These, again, Your Honor, these are on tape statements made by D'Angelo White. Typically in trials, in my experience, prior statements are not just played to the jury. So, but I've noticed throughout this trial that the state, that is the way, their preferred method of impeaching their own witnesses. So if we're going to proceed on that method, which I don't necessarily agree with, I just think we need to clean up those 2 small areas. One area that has hearsay and one that has inappropriate argument of future dangerousness.
How long have you had this particular recording, Mr. Sharp?
I've had it for over a year.
Why the motion at this point in time then?
Your Honor, I'm not articulating this correctly, I don't think. In trial, we have.
Well, I'm asking.
I'm explaining, Your Honor.
I'm asking you because here's the court's concern. You could have filed this as a motion months ago.
I wouldn't think that we were going to just.
No, that's not the point. If you think something's going to come up.
I didn't think it would come up.
Well, you filed it now, so you obviously. Because you've identified a course.
I've been sitting in trial.
Mr. Sharp, because you've identified a course of behavior. So you should have filed it way before the witness is close to getting on the stand. Do you understand that?
The witness. Well,
let me ask you a question. Let me ask you a question. Do you practice in federal court?
No, I don't. But
I can tell you, this would not happen.
Can I?
This would not happen.
Okay. Your Honor, I don't think that the statements would be played in totality like this in federal court, quite honestly.
That may be true, but that does not relieve you of the responsibility to timely file a motion and it's just not wait till the last minute. I'm not waiting till the last minute, Your Honor. I am not anticipating that we're about to discuss a slideshow. Focus. We ain't got to that yet. All right. Focus. I'm focusing on your behavior at this point in time. I'm not saying to you that the information is not any less invalid, but it's the timing that's a problem. It's a problem, and since you
I wouldn't think that we would be admitting these things, but since I've seen these things, these statements, these out-of-court statements being admitted, I've taken it upon myself. A couple weeks ago, you said to us, please flag things in advance. I took that to heart. This is not in advance. This is not in advance. This is like, we got a jury sitting here. You all didn't get here at 1 o'clock. I told you to be here at 12:30. I've been here. I know that you were here early, and I know why you were here early. Okay. So, but focus. The focus is on why didn't we file this stuff months ago, and let's wind it out and air it out at that point in time. Okay. So I'm going to ask the state their issue on this. Are you cutting this out? Did you have discussions with Mr. Sharp, Madam?
We did have discussions.
When?
Well, this morning.
That's too late. The evidence is excluded. The evidence is excluded. I'm going to exclude because I told you that this was going to happen.
We reached out to
No. We're excluding that. And I'm going to exclude the PowerPoint that you all submitted. Well, you're not going to wholesale introduce it.
We had no intention. Your Honor,
all right.
Let's be real clear. We did not intend to introduce this PowerPoint today. I personally reached out via telephone and called at least 2 members of the defense team and asked them to call me back. And I would like
but you all should not be identifying this stuff the moment of trial while the jury's sitting in a box. This is the last. I am not going to tolerate this any further. If you don't get together with your colleagues and flag issues and resolve them promptly, and if I have to take them up, remember, I can exclude them, we'll work the weekends, or we'll do a combination of both. So this time, I'm going to exclude those 2 sections.
Your Honor, Mr. Atkins, he confronted this witness with those sections. I last week let them know that we were introducing that.
If the exhibit's not ready and you haven't made, no, well, Mr. Sharp's got objections to it.
So, Judge, Mr. Sharp can get in and have our evidence excluded every day that he makes an objection at midnight, and then comes in and says.
Well, then you all should have gotten your stuff together before then. Some of our juries, please. Some of our juries. Have a seat, madam. Have a seat. You better exclude that, and next time, make sure you're prepared. Make sure you're prepared next time. I'm not going to do this anymore. I'm just not. We are starting right now. It's 1:20. So
we have talked to them. We have said we don't agree.
Then file a motion and get it before me, and we'll take it up. Both of you all have equally responsibility to do that. Oh, it's going to be inadmissible right now.
I'm saying, Judge, that you said to file a motion. There's nothing in
I'm not going to have any more discussion about this, madam. I'm not.
Talked to them this morning about that.
Well, you know what?
And I attempted to try to talk to them earlier this week.
Well, then that's why we have to.
So the court punishes the state because the defense.
I'm not punishing anybody, but but prior preparation prevents poor performance.
Be prepared, Judge. That's why I sent them what I sent them last week. A whole week and a half ago, 2 weeks, Your Honor. And I have said I would like to discuss.
Our jury's coming in, madam. Our jury's coming in. Have a seat.
Your Honor, I think he's finished already. So, were you done with your answer?
And it was not a response.
Yeah. All right.
Okay.
So this is yes or no?
So.
I don't think the Sir. Please sit down. Please sit down. Thank you. Just please sit down, okay? I don't need any help from you, okay? All right. And there's no objection on the floor. So, all right?
My objection, Your Honor, to that last series is that the court I would ask the court to allow the witness.
He's finished the statement. There's nothing else. It's like if he asks to continue his statement, then fine. But sit down and stop interrupting, Mr. Matthews. Mr. Stevens, are you finished with your last response, or did you finish? Was there anything else you were going to say?
But I lost my train of thoughts, Your Honor. But I mean, she can continue.
No. If you weren't finished, we'll let you finish that statement if you wish to. But you have to.
I don't wish to.
All right. When you trail off, what happens is that the examiner thinks that you're done. Okay?
Yes, sir.
And that's causing a little bit of confusion because the folks out here think you want to say more things. So if you have more things to say, just go ahead and just continue to talk. Okay?
Yes, sir. I'm trying to my best to
and complete your answer.
Yes, sir.
Fair enough?
Yes, sir, Your Honor.
Okay. All right.
Mr. Stevens, what colors are associated with Young's Limelight? The gang.
All colors?
Mr. Stevens, would you do me a favor and tell me, you ever heard the word snitch?
Yes.
And what does the word snitching mean to you?
Excuse me, Miss Lowe. Madam in the black, get rid of your gum. Remove yourself from my courtroom and get rid of your gum. In the earrings, you. Yes, you. Get rid of your gum. I apologize, Miss Lowe. Judge Glanville, that he invoked his or withdrew his consent at that point in time and did not wish to speak to law enforcement officers anymore. I understand the state's argument about parsing it out, asking for clarification, but I think that once he's, the appellate, case law that I've looked at, in Paul Doe and others, he has invoked his right at that point in time, and it's this court's opinion that anything thereafter would be inadmissible.
Your Honor, the court also found that he reinitiated, and that was what.
But that's their issue. That's not my issue.
Your Honor, I'm not.
Okay, and to your point earlier, Judge Cohen and Judge Baberman, I can't tell whether or not they listened to what I heard, but you're only as good as the information that you're given.
Right.
So it doesn't say on this particular order that that's what they relied upon. It just says he wished to talk, some point in time. He wanted to speak to his attorney. Now, I'm of the opinion, this court's of the opinion that questioning needs to stop. He's unequivocally revoked. And you can't pick and choose at this point in time whether or not it's to this particular crime or any other assertion. So that's why I'm going to suppress it.
And Your Honor, Your Honor, with respect to the statements that were made after that time, we do have, as I stated, Investigator Thorpe to tell the court on the record, present under oath, that it was not Detective Thorpe, it was the defendant that reinitiated the conversation with Detective Thorpe. Our representations to the court are not evidence, and since the state has the burden of proof.
Okay, but I've seen the video at this point in time.
Video does not encompass when the defendant actually reinitiated contact.
But the problem is, he invokes, and then we don't know what goes on in the 45 minutes, but we come back afterwards, and at that point in time, you don't get to eat your cake, have your cake and eat it too. It's once he invokes, that's it. It's over.
Your Honor,
they should not be bringing him back at that point in time and asking, well, let me just clarify a little bit about whether or not these statements were made to these set of detectives or to Galpin.
It wasn't there in the room that I'm talking about, Your Honor. I'm talking about in the first, the defendant asked for a smoke. So they took him out for a smoke. When they took him out for a smoke, the defendant reinitiated the conversation as they went outside. That is what they found in the district court, but the court doesn't owe that deference. That is why we have, as the burden of proof, holding the burden of proof, that is the reason we have Detective Thorpe here to testify.
I don't need his, I'll consider it, but it's this court's opinion that once he invokes, you don't get another bite at the apple by taking him outside, softening him up, giving him a cigarette, some bonbons or whatever, and then letting him go ahead and then saying, oh, well, let me just clarify with you a little bit. That's not how that this scenario worked. I think that you all are just annoyed more so that your detective did something that he probably regrets now. And that you all probably would not have told him to do. Don't interrupt this particular investigation or this particular hearing, because what you did is you just now created a wrinkle that now I got to deal with, or whether or not the defendant has invoked his right to counsel. He has.
And Your Honor, I'm not annoyed, Your Honor. I just have, with the burden of proof, we have a person who can speak to the issue rather than having us, sort of speculate as to what happened, because it's not, as the court at this time has indicated that it sees, which is that we softened him up with things.
That's my ruling. And prepare an order suitable on my directives, Mr.
Yes, Your Honor. Thank you.
Your Honor, we have not presented any evidence regarding what happened in the Sally Port. Would the court permit the state to present evidence of what happened when they went upon the defendant's request to get a cigarette?
Ms. Love, I'm of the opinion it's not going to change my mind at this point in time, in terms of, because he's invoked, anything after that would be improper. It really would be, because it'd be one thing if he said, well, maybe should I get a lawyer? Maybe should I do whatever this, or kind of make vacillate. But he's pretty significant in the sense of, I need to talk to my lawyer. I don't want to talk to no one.
And Your Honor, our case law shows that even when that happens, when the defendant reinitiates the conversation and communication, that the court has found that those statements made after the defendant reinitiates conversation, as unequivocal as his initial assertion was, when the defendant reinitiates the conversation, the statements that he makes are not to be suppressed. And in this case, the defendant reinitiated the conversation, not the officers. And Your Honor, we've provided to the court, and we have proof. We have actual testimony, given that we do have the burden of proof. Your Honor, Munn versus the state, 313, Georgia 716, says that the court must consider the totality of the circumstances and determine the admissibility of the evidence of the statement under the preponderance of the evidence standard. And Your Honor, given the fact that we have a witness here to testify, the court doesn't have to take my word for it or Mr. Weinstein's word for it. We have the person who was there. The court gets to gauge Detective Thorpe's credibility, and the court then has substantive information and evidence upon which to base a ruling under the actual totality of the circumstances. Right now, we have a clip. When I asked Mr. Weinstein to play for the court the portion to which he objected, that wasn't the state conceding that we weren't going to put up evidence, Your Honor. I was trying for the sake of brevity to have him point out the part that he objected to, but then that left us without the ability to present anything. And we weren't stopping there. We were just showing to the court where he was arguing, the points that he made to us that he wanted to contest. So we would like to present actual evidence to show under a totality of the circumstances.
I got the evidence. It's been admitted. The two videotapes are sufficient for the court's analysis at this point in time. Sir,
that's your ruling. Thank you. I have nothing to add, Your Honor.
Right.
And Your Honor, what happened with the Sally Port, the conversation being reinitiated by the defendant, that actually happened, and we have the proof here to show it to the court.
Well, based upon what you've argued so far, in this particular circumstance, this court's of the opinion that it's like this. Once you initiate your right, or you revoke your right to be examined and have counsel, and to have counsel present at that point in time, the courts are very let's just say, cautious about reinitiation at that point in time. And at that, you all presented to me what was the salient point of this particular issue is. So if I believe at this point in time that he's invoked unequivocally his right to counsel at this point in time, the questioning is supposed to stop. You're not supposed to go out and get cigarettes and do everything else. It's supposed to stop. I mean, that's this court's opinion. So, and that's my ruling.
And Your Honor, the thing is that, Your Honor, we did not.
You're arguing with me now, Ms. Love. So can we stop at this point in time?
Your Honor,
if you've got if you have other evidence independent of this, I'll consider it at the appropriate time.
And we do, and that is what I was asking. So if the court will permit me to actually introduce the evidence that we have, as the court in State versus Paldo 309 Georgia 130, where it says a suspect who asks for a lawyer at any time during a custodial interrogation may not be subjected to further questioning until the suspect reinitiates the conversation. And in that, they are citing Dozier versus the State 306 Georgia at 35. Your Honor, Edwards versus Arizona. And Your Honor, this is a 2020 Georgia Supreme Court case where it specifically says that a suspect who asks for a lawyer at any time during a custodial interrogation may not be subjected to further questioning, as the court has said, by law enforcement until an attorney has been made available or until the suspect reinitiates the conversation.
Your Honor, at some point, Your Honor,
I'm sorry, I'm talking, and I don't know why I am being interrupted. I will not stop.
Hey.
I was speaking.
Ms. Love. Y'all got.
I'm sorry, I was speaking.
Both y'all can't talk at the same time.
I know, I was speaking, and I expect you to allow to speak when I'm speaking.
Hey, both of you all need to just take it down a notch.
And so, Your Honor, if I may finish, because I was the one speaking before Mr. Weinstein interrupted.
But you continually engage in this pattern of behavior, Ms. Love. You don't want to accept my ruling.
Your Honor,
and I know you're being an advocate, but at some point, stop. Just stop. I made my ruling. Good, bad, or indifferent to you. You're going to win some, you're going to lose some.
I do accept that fact.
Okay, no, you don't. No, you don't.
Your Honor, we have just not been able to present the evidence.
No, you don't. I get it. And if you have an independent basis to introduce statements that may not, or that may be not subject to the fruit of the poisonous tree, or any other thing, or any other issue related to evidence that may have flown out of this particular interview, then I'll hear it at that point in time.
When the court says independent basis, does the court mean outside of that video? Because we do have that.
Yeah, if it's not tied to the statement, of course you can introduce it. Yeah. I mean, as long as you have some independent basis, right? If you didn't get it from his particular statement.
But Your Honor, that's the point that we have the witness here, that we brought the witness here. And had him cancel medical appointments to testify to the court about. We brought the witness here.
I made a ruling. That has nothing to do with it. That's a red herring and you know it.
No, Your Honor, I was saying that we were ready to present evidence and the court is not allowing us to present the evidence. That's all that I'm saying. We have the burden of proof and we haven't even been able to present the evidence that we have. We only, for the sake of ease, allowed the court to introduce the statements that the defendant made as states 1 and 2 to help Mr. Weinstein play the portion that he wanted to talk about. We didn't even get a chance to play or to have the evidence that the state has ready for presentation to the court to be presented. We should be entitled to present the evidence so that the court actually has the circumstances and does not have speculation or conjecture as to what happened when the Georgia Supreme Court has clearly said, just as clearly as an attorney being present is required before you consider the statement once he's invoked, the court has as clearly said, if he reinitiates, then that statement can be considered. It does not use them like maybe. It says, if this or that, then the statement can be considered, unless it should be suppressed for another reason. And that case, Paldo, is as recent as 4 years ago. And I'm not just doing this for the sake of engaging in a pattern of behavior, Your Honor. I am standing here emphatically asking that the court allow the state to present its evidence so that the court can make a ruling based on the evidence and not on the assertion by one party or the other as to what should or could be done. We have evidence that I believe that the state is entitled to present and the court is entitled to hear in the form of testimony. And I understand that Mr. Weinstein wants us to hurry it along and not hear Detective Thorpe because that might be an adverse position or evidence to his client's position. But we are simply asking that the court allow us the opportunity to present the evidence and to not hold it against the state that I am asking this, that the court allow us to present evidence that this statement was made voluntarily and that the fact that he ceased it but then reinitiated it is something that the court should consider. And Your Honor, I don't like drawing the court's ire.
Glamble,
Sir.
you allow another moment when Miss Love calls me that I did not do something. They have the exact image of what we got from the jail in Fayette County. That is it. And if I get another false allegation and you do nothing, I'm shocked. I'm appalled at you. I sit here day after day with this false allegation just machine. I gave the state everything. There's been no disconstruction. There's been no purposeful, I don't care. I don't care. I give over everything. I've done this for 33 years. Never in my life have I seen a trial. I've done 300 appeals in the state of Georgia alone. I've never read a case like this. Judge, I gave them everything I had. I waited. I was at my office till 8, after 8 last night. I waited for their investigator to come by. I handed him an exact copy of thumb drive. They have everything that we got from the Fayette County Jail. There's been no deconstruction. There's been no purposeful exclusion. This is not the first time.
Okay.
And I apologize that I'm getting tempered. But I've never been treated like this. You talk about professionalism every week. Professionalism is lacking with one lawyer here. It has never been. I don't even like coming to court. I used to love this. I would die for what we do. I used to say, I'm dying. I would die. I couldn't choose a better profession. If I had litigated with Miss Love, I would.
Your Honor, could we strike the hominem attack?
No, I'm speaking.
Really, could we strike that?
Okay, everybody, calm down. Everybody, both of you, please be seated.
Judge, I'm not
Both of
done.
you, please be seated.
You have to do something. You have threatened me with contempt. You have threatened me with jail. If you go back in time, we can just start in voir dire. Jury after jury, you did individual voir dire painfully. Miss Love would come in and say that juror was crying. It was not true. You would say, that's not my recollection after I said it. You did nothing. We start the case.
But Mr. Steele.
I asked you, please.
Mr. Steele.
Please, Judge, how would you feel if you were being treated like
Mr.
this?
Steele. Mr.
Well,
Steele.
I'd like to finish.
Mr. Steele.
I gave them everything on that drive, and it's continual abuse of a prosecutor, of another member of the bar. I don't talk with Miss Love. And that's fine. I like that. But Judge, I'm not going to stand here anymore. I don't care. You can take my bar card.
Mr. Steele, listen.
And Mr. Williams, to me, this is an innocent man. You talk about, Miss Love said there's a man in the Fulton County Jail who shouldn't be there, Mr. Copeland. Mr. Williams shouldn't be in custody. But he's been charged, and we come here for a fair trial. It's been everything but that, according to Miss Love has tried to demonize me. At times, Mr. Adams. At times, Mr. Shaw.
I object
Now
to the
it's
ad hominem
Mr.
attacks, and I ask
all
you to
because she wants to
Again,
win the
from the
case. And now she speaks over people. It's not right. I gave them everything. And by the way, and what I want to tell you, by the way, it's not even the law. If they call that gentleman on direct, I don't have to give them anything before trial. I do it because you asked me to. You said, listen, we got a big case. It's going to take a long time. Give them things. I gave this, by the way, to the state October of 2023. October 2023, that was uploaded, given to the state. I hear about it now, and I wait there, and I give them the exact duplicate of what we have, and now there's a false allegation of misconduct. And what I'm telling the court is what I said again. I do not appreciate it, and you have told it in front of the jury that I'm unprofessional. You were wrong. You based that on Miss Love's false
Your
representation.
Honor, again, the ad hominem attacks, Your Honor. I object, and he should stop talking when I
Ms. Love can
object.
try to silence me. I will not be silenced.
But Mr. Steele, here's the thing, okay? I think that, Mr. Steele, please be quiet at this point in time. You made your point. You made your point at this point in time. Both of you, please be seated. I've been doing this a long time. Yes, I have. Yes. And if you really must know, she's going to reschedule her appointment to the week of the King holiday. You happy? No, you're not happy. But anyways, that's the explanation you're going to get. I'm on top of it. Okay. All right. Yes, Mr. Sharp.
Your Honor, in an effort to make things go smoothly next week.
No, you're not trying to do that. You're just trying to get in my business as well.
No, not in your business at all, Judge. No. We have a list of the witnesses.
Okay, who are you calling next week, madam? Monday, Tuesday. Let's just say Monday, Tuesday, Wednesday.
We'll get that. We'll provide that by tomorrow with the court's permission by close of business.
I don't trust that's not going to be done. Okay, so let me just kind of so nobody's at fault. Nobody's kind of says, hey, I didn't get it, whatever else. Can you at least tell me or who you plan on calling on Monday, the 4th?
Go ahead. Your Honor, we haven't had an opportunity to speak with our investigation team, so we can know who exactly is ready. So we
That's
can
the last time I'm gonna accept that answer, okay? Because you got 1,100 people that work in your office, all right? So you can get, or at least be able to tell me in advance who you think you're going to be able to call the next day, okay? So if you could tell your team, the judge is going to ask me this question, so please go ahead and have who you're going to call. I mean, I understand the essences of calling witnesses and everything else, but for the most part, you're probably going to have a stock number of people you're probably going to call.
We did, and that's the reason that we gave them the list of people that we intend to call.
Yeah, but 70 witnesses is kind of a little bit kind of old. You know, that's a lot. I mean, you know.
Can we at least get an opportunity to get back to the office and speak with our team? Oh, okay.
He said it's his time. So yes, we've been doing scheduling based on how things have been going, and that's the only reason.
All right, please don't let me get any emails tomorrow or over the weekend saying that witness list has not come out, because they need to be able to prepare for who you're going to call on Monday, okay? And I think that's only fair. So can we have that list to them by noon tomorrow?
Yes, we will get that to them by noon tomorrow.
And
they will be from the list of people that
and copy me. Yes, that's fine. I mean, but they just need to know so they can prepare like you all preparing, all right?
Judge, I'm sorry, I'm unclear. Is that list we're getting by noon tomorrow only the Monday witnesses?
Yes, only the Monday witnesses. If you have the other witnesses, let's just say
It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment. Then I was told, based upon information belief, that Adrian Love, the lawyer for Mr. Copeland, and this court were together, and Ms. Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Ms. Love, to Adrian Love, stating that Mr. Melnick does not represent the witness, and that Mr. Melnick wrote an email saying F you, and then somehow that email was CC'd to me. That never...
Mr. Steele, can I interrupt you for just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too. And the reason
I'm asking you a question. How did you find out about it?
I'm going to ask you the question.
Okay.
Scuttle, if you look at SCUDDER versus State, which is 298 Georgia, 438, it's Division 2, 782 Southeast 2D 638, 2016. Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somewhat accurate based upon what you just said, we're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's a critical stage.
It's just like when you meet with me, and you and Mr. Adams meet with me, and others have met with me. It's those are ex parte for a lot of different other reasons, but I will certainly note that for purposes of record.
Well, I'm going forward. What I was told was that Mr. Copeland said,
and you haven't answered my question yet.
I'm not going to answer that question.
You're not?
No, I will not answer that question.
Why will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to get anybody else.
I'm asking you, how did you get this information?
I'm not telling the court. What I'm saying is based upon information.
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have this. I have problems right now.
Okay, I know. Look, I don't want to know about your problems, okay, at this point in time. All I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that how somehow you have surreptitiously gotten information in regards to the court's private ex parte conversations with a party. I mean,
a witness who was sworn in Friday. The court's telling, this is what I was told. If this is not true, not true. This court handed Mr. Copeland.
Tell me how you got the information.
Listen, whatever you want to do.
Tell me how you got the information, then we can go ahead and go forward.
I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court.
It concerns me that you have proprietary information.
Why is it
Or
proprietary?
information that you should not be having that was ex parte.
Why?
With a party.
Why?
State of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court, or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele, I still want to know, how did you come upon this information? Who told you?
What I want to know is, why wasn't I there? Why,
sir, I'm going to hold you in contempt if you don't tell me who tell me who this information was coming from.
I don't want to be held in contempt. Well, I'm not answering that question. That's attorney-client privilege information. I am not
attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out. I tell you what, I'm going to give you 5 minutes. If you don't tell me if you don't tell me who it is, I'm going to put you in, I'm going to put you in contempt, because that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information supposedly from my chambers? Did somebody tell you?
I'm not. You should have told me.
You got 5 minutes.
Well, I don't need it. I want to continue.
You got 5 minutes.
This is what I was told. Mr. Copeland made statements that he admitted to killing Donovan Thomas and was. Don't take my notes. No. I don't think Mr. Adams is back. I have a.
He is. He's right behind you.
Sorry. I have a motion that I need to make outside the presence of Mr. Copeland.
All right, you can make it right now. Is he out?
Let me know when you get down to the.
Is Mr. Copeland out?
No, he's upstairs.
Okay, good. All right.
Yeah, come on down. Don't come in the courtroom. Come when you get to the back. All right.
Thank you.
Go ahead.
The way I understand my constitutional obligations, pursuant to the 6th and 14th Amendments of the United States Constitution, the corresponding sections of the Georgia Constitution, I'm required to make a full and complete statement to the court. For the record, and if God forbid this goes up on appeal for the appellate courts or another tribunal, commission, or administrative body, I was told, based upon information and belief, that when we arrived at 8:30, 9 o'clock today, we did not come into your courtroom until almost 11:30. And what I found out just recently, this is not waived, is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment. Then I was told, based upon information belief, that Adrian Love, the lawyer for Mr. Copeland, and this court were together, and Ms. Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Ms. Love, to Adrian Love, stating that Mr. Melnick does not represent the witness, and that Mr. Melnick wrote an email saying F you, and then somehow that email was CC'd to me. That never...
Mr. Steele, can I interrupt you just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too. And the reason
I'm asking you a question. How did you find out about it?
I'm going to answer you the question.
Okay.
Scuttle, if you look at SCUDDER versus State, which is 298 Georgia, 438, it's Division 2, 782 Southeast 2D 638, 2016. Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somewhat accurate based upon what you just said. We're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's a critical stage.
It's just like when you meet with me, and you and Mr. Adams meet with me, and others have met with me. It's those are ex parte for a lot of different other reasons, but I will certainly note that for purposes of the record.
Well, I'm going forward. What I was told was that Mr. Copeland said...
And you haven't answered my question yet.
I'm not going to answer that question.
You're not?
No, I will not answer that question.
Why will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to get anybody else.
I'm asking you, how did you get this information?
I'm not telling the court. What I'm saying is based upon information.
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have this. I have problems right now.
Okay, I know. Look, I don't want to know about your problems, okay, at this point in time. All I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that how somehow you have surreptitiously gotten information in regards to the court's private ex parte conversation with a party. I mean,
a witness who was sworn in Friday. The court's telling, this is what I was told. If this is not true, not true. This court handed Mr. Copeland.
Tell me how you got the information.
Listen, whatever you want to do.
Tell me how you got the information, then we can go ahead and go forward.
I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court.
It concerns me that you have proprietary information.
Why is it proprietary?
Or information that you should not be having that was ex parte.
Why?
With a party.
Why?
State of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court, or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele, I still want to know, how did you come upon this information? Who told you?
What I want to know is, why wasn't I there? Why,
sir, I'm going to hold you in contempt if you don't tell me who tell me who this information was coming from.
I don't want to be held in contempt. Well, I'm not answering that question. That's attorney-client privilege information. I am not
attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out. I tell you what, I'm going to give you 5 minutes. If you don't tell me who it is, I'm going to put you in. I'm going to put you in contempt because that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information supposedly from my chambers? Did somebody tell you?
I'm not. You should have told me.
You got 5 minutes.
Well, I don't need it. I want to continue.
You got 5 minutes?
This is what I was told. Mr. Copeland made statements that he admitted to killing Donovan Thomas and was. Don't take my notes. No.
Okay, Mr. Steele, would you take the podium, please, sir? All right. All right. Mr. Steele, before I recessed, I asked you, how did you get this information? And it is not covered by work product. There's only one way you could have gotten it. So I'm going to ask you again.
And I respect that. And it gives me no joy, but as you know, Georgia Rule of Professional Conduct, please check me. Rule 1.6, comment 5 reads, and this is what I have. 1.6.
I know what the rule says, but here's the thing.
Well, let me just.
You need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt.
I understand. I don't want to be held in contempt.
And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious.
Yeah. And that's why I raised it. It is that serious that we should have been there and it shouldn't have happened.
Sir, that's a whole separate issue. And that's why ex parte conversations are recorded.
Why would it be ex parte? You're acting like it's ex parte under seal.
It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation.
I've never asked this honorable court or any court to meet with me and a witness.
Sir, you're straying off the issue.
I'm not.
The issue is how did you get this information?
I understand the issue. I promise you, I understand it. But what I'm trying to ask you is, if you look at comment 5, this is how I understand the law.
You cannot you can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, but that's why I'm saying, how did you get information?
But just listen to what I'm trying to tell you. You're threatening me with contempt.
The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
Let me tell you, I'm just reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe, you're asking me, I'm not saying you're ordering me, but to give you information, and you're saying it's not sum and substance, but I'm telling you I can't do that under the bar rule.
All right, well, I'm going to hold you in contempt. And you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it.
You can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea.
I have an idea how you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to listen. I told you the first time. And I'm not going to breach that confidence.
I don't want to hold you in contempt, but this is that serious.
Judge,
you cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
Judge, listen, and listen, I'll do whatever you want to 5 o'clock or thereafter. But what I'm trying to tell you is, Your Honor, this is so serious to me. We need a hearing, and I'm moving for a mistrial. It is my understanding, based upon information belief,
from whom?
Part of it.
From whom?
Well, I'd like to get the substance first, and then we can talk.
Okay, well, then you'll be in custody until then, because you need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you. So,
but you're assuming something because I told you already.
Well, then, other than if you were sitting, unless you were sitting in there with a recorder, or Miss Love, or Miss Hilton, or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left.
Well, Your Honor.
And if that person gave you that information or shared that information with you, she probably violated privilege.
Well, let me tell you two things. One, I don't know how that is a privileged communication. It shouldn't have been.
Well, it's because she has a client she's supposed to represent.
Who are you talking
But anyways, I'm not going to have a.
When I got this information,
I'm not going to have any further conversation with you about this. I want to know, the question still remains. I want to know who gave you the information?
I'd like to know what information happened outside our presence. That's really it.
He can go into custody at this point in time.
I think that the court needs to again declare a mistrial based upon.
Okay, and I'm going to deny your motion. I'm going to deny your motion.
I understand that you spoke with a witness outside our presence.
And whenever, yes, I had an ex parte conversation, which is appropriate.
And you influenced the witness based on information belief, and I'd like to have that all on the record.
All right.
I mean, I don't know why that's so hard to do. If nothing happened bad, that's fine. But you're acting like, tell me who it is and don't talk about the substance. Why can't we have an issue that was outside of presence? It should not have been.
Because you got some information that you shouldn't have gotten.
Why?
Well, that's for another day.
But why?
Okay,
why
that's for another day.
In the first place, I didn't know about this stuff.
That's for another day. So
I raised it as soon as we found out about it.
Well,
I gave you the case I'm relying on. I assume you read it. If you didn't read it, you should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the court has said it's right there in Division 2. That is a material or critical part of the case, and it's an automatic reversal.
Mr. Steele.
But you're acting like it's
Mr. Steele, that is not that is not the case when somebody discloses information in a ex parte conversation that one of the parties lawfully asked me to hold.
You're not supposed to have communication with a witness who's been sworn. You know that I'm not telling you. I'm just saying if you read I'm assuming you read it. That's what it says. And you did it.
Does the state wish to be heard?
You said it supposedly.
Yes, Your Honor.
And what I'm trying to get to is why did that happen outside of presence? And I need to have I'm respectfully requesting the transcript that you mentioned to be given to us so we could really understand it. And then anything that was not on the transcript, if anything, that we understand what happened outside our presence.
Okay.
And now you have put it where somehow I have to reveal, and I told you the first time, I'd be breaching 1.6. And I know you're assuming something.
I don't think you're breaching 1.6. You can't hide behind 1.6.
I'm not hiding behind anything.
You can't hide behind, yeah, but the thing is, I think you got this information, somebody disclosed it to you, and that's the only way you could have gotten it.
What I got.
Because unless you're sitting there, you're eavesdropping. So you can't use something ordinarily that you had no business getting to begin with, and then stand on, well, hey, we didn't give you the information, or that a party didn't give you the information. So,
Your Honor, but that's the issue, isn't it?
Well,
why aren't we
that leads to be told. But
right now, we don't know why we were excluded from that.
Mr. Steele,
and I want that information because Mr. Williams' constitutional right on the Georgia Constitution.
Just stop at this point in time, because
Article 1, Section 1,
you've already said that. You've already said
Georgia Constitution, and we have the right to be present.
All right, Mr.
And we're not waiving anything.
Yes, Madam, Ms. Love.
And Your Honor, excuse me. And I know I said this previously.
Yes, sir.
But we are not accepting any proffer from Ms. Love.
Okay, excuse me.
And the challenge I'm having in this particular circumstance is that is such a violation of the sacrosanctness of the court's chambers and an ex parte conversation. You're just glossing over that. You're glossing over that in its entirety. No.
Mr. Williams' rights.
It's not, sir.
Sir. Is not.
That's not what happened. That's not what happened. That's not what happened. I'm just telling you, that's not what happened.
Judge, respectfully, we are not obligated to simply accept that there's been no violation. We believe that there has been, and the only.
Okay, well then you've made your. No, we're not doing that at this point in time. So you'll have a choice to make. All right. Take Mr. Steele into custody, please.
Without being heard on this issue.
Your Honor, would the court afford me one moment to confer with counsel regarding the appropriate remedy in this type of...
Okay, all right.
May I say one thing, Your Honor?
Yes, sir, you certainly may.
Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you deny, but I'd like you to deny our motions for mistrial. You denied the other people.
I've denied your motion, but I'll certainly take that under advisement, sir.
At this point, the stream will be ending. Thank you all for coming. See you all tomorrow.